Someone make it make sense.
Probably a couple.
Hello, squirrel friends of the world. How are you guys doing today, tonight, this morning, depending on where you guys are? Hi, Flash fan. Glad to see you. So I'm really excited about this episode. I think I did a little test run earlier. It looks like StreamYard is working better. Hopefully they have some of those glitches fixed. So I'm really looking forward to this one today. And yeah, so the first thing that we're going to do is we're going to talk about, because here we are, the state's going to rest today, right? So we're at the end of their case in chief. And, you know, over the past like one or two episodes, right? We heard a lot about, we heard from the medical examiners, we heard from the forensic anthropologists, we heard from the forensic etymologist about the bugs, and all the stuff about the bugs got me really thinking, because, you know, there was a lot of talk about, you know, how long was the body in the trunk? If there was a body in the trunk, you know, that's a high point of contention there. There's really not any solid evidence that there was any body in the trunk, but you know, that's the state's theory. But the big problem there is the bugs, right? So you have the trunk, and then you had the crime scene on Suburban Drive. And the problem that the state ran into is that they didn't have enough bugs in the trunk to really show that there was anything in that trunk. So then Mr. Ashton elicited on like redirect from the expert that, well, maybe the body was, and it was leading, by the way, that maybe the body was only in there for 3 to 4 days, and that could explain it. Well, problem you have there is that, like, if that's the case, then you should have had the other bugs that you would have had at the crime scene, because it would have been, you know, 5.5 months minus 3 or 4 days. And so that's when I started thinking, well, what about the backyard? Because what about all this evidence we heard earlier in the trial? Now, they didn't bring this up at any point with these last experts, but earlier on in the trial, there was, you know, we had all that the canine handlers and whatnot, right? So there was a lot of testimony about the backyard, and that's what, and then that never came back up. And it's like, so that's why this question is on the screen, like, right? Like, why did they even bring that in? Like, what are they hoping to prove with the backyard evidence? Because, I mean, basically what it does is it just kind of discredits the canines by saying, you know, they alerted on it, and then, you know, there was nothing there. And we're going to go through all of that. And so why did they bring that in? What are they hoping to prove? They could have tried to tie that in with these other experts as to maybe where, like, for example, if their theory was that maybe it was in the backyard for some of that time, and then the car, and then the crime, like, then that might explain some of the stuff. But the problem was there was no evidence that there was anything in that backyard. And then you have to look at how does that fit in terms of Casey being in custody. So we're going to take a look at all of this and try and figure out why the heck the state brought that in. What do they think it's going to prove? How does that fit in with their theory? Because that was a lot of time spent on all that. So, and there's also some other interesting elements that are going to come up in this video as well that pertain to the backyard. I went back and pulled up some really interesting testimony from, like, Cindy Anthony's first time on the stand. So we're going to take a look at this. I think it's pretty interesting. I'm really curious what y'all's thoughts are. Like, what do you guys think? Why did this come in? What was the state hoping with this? The pavers.
There were also these concrete pavers nearby, correct?
I'm unaware of any concrete pavers. They didn't have anything to do with my area of responsibility.
There's the pavers.
There were some that were very close to the remains, were they not?
I recall one that was close to the remains.
And they are like stone pavers?
I don't know what type of stone, but yes, it could be consistent with pavers.
Changes made to the backyard.
What changes have been made since 2008? Well, we have no grass in the front yard, but we actually extended our patio. From 2008, we placed In fact, last fall, I re-patioed, re-added more. We took the grass completely out of the backyard. Since 2008, we've been unable to grow grass in the back, so we
Interesting.
put pavers here,
Interesting.
mulched this area,
This is interesting.
and my husband extended the patio from here down with a walkway to the shed, a cement walkway to the shed.
Aside from those changes, cosmetic changes, would you call them?
Out of frustration of George and I,
Okay.
it was cosmetic changes.
That's a weird answer too.
No changes to the actual structure of the home or the placement of items in the backyard, like the pools and the shed.
Absolutely not.
As it's published, there are the annotations that you made while you were talking about the photograph. Right there where I put the red dot, what is it that you describe as being different from 2008? Just briefly.
In 2008, we had grass, and now we have pavers. We have a paver patio.
Paver patio.
And then this X that you made, where I made the second red dot,
We had grass, and we put bark chips and stepping stones.
all right.
So it's okay. So I'm pause real quick. So it's like they got rid of all of the grass, which is weird. And you're gonna hear why that's weird in a second. So I zoomed in. So look at where you have the two red dots, right? And we're gonna get some more pictures here. Don't worry. But that's where you have the pavers and where it's labeled, right? And then the other place with the red dot is where she said they put down like mulch and then like stepping stones or something, right?
Just to limit the amount of maintenance that you have to do with that grass.
Yes, and also for an area for our two dogs to relieve themselves.
That makes no sense. Does that make any sense to you guys? You put concrete, you put pavers, you put patio stones, all that stuff down for the dogs to go pee. Like what? You got rid of the grass and put man-made materials down for that makes just literally no sense. Like, I don't know why would you even say that? Like, it literally makes no sense. It just adds to the weirdness of it, right? Like trying to over explain, but like that doesn't make sense. You could just say you don't have to even elaborate that much, right? You're allowed to do things to your backyard, but like it's just going overboard, but it just doesn't make any sense, right?
Okay.
Yeah.
And then you have a line heading to
And by the way, I know Flashman said that he's got to go mod. I would say if you can come back after, because then the last thing in this episode is the motion for a directed verdict, and you're not going to want to miss that. That's exceptional.
a structure on the side of the house. Was that is that concrete?
Yes, it is now. It used to be lava rock and bark chips. We did that because George used to keep his, at that time, George was keeping his lawn equipment in that shed. And he had to pull it through the mulch, through the chips. And
Again, no question, Penny. She wasn't asked why. They weren't asked why. But like what it sounds like, again, at the time, it was like, this is boring. This is why we're hearing all this. But now it's like they got rid of all of their grass. They basically turned their backyard into like a rec, like a prison, like the rec area that they have out there, like where it's just all concrete, pavers, patio stones. It's odd, right?
became difficult. So that was something we had intended to do in 2008 and never
Okay, cool.
had a
Yeah, you'll
chance.
definitely,
So
we'll definitely
he
be
went
back
ahead
to
and
that.
concreted it last year.
Complaining about the concrete.
There are three sheds on your property.
Yes, ma'am.
Can you tell the jury from this aerial view where those are?
Sheds, guys. 3 sheds.
Our main
Three
shed.
sheds. 3 sheds.
Well, actually, we use them all now as main sheds because they all serve a different function. But
I mean, again, what? This is so. Dude.
this one's our largest shed, and then this one and this one are the same size. This item right here with the green roof is Caylee's playhouse.
Okay. And this item, if you could just describe for the record.
That is our above ground swimming pool. Yes,
Let me back that up a second because I guess it is glitching after all. But yeah, so that's the only time we don't get much talk about the swimming pool from the state, even though it's really important. This is the only pictures we get are these aerial views, guys, which is insanity to me. Okay, let's just go
same
through.
size. This item right here with the green roof is
There's the
Caylee's
playhouse.
playhouse.
And this item, if you could
That's
just
our-
describe for the record.
That is our above ground swimming pool. Yes, if you come through the gate, that is a pathway to our backyard.
What are these two items that I've marked with a red line on the right side
Or
of the
just
photograph?
precious sheds.
Those are our other two sheds.
All right.
If
Let me see if I can
Mother of God. Y'all,
fix our
This is so-
discussions and look at the aerial. You were trying to describe something related to the pool using the aerial.
this I found interesting. And this is the only time we hear about this testimony, at least so far in this trial. This is the only time we hear about this. And this is interesting. Here, listen to what she's going to say about the pool here.
Aerial photograph. Can you tell us what you were
Yes, ma'am.
indicating?
When I was talking about it being like mid-sternum, it would be from this area or this area around the pool. But right on the pool's edge, if you were on the outside of the pool, you would be standing on a concrete patio.
Another concrete patio. And I don't think she says when they put that in, but you know what? They surely did a whole lot of concreting and paving and stoning after 2008 or starting in 2008 and then it's noteworthy here. The other thing I wanted to point out, I'm glad I remembered this, is that all of this happened, all of these changes to the backyard, all of them were made after Caylee went missing. Because what they're saying, that was why she's like, I can't remember if I included it, but basically this aerial view was taken from, Google or whatever, after 2008. And you'll notice it too, because we're going to see pictures of the backyard here very shortly from the actual time from 2008, right? When they were doing all the, from the searches and stuff. And you'll see that the stuff that is being pointed out now wasn't there. So all of this was done after Caylee went missing.
And that is approximately a foot down from the level of the pool, from the bottom of the pool. We made a retention wall there. So this area right here is a cement patio.
Do you see?
She called it a retention wall, but now she's calling it a cement patio. And that's a little bit different, right? Because a retention wall, I don't even know what that would mean, but it would serve some sort of purpose, ostensibly, right? I don't know. It's like as if water's gonna, I don't know. But she's calling it a patio. And so that to me is different, right? Because it's like you're just covering your entire yard with concrete. And, it's almost like maybe they thought it would be too weird to cover just literally all in concrete. She's like, okay, this is going to be concrete here, and then we'll do concrete over there, and then we'll do stones over here and patio pavers over here. They're all concrete, right? It's just different names for the same, in other words, just to try to make it seem like less weird, because who takes their backyard and covers it in concrete, really? These people.
The photograph?
Yes, ma'am.
What is it?
Okay, so this is what I was pointing out. So here's a picture of the backyard from 2008 before those changes were made. So you can already see how there's a patio there. But what she was just explaining is that they extended that. They made it bigger. And why does that matter? We're going to see here in a second where those dogs alerted in the backyard. It's basically all of that grass is gone now. It's all covered in pavers or patio stones.
Depicting.
If you would, as soon as you would step out of our screen patio's here, there's a door that's off of here. If you'd step out, this is Pavers. That is our screened-in patio.
All right. What is this now that we're not looking at it from an aerial point of view?
That's Caylee's playhouse.
Off in this direction?
Playhouse.
That would be, if you followed that arrow, that's the other property line. That fence would lead us back to the other shed on the side of our house where Caylee's room and Lee's room would be. Oh, it's patio stones. It's the square patio stones we made like a 4. We didn't want her to be on grass when she was sitting in there playing.
I thought that was weird too. You don't want her to sit in the grass. She's a child. Whoever would say that they don't want a little child to play in the grass? It's odd.
So we didn't pour concrete because we didn't know if we'd ever move it. So we just put patio stones down.
Cover everything with concrete or patio stones. Again, it's just odd. Okay, now we're getting to the canines.
To another location that same day or subsequent date?
Yes.
Okay. Same day?
I believe it was the next day. I'm not sure. The Hope Spring address.
Now,
So when we were going through this again in chronological order and this canine stuff came out, right? Remember, on Jason Forgey's direct examination, Miss Drane-Burdick did not ask him about the second day. So I have my notes here. On July 17th, 2 things happened that day. Well, more than 2 things, but noteworthy with the canines, right? The car, Garris, alerted the car. There were issues with that, but we're not going to go into all that. But it is kind of relevant, which is why I mentioned it, that Garris alerted on the car. And then after that, they took Garris to the backyard. Again, this is July 17th. And Garris alerted in the backyard. And there was a discrepancy because during his testimony, Jason Forgey circled the place in the backyard saying this is where Garris alerted. And it was the same place where the other handler said her dog alerted, which is the place right near the playhouse where they now have all the of all things, that's where they have the pavers, which is, again, this is the point. That's what they found at the crimes, where the remains, the patios, the patio pavers, paver stones. That's what they found. It's what we saw at the very beginning of this video. But however, he had told her at the time, the other handler, that his dog had alerted 6 to 8 feet away from there, which is actually towards the pool. But regardless, it came out with him on direct that, there was an alert, blah, blah. She did not ask about the next day, July 18th. That came out on cross. So again, I think that is indicative of something. But again, as I was going along watching this, I'm like, okay, well, why is the state bringing this in? Clearly, they're trying to suggest, right? Common sense would tell you the state is trying to suggest that maybe Caylee was at some point buried in the backyard and then moved. That was what I thought their theory was. Did anyone else think that was where the state was going with this? That they were trying to be like, oh, Caylee was in the backyard and then maybe after that moved to the car, right? Is that what anyone else was thinking? Because there's a reason I'm asking that question, and we'll get to that in just a second. Yeah, truer words have never been spoken.
going back to the search of the home, you were called after your alert or your dog full train alert in the backyard. CSI was called out there.
Sergeant Brewer was called first, and then the forensic CSI were called, yes.
And they then began to dig and search for remains in the backyard.
Like I've said before multiple times, it's not, I don't think they dug. I don't know for sure. I know what it appeared to be is what they scraped the surface, but I wasn't present.
And see, again, this type of testimony, again, would lead me to believe that what he's trying to hint at is that maybe there was something there, but they didn't dig deep enough, that type of thing. But don't
They
worry.
weren't looking.
Absolutely.
And they didn't find anything.
No, they did not.
And then they called you out the next day to come out.
Yes, sir.
Okay.
And the next day you came out.
Yes, sir.
And tell the ladies and gentlemen of the jury what happened.
The next day, after they had done what they were doing, scraping the surface and moving the area, I did not get any alerts.
Do you recall being asked the question?
So again, it's crazy to me that that the state did not ask that question on direct. Again, the fact that they didn't ask that question would make you think, again, why are they doing this? Well, if they didn't ask that question, I don't know why they thought it wouldn't come out on cross, but surely they were trying to suggest that the body was there. And that really matters because there's a lot of problems with this entire thing about, because all of this matters in terms of the circumstances here. And so, and that's going to come out whenever we hear Roy Kronk testify. Now, the state did not call him and he's the one who found the remains. But I've touched on this before, but that's really the only thing that fits in. And the problem with that is that destroys the state's entire case, destroys it. And so they're trying to explain away things that don't make sense in terms of where the body was. So, okay, but now there's what they're talking about is this is the craziest part of all. So you have July 17th, right? There's an alert. Next day, no alert. And then you have Garris taken to the crime scene where there are remains. The remains are there. They're at the crime scene. And here's what happens.
I'm sorry, page 81, lines 23 through 25.
Ever a
page
dog
82,
should alert,
line
right?
1.
In other words, if ever a dog should alert, like hello,
Do you
right?
recall being asked a question? He didn't give any alerts at all. And your response being, no, sir. Well, yes, he showed some interest. He showed interest, change of behavior, blah, blah, blah. He did give me his final. Did he give me his final alert? No, sir. Do you recall making that statement, sir?
Yes, I do.
You didn't find any human remains.
They had been recovered. I didn't find any. No, sir.
Neither did your dog.
No, sir.
And your dog did not give a final train alert anywhere on Suburban Drive.
Correct.
Ms. Drane-Burdick asked you about your belief as to why the dog didn't alert in the backyard.
Mind reader.
The second day.
The second day.
Yes, sir.
Now, this is important because, so my thought was, because again, I'm like, this is such, what is the state doing with this? Is the state, so then I thought, well, maybe what the state is the state trying to suggest, because again, they've got all these problems they're trying to solve. Is the state trying to suggest that the body was there, they went digging, and the dogs alerted, right? They went digging or whatever, and then that someone in the family, right, was like, oh no, because knowing they were going to come back the next day. And at that point, that's when the body was moved to the car, right? Is that what they're trying to suggest? Or the body was moved elsewhere. The body was moved, you know, who knows? Maybe they're trying to suggest it was car, then backyard, then crime scene. Either way, if they're are they trying to suggest that maybe it was there on the 17th and then overnight somebody moved it, you know, because the dogs were back there sniffing? And here's the reason I'm asking that. And this is why I think the state stopped bringing this up, right? Because we don't hear anything else about the backyard after this canine testimony. And this is on what, day 12. Here's why. I went through everything, and I have a comprehensive calendar of when Casey was in custody and when she was out of custody. And guess what? She was in custody from July 16th to August 22nd. So if there was anything in that backyard on July 17th that got moved overnight between the 17th and the 18th, it could not have been Casey. You guys see the significance of that? If there was, and now again, it's this is their best case scenario, right? If they're bringing this evidence in, it's supposed to be showing that there was something in the backyard. But are they just like, did they not look at the calendar? Like, because the problem is if that's what they're going with, you're proving again for the millionth thing, it had to have been George or Cindy. But I mean, come on, you know? Okay, let's keep going. Uh-oh, don't be frozen, please. I don't know if it's frozen. I hope not. Hopefully you guys can hear me. Okay, let's see.
Other than...
Oh, Flashfan says he found one pretrial hearing shortly before jury selection. Awesome. Where did you find that? Was that on the Court TV archives? Because I mean, that's where I didn't see anything on there, and I went looking. And that's of course where I got everything for the trial. So, but that's awesome. Please put that in the Discord if you can, and we'll definitely watch that.
Well, I don't believe a dead body in the backyard is a disputed issue in this case.
And I forgot he asked that question, but there is the question, right? And again, why is he asking that? Because the state, again, at this juncture, clearly they're hinting at that. Why else would this testimony come in? But the way, let me back that this is so again, This is all pointing to that the state is trying to suggest that. But if they are, that only indicates that George could have moved it.
I don't believe a dead body in the backyard is a disputed issue in this case, but let me ask you this. Are you guessing?
Just a second.
I'm trying to explain the question.
No.
Object to the commentary by counsel as to what is and what isn't in dispute.
Sustained. Rephrase your question.
Yes, sir. Other than that, I guess the easiest way to ask you this is, you really don't know, do you, sir?
What?
You don't know whether Caylee's dead body was in the backyard, or whether this is a false alert, or whether as you explained to the jury, when digging up, it lost the scent. You don't know any of those three.
Right. I couldn't tell you why. I can tell you from experience. I haven't had a problem with it. I can tell you I had a final trained alert in that exact spot the day before. After they moved whatever was on the surface, I did not get an alert at all.
Here's the other handler.
2008?
2008. It was approximately 8 o'clock in the evening. He immediately did a quick search of the yard. He went around where there was a swimming pool, and then he went back towards the screened-in porch. He checked a couple corners of the area. His nose was down. He spent approximately 3 to 4 minutes searching in the backyard. I saw that there was an area of interest that he kept going back to and sniffing pretty hard. He finally came back to that same area after making another lap of the yard and gave a final trained indication in one location in the backyard.
Did you run bones through the same process on that date?
Yes, ma'am.
Okay. And what result did you receive then?
No alerts.
Okay. Do you have some
Both dogs alerted on the 17th and did not alert on the 18th.
opinion as to why that occurred on day 2?
Whatever he was alerting to could have been moved or destroyed or dissipated because of all the work that had been done.
So again, when she says moved, now it's sort of like, well, it could have been from the CSI people. But again, hearing that word moved, it's almost like, it's like, did no one look at the timeline? The jury knows that she's in custody. They know she was taken into custody after that interrogation at Universal Studios, and that was on the 16th.
Or they may just not have dug enough to find what may have been below the surface.
Now, this is an area you circled where you had indicated your dog alerted to,
Yes.
correct? You also testified that Sergeant Forgy had informed you that his dog alerted 6 to 8 feet away from this.
Right. This is what I was talking about.
Correct. I think the first arrow would have been more.
Yeah, the thing
So here's the thing. So the 6 to 8 feet away,
went
right?
a little haywire on me at
It
the
went
end.
haywire on him. That's where the pool is. Okay, so here's the thing. So where that blue circle is, that's where the full trained alert was, okay? And 6 to 8 feet away. If you go 6 to 8 feet behind the circle, where where that picnic table is, there's a fence. So it couldn't have been over there. If you go 6 to 8 feet towards the side, you're going towards the playhouse. Couldn't have been over there. Now, here's what's interesting. So remember, this is the backyard at the time. Remember, all of this has shit over it now. So there's more concrete, there's patio pavers, there's patio stones. But if you go 6 to 8 feet to the right, as you can see where there's arrows, that's concrete. Okay. And then if you go 6 to 8 feet, the only other option there is now you're going to the other direction. That's towards the swimming pool. So, but that's why it's so interesting that this area right here, it's all covered. It's all covered with, pavers, concrete, patio stones, and all type of things like that. And, and according to Cindy, it's so the dogs can go use the bathroom out there, okay.
What about the back patio where, do you recall a patio before you enter into the house?
Screened in porch.
Yes, screened-in porch. Were you allowed to deploy your dog in there?
They didn't ask me to.
Did you though?
No.
And so I thought it was interesting that he asked that question because, again, they extended that whole area with more pavers. And the thing that the state does time and time again is they bring evidence in that only points to George. And I think that's what's going on here. I think they were hoping that it would point to Casey. But again, she was in custody. So if you tie the fact that there was an alert on the 17th and no alert on the 18th, and then you say, okay, and look at all the changes made in the backyard, but of the change, the pavers, and then the pavers being found with the remains on Suburban Drive, you know, so for the state, okay, the best case scenario for the state is that the alert, if they're trying to prove that the alerts were legitimate on the 17th, and that's their best case scenario, all it does is prove that, if anything, all it does is prove that either the dogs don't know what they're doing because they alerted one day and didn't alert the next day, or it proves that there was something back there and George moved it. Now, here's the thing. Why would it be bad for the state if, for the dogs to have just gotten it wrong, right? Like, so in other words, again, if it's like, okay, the state's trying to say it wasn't George, right? That then bringing this in, all they're showing is that the dogs just, you know, they're doing their best, right? But they're getting it wrong because they alerted on the 17th and they didn't alert on the 18th, but there wasn't actually anything there. They just made a mistake or whatever the case is, right? And then, of course, also not alerting at the crime scene itself. The problem for the state with that is that then that totally discredits the dog alerting at the car. That's when I was thinking about this. I was like, you know what? That's the whole thing, because they have nothing. They have no evidence, right, for Casey. And so the only thing they've got two things: the duct tape and the car. And I think they know very well the jury's going to have a hard time with the duct tape because that connects to George. And we're going to get into that in this episode. We're going to hear a lot more about the duct tape. And the car, again, well, it was Casey's car, but technically it was the family car. And we know George had it during the period of time. And we also know Lee Anthony said that George cleaned it weekly and all this. So again, it's not like George didn't have access to the car. But regardless, even if you say it was Casey's car, she was the only one that was, conscious machines. I'm happy to see you. I know I've seen you before here. Because Casey's innocent and was only guilty of neglect. Actually, she wasn't charged with anything like neglect. You might be thinking of like aggravated child abuse, but she was acquitted on all charges except for making false statements to law enforcement. So her charges were, first degree murder. What was it? So first degree murder, first degree murder. What was the second one? Now I'm forgetting. I can actually pull up. Hold on. Let me pull up the indictment. Was it reckless homicide? Hold on. Let me see here. Let me just pull this up real quick. I want to make sure I get the wording right. I've been listening to Supreme Court argument today, and I'm just, I'm getting some of my things confused because there's so many different types of charges in places, and they're all different. So, okay, hold on. Let me just see here. I just want to make sure I get the wording right. So. Right. Okay. So it was aggravated child abuse. I was right about that. But then the other one was the aggravated manslaughter of a child. That's what I thought. I just want to make sure I got it right. So first degree murder, aggravated child abuse, aggravated manslaughter of a child, and then making false statements to law enforcement. And she was acquitted of everything except for the false statements and time served. Exactly. Yep. And the car, right? So they need the car. They need the car. Now, what do they have for the car? They've got Dr. Arpad Voss with doing the air samples, and that was a complete disaster. They've got the one leg of a fly. It's sad, really, when you think about it. One fly leg, one blowfly leg for the bugs. Are you kidding me? Any bag of trash anywhere would probably have more bugs in it than that. Like, that's ridiculous. So there's nothing and then, as far as like the chloroform, that ended up being a mess as well. And the other funny thing about the chloroform is it's like they wanted it to be a theory that maybe she was drugged or poisoned with chloroform, but then also they're trying to make it serve two purposes because their case is nothing. Because the other thing they were trying to say is, well, the chloroform could have actually been from a decomposing body. So which is it, right? But nonetheless, those levels, as it came out on cross with the FBI expert, were actually really minimal, and it was only found in like one spot. And anyway, that was all the stuff with the trunk was just shot to shit, whether it was the bugs, the chloroform, the airs, all of it. So all they've got left is the dog alerting at the car. And I think that's why all of this came in, is because they had to get in that one dog alerted at the car. And again, there were issues around that as well. But that's all it's because either it's that or they're going with, like, I think it's trying to bolster that because that, but again, how does that explain all of the other times? Like, again, the dog's not alerting at the crime scene where the remains were, when the remains were already being dug up of all times. Yes. So, Conscious Machine says George let Caylee. Yeah, 100%. And I agree with you that Mr. Baez is an amazing lawyer. He is my favorite defense attorney of all time, and that is not an easy spot to gain. And actually, I started covering, for anyone who's missed it, I actually started covering all the Shannon Gardner stuff because of that, because I've forgotten that he was her attorney. So I went back and I started covering that from the very beginning, every single thing in chronological order, all of the court filings and all of the hearings because of that, because Jose Baez is amazing. And he is incredible. So basically all of this stuff about the backyard, again, at best, I think they're trying to help bolster only one thing, which is that the dogs, there's any type of legitimacy that about the dog alerting on the car. However, the problem with that is if they're saying, okay, the dog's alerting was legitimate, well, then you've got a problem because the alert in the backyard on one day and not the next day, again, that only points to George moving the body because Casey was in custody. If there was anything back there, again, if you're going off of what the state is trying to present, that only points to George. So it's pretty much insane. Yeah. And I think, did I have another thing about that with the backyard? I'm trying to remember. Essentially you would think they're trying to prove that there was a body back there and that Casey moved it. The problem that they have is the timeline because Casey was in custody. So it's like, did they just not think about this stuff when they brought this in? Like, did they just not bother to think about this because they were just tunnel visioning to the car? Oh my God, it's just a mess. So now let me show you guys this real quick. This is the surprise I've been talking about before. No one's noticed this. I don't know how no one's noticed this. No one's noticed this. You guys, are you guys gonna see what I'm seeing here? So this is the Orange County clerk of court. So for Casey, and some of this isn't really related to her or whatever, there's other things, whatever. But here's the thing. If you look at the judges here, can you guys see this? If I highlight this, can you guys see this? Do you see what I'm seeing? You guys see what I'm seeing? Do you guys see that? Judge KRAYNICK, y'all. Judge KRAYNICK in 2008. This was related to like the checks, the fraudulent checks or whatever the fuck it was. Flash fan, I hope you just saw this before you go mod, that Judge KRAYNICK was presiding over the stuff about the stolen checks or whatever it was, like for $300, something stupid. Judge KRAYNICK, dude. Isn't that insanity though? Like Judge KRAYNICK presided over some of these charges for Casey Anthony. Insanity. It just blows my mind. Yeah, I know, right? So we haven't gotten to the girlfriend testimony because we're going in order. I assume that comes up in the state or in the defense case in chief. We're at the state resting. The state's going to rest today. I will say that for me so far, the jailhouse visits, seriously, I have parts where I've zoomed in on his face when Cindy brings up the pool, and there's many statements, and I point them out. If you go back and watch it, I comment on it and I say these are these are like embedded confessions from George about this stuff during those jailhouse visits. It is, it was already pointing to him, to me, in my view, but by the time it got to those jail visits and you watch that and you hear what he says that was where it sealed the deal for me. That was a game changer for me. And I know for other people that were watching as well. I'm covering the trial gavel to gavel. No one's done it so far on YouTube. No one's done it. So the entire trial, gavel to gavel. The only thing that we're skipping is like, long silences. I just cut those out, if there's just like nothing happened. We're watching the entire trial. Yeah. And going through it, we also went through the entire Orange County Sheriff's Office investigative report. We went through that whole thing as well. So yeah, but no one's covered this on YouTube. So, and we have not gotten to the girlfriend yet, but I'm really excited. Yeah, I mean, she's definitely like out to lunch, as they say. It's terrifying. Him in those videos, dude, it's like Casey's crying her eyes out. And he's sitting there smiling and bragging and saying one of the weirdest fucking parts was when George was like saying, I just hope, he's saying this to Casey. Casey's just bawling her eyes out. He's saying, I just hope that whoever has her, that they're just treating her with like, that they're loving her and that they're letting her watch her videos and that they're just like, taking care of her. And it's like, what? It honestly, it's weirder than that. I'm paraphrasing because it's so weird. I can't even, I couldn't even imagine it to get it right to what he said. So yeah. But now let's jump in and actually it'll give a little recap from the last episode. So let me pull this up. And we're going to get into the duct tape and all kinds of stuff. And Cindy's going to testify again as well. So, all righty, here we go.
It's a house.
Yeah, Lee is pretty.
We had no knowledge of this PowerPoint. Obviously, since we didn't have knowledge of it, we couldn't have discussed it with the witness. So, whatever.
One at a time, Mr. Ashton.
Yes, sir. Whichever way the court thinks is the most efficient and just way of proceeding, we're in agreement. But I'd certainly like to know what the witness will be describing and talking about as he goes through this PowerPoint.
Is it true that the defense has not been given this PowerPoint?
Here we go.
It is true we have not received it.
Just so, if I might respond to that.
Yes.
The actual PowerPoint, no. Everything in the PowerPoint, every photograph, yes. And that's my understanding. And Mr. Shaw can, let me ask Mr. Shaw that. All the photographs in the PowerPoint have been provided to the defense. Is that correct?
That's correct. They were provided to you.
And there's nothing in the PowerPoint but photographs.
Mr. Ashton.
There's no text. There's no discussion.
So when I was editing this, I was like, okay, yeah, no, that makes sense. That sounds good. No, he's being shady. He's actually not just being shady to the defense. He's actually being shady to the poor FBI dude who doesn't understand that there was a problem. Now the FBI guy doesn't know there's a problem. You guys will hear. This is crazy.
Anything like that.
Wow. More points, but if I need to. I one more point if the court feels necessary. One, we just received these photographs when we walked in this morning. Two, if there are photographs that were previously disclosed, they're black and white photocopies, which is significantly different than something.
He shrugged. So he tried to sneak it in and say, the PowerPoint is just photos. And even though we didn't give them the PowerPoint, we've given them all the photos and all it is photos. And Mr. Byers is saying these photographs that we were given in discovery were all black and white. And Mr. Ashton is like shrugging like, so just wait.
That is in color. Everything that they've
This is gross. The pictures that are in the PowerPoint are in color.
been presenting is in color. If they plan on presenting in black and white, okay. Let me go back. I'm sorry. Was this the same person?
Yes, it was.
So it's the same person, two different types of post-mortem banding characteristics?
Well, they're both post-mortem bands.
Okay. But the characteristics appear to be different, do they not?
One appears to be closer to the root than the other.
If you may.
Wise is done. The first point is that the FBI had offered to transmit these materials to the FBI field office in the location.
This is so stupid. He's trying to blame the FBI. It is not the FBI's fault. It is your fault.
Of the defense's expert so that they could examine it. And I understand that the defense did not take them up on that. So there has been
the thing. It is not the FBI's job to provide discovery and just provide discovery in the correct form. So he's trying to make it seem like it's the FBI's job.
an opportunity for their expert to examine this material. Second is this, and we can take, and we will get testimony from the witness on this. This study was contemplated before the deposition in this case.
State has indicated by notice filed that they seek the ultimate sanction, in this case, death by lethal injection upon the defendant if the defendant is convicted of the crime of murder in the first degree. Rule 3.220 specifically provides the state of Florida with the specific obligation to provide certain things to the defendant.
Yes, sir.
It is not the FBI's sole responsibility to provide particular items. The Sixth Amendment to the United States Constitution.
Like when you hear him say Sixth Amendment, you're like, oh wow, he's actually going to make a ruling that's a proper ruling and it's in favor of the defense. Because there's been so many rulings where it's like, really, but it's like you know. So with him, I'm almost like thinking, oh, it's probably going to rule in favor of the state. As soon as I heard Sixth Amendment, I was like, fuck yeah, Judge Belvin getting it right on this one.
Made applicable to the states via the 14th Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to confront the witnesses against him or her. The court does find it troubling that the state at the 9th hour provides a PowerPoint with color photographs that was not provided to the defense.
It's insane.
Therefore, the court will not permit the utilization of the PowerPoint since it was not provided to the defense. It is the state of Florida who is the proponent and will be presenting this evidence, and it is the state of Florida's obligation, not the Federal Bureau of Investigation, to decide when they want to let something go and when they don't want to let something go, particularly when one wants to initiate the ultimate sanction given by law. Therefore, the court will sustain the objection to the use of the PowerPoint.
Yes.
And when these two different examiners on two different hairs gave their opinion, they were wrong.
Correct. They did commit errors.
Okay.
Interesting.
Let's see if I can redo the question because I'm not certain I asked you this correctly.
Oh my God,
Mr. Rephrase your question.
Ashton.
Let me rephrase this, sir.
Sure.
That's what he was.
You don't know if post-mortem root banding is exclusively from people who are deceased, correct?
There
That's
it is.
correct.
Oh, that's
And you can never testify in a court of law to such a fact.
That's correct.
Okay, so when someone says this is post-mortem root banding, they're not saying it's from a dead person, correct?
That's correct. Not.
That's what is
so
the point.
that's what I meant when I said the person who made the call, they were wrong according to what you consider post-mortem root banding.
Well, not just what I consider post-mortem root banding, but also the two of them. I mean, once they did initial analysis and discussions, they excluded those hairs.
Those 3 pieces of duct tape were received.
I mean, y'all, there was so much in this trial about the hair. One hair. That's all it is. They had one hair that was in the trunk that showed. Well, I'll even if you say it shows post-mortem root banding. I'm trying to remember when Dr. Karen Korsberg Lowe was on the stand, I'm sure there were problems with that as well. But even if you say, okay, sure, it's definitely post-mortem root banding, the other FBI guy point blank just said they found it when they did that study. They found characteristics of post-mortem root banding in hairs that came from alive people. They cannot say that so in other words, the whole thing is just pointless. Like, the whole theory was like post-mortem root banding is called that because it means that this is a hair from someone who's deceased, but they're finding those characteristics on regular people's hairs. So it's like, it's not even a real thing. Sad. And that's why I think we have not heard, or at least I have not heard, that type of soft science
to me as Q items
used in any other trial. This is the only trial I've ever heard them talk about this post-mortem root banding, and I wonder if this was the only time, because it was like, yeah, it's not a thing.
and I refer to them as Q62, Q63.
Okay, so we're getting into the duct tape and the heart sticker, and that's going to be a big thing that's coming up in this episode, because again, this is the recap. This is some really crazy stuff that's going to happen here with this, where we're going to see the state try to hide things from the jury, and the jury is like, no, we're not having any of that. Of all the times I've gotten angry with the fact that the state is allowed to present certain pieces of evidence for different reasons, whether it's because it was tested improperly or because it was like, whatever the circumstances were, right? The thing with this heart sticker probably pissed me off more than anything. And that's a tough, that's a high bar, because there's been a lot, but we're going to get into that testimony today where it's like, and the reason I'm mentioning it is because I had somebody come in the chat. This was probably 2 weeks ago or 3 weeks ago or something. And again, this heart shape thing in the duct had not come up yet, and up until now, like in the trial. So I didn't know about it. And this person came in the chat and was like, referencing this, like, oh, hi Candace, happy to see you. Like this, this piece of the person said, here's what they said. And when they say this, they didn't watch the trial. So the reason I'm even referencing this is because what this person said is probably what was reported by Nancy Grace and reported by the news media. And so this is probably what a lot of people think. And so I want to make sure that we know what the popular opinion was, because we're going to hear the truth and then we can see and compare. So here's what was told to me. And again, this would have been the popular opinion at the time. Probably it's what's clearly still what many people think, that what they thought came in at trial, okay, was that there was the piece of, we had the one piece of duct tape that was on the remains, and it was not on the mouth and it was not on the nose. It was on the bottom part of the jaw, okay? But that one piece of duct tape, that one piece of, there's a number of elements and all of them are going to come up. So I'm going to break it down. That one piece of duct tape specifically had an outline of a heart-shaped sticker or whatever on it, okay? That's part one. And that part two, that sticker was, and actually, let me correct it. What the person actually said was that the actual sticker was on it. The person told me that the piece of duct tape had a sticker on it. Okay. But even that's not correct. So, but it's an outline. There's a lot of problems, but even if you go with sticker or outline, okay. And that sticker was the same sticker found in Casey Anthony's room. That's what apparently people think. And we're going to get it. It's sad. It's sad isn't even the word. I don't have a word, but we're going to see what the actual truth is. How it comes, how they go from what actually came in at trial to that blows my mind. Okay, but we're going to get into this today. So. I think StreamYard is having a moment. StreamYard moment. By the way, when this was happening on the last one, what I've been doing is timestamping it if it freezes for a long period of time, so that way you guys can skip it. And it's stamping it to like StreamYard Glitch, and then when it's fixed. So hopefully it'll start working here in a second.
And Q64. Q62, upon initial receipt, was a separate piece of tape. and Q63 and Q64 were initially received on top of each other or stuck together.
And on which exhibit?
Okay. And there's a reason that I included this in the recap, because remember what I said that I was told to me was that there's the one piece of duct tape that was on the remains, and then the other two pieces that were not on there. They were 7 feet away and they were stuck together. Okay. And remember, what was told to me was that there was a heart-shaped sticker on the piece that was on the remains. Okay. Keep that, remember that. Okay. Because the Q numbers matter. That's why I included this, because the Q numbers matter.
Did you see that this item we're going to talk about?
It was on Q63.
Okay.
And what?
She's gonna talk about what she found on Q63. So what's Q63? Q63 is one of the two pieces of duct tape that were 7 feet from the remains and were stuck together. And 7 feet from the remains matters for a lot of reasons we're going to see. But the point is, so far what we know is whatever it is she's going to describe, first of all, it was not on the duct tape that was actually on the remains. So the first point of going through again what the popular opinion was is what was again relayed to me. Wrong piece of duct tape, people. Okay. So that's the first thing. It was found in between the two pieces that were stuck together 7 feet away from the remains.
What did you see?
During my examination of Q63, an outline of a heart appeared in one of the corners on the edge of that piece of duct tape.
Now, can you give us any further description of what?
I'm pausing it because in case anyone's thinking, oh, good, are we going to get to see a picture? Yeah, wouldn't that be nice? So Conscious Machine is saying, I was in your chat. Okay, that's where I remember you from when I was doing Karen. Well, I'm still covering Karen, but yeah. Yeah, it's, we still don't know what happened. There's a similarity, right? We still don't know the truth really of what happened to John O'Keefe. And we still don't really, again, in terms of it being adjudicated, right? We still don't know the truth about for Caylee, you know what I mean? Even if we say that we know for sure that, again, it's not been adjudicated, but in terms of what the evidence bore out so far in trial, and I think is going to continue, that it was an accident, George was involved, an accidental drowning. We still don't really know the full details, right? Same thing with John O'Keefe. Like we can kind of, say, okay, well, there's this thing points to that or whatever, but we still don't really know. But what we do know in both of these cases is that the person who was charged did not commit a crime, right? We do know that. So, yeah. Okay, StreamYard. Okay, let's work.
This shape looked like. About how big was it?
It was approximately the size of a dime. And the best way to illustrate what I saw was if you were to wear a Band-Aid for an extended period of time and eventually remove that Band-Aid, you have that glue or debris surrounding the outer edges of that Band-Aid. The outline of the heart resembled that glue or debris that if you had been wearing a Band-Aid for an extended period of time. However, rather than in the shape of a Band-Aid, it was in the shape of a heart.
Now, upon seeing that, did you believe it to be of any special significance in the case at the time you saw it?
At the time, no.
Did you note it in?
Okay, first problem, why not? Okay, why not? Let's keep in mind, guys, right? What is the job of these people when she's from the FBI. Is their job to just look for certain things when they're given evidence, right? They're given evidence, in this case, duct tape, and they're supposed to examine it. Are they supposed to only look for certain things to examine? Or are they supposed to examine it and whatever you find, right? I mean, how is this supposed to work, right? Like, listen to what she says.
Your file.
I noted it in my file and I notified the appropriate people involved in the case.
Did you photograph it?
No, I did not. The FBI does not require photographing of unexpected items to be done.
All right, unexpected items. The way that this makes me so angry and sad, because you know what that means? If that's true, what that means is that they only want you to photograph expected items. So what does that mean? Think about this, guys, logically through. Think about this. If they only want you to photograph expected items, that means that you go into it as an FBI analyst looking for certain things and ignoring other things. In other words, if you expect it to not have something, then that's what you're going to go find and photograph. It's the opposite of what you're supposed to do. You're supposed to document what is, also, if you only photograph expected things, then what's even the point of examining it, right? Like if you're just going to, isn't the point the unexpected? Isn't that the point? I don't understand. Like, compare it to something else, right? Compare it to a gun, okay? Let's say that they're inspecting a gun for fingerprints, okay? And let's just say that they are like, yeah, we don't think anyone touched this gun, so we're not expecting any fingerprints, okay? And then they find a fingerprint. You're supposed to say, I'm not going to photograph that, or I'm not going to take the proper documentation of that fingerprint because we didn't expect it. And the expectation is prior to testing, right? It'd be like looking at a piece of evidence and it's like, in other words, it's theoretical. It's not like we already tested it, so we don't expect something. No. They're testing it now. So the expectation would be going into it ahead of time. I just don't. You guys see why this is so upsetting and problematic?
In this case, when I observed the unexpected item, I continued on with my examination. And upon completion of processing and examining the duct tape, I did attempt to photograph the heart. However, at that point in time, it was no longer visible on the object.
All right, next problem with that. So if your job is to only photograph expected things, then why did you change your mind and decide to photograph it later? And just how convenient that it's not there anymore, right? All of this is just too convenient to try to explain that this thing existed, but there's no proof of it, and then why there's no proof of it. That's the only explanation, because none of this makes any sense. Like, she would have done better to say, yep, I didn't even attempt to photograph it the second. I didn't attempt to photograph it because it's not the possible. Like, that's bad, but you know what? At least it's more consistent, because it's even worse when you're contradicting it, saying, well, now I decided to photograph it, but it was gone. I can't with this.
Well, when you went back to try and photograph the whatever
How does the state bring this shit in, honestly?
you couldn't find it anymore.
That is correct.
Now, do you know what that artifact was?
Other than stating that it was in the shape of a heart, approximately the size of a dime, I cannot go further.
And do you have any idea how it got there, when it got there, who put it there, or why?
No, I do not.
You're aware that the item of evidence, after you're finished with it, goes back to evidence control and then probably to another division.
That is correct.
Okay. And you're aware that the item was later contaminated by another member, weren't
I'm waiting for that.
May we approach?
You may.
Disgusting, that thing.
Objection sustained. You may continue.
His face. I love this so much.
Okay, ladies and gentlemen of the jury, we're going to recess for the balance of the day.
All right, so here we go, guys. Yay! Into the next episode, episode 17, The State Rests. Here we go.
My name is Catherine Theisen. Catherine is spelled with a C, and Theisen is spelled Theisen.
You may proceed, Mr. Ashton.
Thank you. How are you currently employed?
I'm employed as the Chief of the Quality Assurance and Training Unit at the FBI Laboratory in Quantico, Virginia.
And how long have you been employed by the FBI?
For 23 years.
What work did you do while with the FBI Laboratory before your current position?
For 6.5 years, I was a research scientist, and in that position, I researched and developed new forensic DNA typing techniques for the FBI Laboratory and for other laboratories. Then for 5 years, I was a quality assurance specialist in the FBI Laboratory, and I developed quality assurance procedures and practices for use by our laboratory. And then following that, for 9 years, I was a forensic mitochondrial DNA examiner.
What is your educational background that led you to your positions with the FBI?
I have a bachelor's degree in biology from the University of Virginia and a PhD in human molecular genetics from Johns Hopkins University.
Have you taught any classes in forensic DNA analysis?
Yes, I have. Over my career with the FBI, I've taught numerous classes, mostly at the graduate school level, to personnel from crime labs from around the country as well as other labs in the world.
And what specialized training, or have you received any additional training with the FBI Laboratory since the PhD and the master's you told us about.
Yes, specifically for my position as a forensic mitochondrial DNA examiner, I was in our training program for over a year, and that training program consisted of formalized lectures and independent study, as well as lab work, and at the culmination of that was being subjected to numerous examinations, which qualified me to be a forensic mitochondrial DNA examiner.
Have you ever testified as an expert in that area in the past?
So to this comment right here, I just have to say, quabity. Oh my God, you said that. I didn't even see that. That's so funny. Jinx. Yep. I got your reference. Huge Office fan. Oh yeah. Yep. As soon as you said this, I was like, oh my God, that's amazing. Yes. Quabity. What does he settle on? Quabity. Affluent, he doesn't get assurance fright either. That is really funny. Really funny.
Past.
Yes, I have.
On approximately how many occasions?
This is my 20th time.
And in how many different, all federal jurisdictions, all state, or a mix?
A mix, mostly state and local jurisdictions.
This time, Your Honor, I would submit the witness as an expert in the area of forensic mitochondrial DNA analysis.
No objections, Your Honor.
The witness will be accepted as expert witness in the area tendered. You may proceed.
Great minds think alike, people.
Pardon me. Would you tell us?
Speaking of great minds, just another Office reference that I try to bring up whenever it's applicable. There's the one where Michael Scott is quoting. He's saying he's talking about I don't remember what the context is actually, but it's the one where he's like, oh yeah, he's talking about Dwight, and he's like saying like he's talking about a tiger, and he's like, nobody knows. What does he say? He's like, what is the tiger thinking? He's like, no one knows. No one knows what's inside the mind of the tiger. And then there's a long pause, and then he's like, we don't have the technology yet. He says it with a straight face. It's so good.
If you would, what type or types of DNA testing are done by the FBI laboratory?
The FBI laboratory conducts nuclear DNA testing and mitochondrial DNA testing. Nuclear DNA is inherited from both of our parents, from our mother and our father, and nuclear DNA testing then gives us the ability to potentially identify a person as a source of an item of evidence to the exclusion of any other individual. Mitochondrial DNA, on the other hand, is inherited only from our mothers. So we share our mitochondrial DNA type with our mothers, with any siblings we have that share the same mother.
Do you guys think she's ever given this exact same explanation before, ever?
And also, by chance, we share our mitochondrial DNA type with other non-related people. So therefore, mitochondrial DNA testing does not give us the ability to identify a person to the exclusion of anybody else.
How is a mitochondrial DNA examination conducted?
There are several steps that make up a mitochondrial DNA examination. First, the DNA is extracted or isolated from an item of evidence. That DNA is then subjected to a process that we call PCR, which copies that DNA or amplifies it, which then gives us enough DNA to take further along in the following steps of the test.
PCR, anyone thinking about PCR tests? I just wanted to say, Candace, I'm really sorry to hear this about your daughter. Keep us posted. I hope that's something that you get to have that happen sooner rather than later. Sorry for this awful pause. Let me. Okay, that's fine. That's better, I guess. But I also wanted to say that this is going to be such an exciting episode because of the fact that we're going to hear from Cindy again. We're going to get this part about the duct tape and the sticker is insane, and I can't wait to get to the part where the jury calls out the state for hiding evidence from them. And that shows how much they're paying attention. I mean, at that moment, right? Can you imagine if you're the jury? Anyway, we'll get there. But the other thing I wanted to say is that for anyone who hasn't seen this, and I know most people probably haven't watched this trial gavel to gavel, so at the end of this episode, we're going to get to the motion for a directed verdict. And I've mentioned it before, but I just wanted to say it again in case anyone hasn't heard this. It is, we usually see that as like a formality, right? It's just sort of like whatever, it happens in every trial. This is different. This motion for a directed verdict is not to miss. Whether it's on replay or while it's live, either way, the motion for a directed verdict is monumentally incredible. It's powerful. it's really something. It's really something. It gives me goosebumps just thinking about it, actually. And the other thing I was going to say too is like Judge Ashton. So Mr. Ashton, by the way, for anyone who hasn't heard this news, he did become a judge later. Okay. And he, like him and Miss Drane-Burdick continue to work together. But here's the other crazy thing. He's been in a lot of hot water. And actually, as recently as October, they've been trying to remove him from the bench because he's been like accused of all kinds of stuff. Like, I think there were some accusations of like, maybe I'm trying to remember. It was like inappropriate misconduct. And being really aggressive at like people. Like they were like saying he can't control his temper. And I don't know, you guys can probably Google and look it up, but like, it's crazy. Like he's really, so he became a judge, but like they're in the process now of trying to get him removed from the bench. And the last I heard was in October that they're still working on that. And so we could get those results. Who knows when, right? But he's, I think, suspended temporarily for his behavior. Isn't that crazy? And I think he also was sued for something, or even had maybe something like a criminal charge pending. But then I don't know. It's pretty crazy.
That DNA, we then type it through a process.
The only prosecutor that I can tolerate for this trial is Mr. George. Mr. George has not been shady. Mr. George, and that's why also all the especially shady witnesses and especially shady evidence has been handled by Ms. Drane-Burdick and Mr. Ashton. Mr. George, we saw him way more at the beginning with like the lay witnesses, like the people who were the friends and whatnot. He took like all of those, and then he has been just kind of hanging out. But I actually like his demeanor. I think he seems like a nice enough guy. Doesn't seem weaselly, doesn't seem like a jerk. So I just want to say shout out to Mr. George. And it's interesting too, right, that you have going on forward into the future. You have Mr. Drane-Burdick and Mr. Ashton still working together and being involved in maybe some controversial stuff and, corruption and whatever. And I don't know what Mr. George is doing. I wasn't able to find that, but yeah.
Process called DNA sequencing. And that DNA sequencing allows us to look at the individual building blocks of a portion of our mitochondrial DNA. That by looking at those building blocks, we can establish or determine a mitochondrial DNA type. And in a forensic examination, we'll typically compare mitochondrial DNA types from different items of evidence, both items of evidence of unknown origin and items of evidence which may be known reference samples from individuals involved in a case.
You and your case.
And finally, those mitochondrial DNA types can be subjected to a search in a mitochondrial DNA database.
And what are the possible outcomes of a mitochondrial DNA analysis?
If a mitochondrial
One thing I will say is we've heard so much about the Q and the K, and we're going to hear there's going to be even more, right? I love it whenever we learn something in a trial that we can carry over for the rest of our trials. So anytime, guys, whenever you're hearing from an FBI, testimony in a trial, if you hear them and they're going through items of evidence and they say they're going to start with a Q or a K. And so now you're going to know going forward, unless they change their system, but I doubt it. Going forward, you're going to know what that means. So even before they start describing pieces of evidence, you're going to have a little bit of information about it because you know what that letter stands for.
Mitochondrial DNA type from an item of evidence from a crime scene is different from a mitochondrial DNA type from an individual, from a known reference source. That item of evidence can be excluded as originating from the source of that known reference sample. On the other hand, if two mitochondrial DNA types are the same, the source of the reference sample can be included as a source of that item of evidence.
If an individual cannot be excluded and is a possible source, what is the significance of that?
If an individual cannot be excluded as a source of a particular item of evidence, we then calculate an estimate of how common or how rare that mitochondrial type is in the general population. And that estimate is based on the results of our database search.
Why would a particular piece of evidence why would a mitochondrial test be used at a particular piece of evidence as opposed to a nuclear DNA test?
We use mitochondrial DNA testing in or on items of evidence which we would expect would not give us enough nuclear DNA to conduct that kind of test. Typically, that kind of evidence may be a shed hair or skeletal remains. Those items may not have enough nuclear DNA. Therefore, mitochondrial DNA typing gives us some DNA evidence, some DNA type, which then is a powerful tool for excluding a person as a source of an item of evidence.
So I think what they're going to be trying to get into is like proving that the hair found in the trunk was Caylee's hair. I don't know why, because I thought that was just like, no one contested that. And it doesn't matter because it was one hair. And as we just referenced earlier in the recap for this episode, they can't say that post-mortem root banding comes from dead people because they found post-mortem root banding in alive people's hairs. So it doesn't even matter regardless. Anyway, all right, I think that's what they're going to be getting into here.
In July of 2008, was some evidence submitted to you for possible examination in reference to a victim by the name of Caylee Marie Anthony?
Yes, it was.
Did those, pardon me, did those exhibits include a portion of a hair designated by your laboratory as Q12?
There it is.
That was identified by trace evidence examiner.
Yes, the designation.
So it's the hair. By the way, for anyone who doesn't know, Mr. Ashton's been sick for like a bazillion years. So that cough, I don't even notice it anymore. But yeah, he's always hacking up along ever since, like, I don't know, maybe a week into trial started.
That hair was actually Q12.1.
The portion that you got was 12.1.
That's correct.
All right. Well, you also submitted some purported buccal swabs from someone named Casey Anthony.
Yes, that item was identified in our laboratory as item K1.
Madam Clerk, could I have items for identification IU and IV? Thank you. May I approach the witness?
You may.
Both of us. Let me show you what's been marked for identification as IU and IV and ask if you recognize those as containing the buccal swabs purported to be from Casey Anthony that you examined.
May I open this package?
You may.
Yes, this item was identified as K1, identified as a buccal swab from Casey Anthony.
Right. That was in reference to State's Exhibit IV. If you do the same examination of IU.
Yes, this is another sample of item K1, identified again as a buccal swab from Casey Anthony.
And is that one of the items that you looked at in your examination?
Yes, it was. I can identify that by the initials of the staff in the laboratory.
Thank you. Did you do a mitochondrial DNA test on State's Exhibit, on your Q12.1, which is a portion of the hair purported to be from the trunk liner of a vehicle?
Yes, I did.
And were you able to get a mitochondrial DNA? Would it be called a profile?
A profile or a type, both are appropriate.
Okay.
Yes, I did.
Did you also obtain a mitochondrial DNA profile from the exhibits I just showed you?
Yes, I did.
Based upon those two profiles, can you come to any conclusions?
Yes, I can.
What would those conclusions be?
The mitochondrial types from the Q12.1 hair and the K1 buccal sample identified as coming from Casey Anthony are the same. Therefore, neither Casey Anthony nor Caylee Anthony can be excluded as a source of that Q12.1 hair. Further, I would not expect to see that mitochondrial DNA type in more than 0.26 of the African American population, nor in more than 1.85% of the Caucasian population, nor in more than 3.9% of the Hispanic population.
Now, when you indicate that that result cannot exclude either Casey Anthony or Caylee Anthony, your understanding is Caylee Anthony is the daughter of Casey Anthony.
Yes, that is how it was identified to me.
Right. Would that result, also not exclude Casey Anthony's mother?
That's correct.
Would it also include, and I'll just use that word include because it's easier for me to say, Casey Anthony's brother from the same mother?
That's correct.
It would also include Casey Anthony's maternal grandmother?
It would.
All right. And any maternal uncles?
It would as well.
Turning now to December of...
So here's the crazy thing about this, guys. Here's the crazy thing about this, because like we were just talking about the post-mortem root banding. Here's the thing. So the state in this case, I don't even know, man. So they've got this one freaking hair, okay? They've got one hair from the trunk. And the hair has post-mortem root banding, but as we were just talking about, that's why that to my knowledge, was never used in any other trials because they can't even say that's from a dead person. Like, in other words, they need to rename it because post-mortem implies it's from a dead person, but their study proved that they were seeing those same characteristics on hairs from live people, right? So here's the problem for the state, that they've got this one hair, and now they've got to try to prove. So first they're trying to prove that it was from a dead person. That didn't work. But now they're trying to prove that it's from Caylee. But the problem is that it's going to get kind of silly, actually, as you guys will see. The problem is that, with the DNA, right, they're having to use this mitochondrial DNA, and they can't exclude other people. So, for example, even just the first part, they said they couldn't exclude Casey. Okay. So you see where the problem is with this? Because if you want to believe, it's one expert versus in other words, the state's evidence is contradictory. Because if you want to say, okay, I believed the lady about the postmortem root banding, then at the same time, you would have to concede, wait, does that mean that Casey's dead? Right? See what I mean? So what they're going to end up having to do is, from just like the testimony from Cindy, is ask what were people's hair lengths and what was their colors? And the state's going to try to prove that this hair was Caylee's hair because of whatever, the length and the color of it, which again, doesn't even matter, because the only reason they're even bringing it up is because they want to try to prove that hair was from her being dead. Again, because of the car. It's so sad. And even if you give them even if you concede all these things that make no sense, what you're still left with is the postmortem root banding doesn't mean anything, because they found it on hairs from living people. So all it would show is that there was a hair somewhere that got somewhere, which, I mean, happens everywhere all the time. I mean, it's just insane. It's insane.
2008. Did you receive an additional sample for mitochondrial DNA examination?
Yes, I did.
And was this designated by your laboratory as Q59.1?
Yes, it was.
And was this a portion of an exhibit identified as Q59, identified as a hair mass?
Yes, that's correct.
And did you subject portions of that to the same mitochondrial DNA examination as the 12.1 hair?
Yes.
And what were the results?
The mitochondrial DNA type from the Q59.1 hair is identified as coming from the Q59 hair mass is the same as the mitochondrial DNA type of the K1 buccal sample identified as coming from Casey Anthony. Therefore, Caylee Anthony cannot be excluded as cannot be excluded as the source of the Q59.1 hairs from the hair mass. I would not expect to see that mitochondrial DNA type in more than 0.26% of the African American population, nor in more than 1.85% of the Caucasian population, nor in more than 0.39% of the Hispanic population.
Okay, let me just explain what she just said, because it's so insane. So what she just said, so remember, they have the remains, right? And the remains had hair. So that's what she said. When they say hair mass, they're talking about that hair is known to be that hair is known to be Caylee's hair, right? No one's disputing that is Caylee's hair, right? And also that hair is on a dead person, right? But what's so crazy is that, so what she's saying is she tested that hair, the hair mass, right, against Casey's buccal swab, Casey's DNA. And then the thing that is so crazy is that she conveniently says Caylee couldn't be excluded as a contributor of the DNA in the hair mass, but equally neither can Casey. So by this, if you use their own logic to say that, oh, that means that hair came from Caylee, even though that's not in dispute, if you use that same exact logic and the same numbers, what that's also saying is that the hair that was on the remains could be Casey's hair. Do you see how much sense that makes, guys?
So, therefore, based on your examinations, the hair from the trunk, Q12, and the hair mass, Q59, are a mitochondrial match. Is that correct?
That is correct.
And they would match either Caylee Anthony, Casey Anthony, or anyone in the maternal line.
So, like, a bunch of people. Like, this is so stupid.
Yes.
Now, would then you look to other disciplines to further narrow down the possible contributors? beyond that.
Yes, mitochondrial DNA alone cannot make those distinctions.
But other disciplines such as trace analysis might be able to further limit the possible contributors.
That is possible, yes.
No further questions, Your Honor.
Great.
Cross-examination.
May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen.
I love Mr. Baez.
Good afternoon, Ms. Theisen.
Good afternoon.
Now, you testified that you were, or the quality control officer for DNA 2 division?
And now I'm the quality manager of the FBI laboratory.
So that's the entire laboratory?
Yes, it is.
Okay. And could you explain to the ladies and gentlemen of the jury exactly what that means?
What that means is that I oversee a group called our Quality Assurance
Wouldn't it be funny if she did like Creed and just ran out of there when asked that question?
Group, and that group is responsible for putting into practice numerous policies and procedures which ensure the quality.
You know what's funny is that just because I'm highlighting it because of Creed and how Creed gets asked that question and then he just like runs away. That made me realize though that, you know, what didn't happen is that Mr. Ashton didn't ask her that on direct. And you want to know why? Because there's already been little hints at that there was some contamination from the FBI laboratory and that they contaminated the duct tape with a fingerprint. So, you know, again, the state, I don't know why I should be giving advice to them because they don't, I mean, hey guys, have you never heard you're supposed to get out ahead of all the bad stuff? Like, that's what you're supposed to do, people. Hello? Like, have you never, like, I don't understand.
Of our casework.
They don't get out
we
ahead
also evaluate proficiency tests, conduct audits of our laboratory, ensure that we meet all the standards of our.
You asked her that question and she just jumps off the stand and just bolts out the door. I would die.
Accreditation.
I'm picturing it just because it's so funny.
And just to kind of break that down a little bit more, the policies and procedures, they're often called protocols, are they not?
We do use those terms slightly differently, but in general, yes, that's correct.
Okay. And what you do basically at times is you develop the rules of how each item is processed and how each item of evidence moves forward throughout the laboratories, correct?
In our unit, we do that to a general degree, and then each individual discipline or caseworking unit has further procedures which specify how items of evidence are moved through and processed through their individual units.
And what that does, and part of that, even for your area of mitochondrial DNA, at least when you worked in that division, there would be like a checklist of things that you have to do and check off as you process that item of evidence, correct?
We don't actually use a checklist, but there is a set procedure that is used as cases and evidence are processed.
And as part of quality control, you also have sometimes people checking up on the first examiner's work, correct?
Yes, all of our casework is subjected to, at a minimum, 2 levels of review.
And what's done in addition to that is each person who works in your laboratory also has proficiency tests to make sure their work is up to par, correct?
Each person who handles and processes evidence in a particular forensic science discipline is indeed subject to proficiency tests, yes.
Okay. And the reason that you have all of these steps in place is to prevent contamination, correct?
Objection exceeds the scope of direct.
I believe this witness has testified about.
You know, it's interesting because this is the only trial I've ever seen where, and I noticed this from day one of trial, where they have objections that, okay, so someone will make an objection on cross, like whoever's doing cross, like they'll make like the state, in this case, we're still in the state's case, the state will make an objection that it exceeds the scope of direct, and those are always sustained. And it's real. I've never, ever seen that before because typically, I mean, always, except for this one trial, and maybe this is Judge Belvin's practice, but you know, you're always given a wider latitude on cross. Like usually when you hear outside the scope, it's if it's like recross or redirect, something like that, or you might hear it outside the scope of expertise. That's when you're talking about an expert witness or something completely different, like beyond the scope of their expertise or beyond the scope of disclosure. But beyond the scope in terms of like the questioning, the line of questioning, you would only get that if it's like a redirect and it's beyond the scope of recross or something like that, right? But you never get it on. But so I just wanted to note that, because in this court, you can't ask questions on cross that didn't come up in direct, which is wild.
That area, Judge.
Sustain.
Yes, sir.
Wild.
Now,
the other thing I'll say real quick is that alone is such a huge handicap if you're a defense attorney in front of this judge. It's huge. It cannot be understated or overstated. Wait, one of them. Overstated. Yeah. That is like, how do you do your job, right? That alone would be huge, but there's so many handicaps that Mr. Bias and the defense team face in this case that it speaks to a number of things: the intelligence of the jury, the weakness of the state's case, and the talent and the intelligence of the defense attorneys, that despite all of the handicaps, again, in terms of like the rulings and whatnot, they still managed to get an acquittal. It makes me have confidence in something. I mean, should have more confidence in the judge's rulings, but had she had different attorneys, Casey, it could have been a very different outcome.
The laboratory, and part of your job as the quality control officer would be to ensure, as you mentioned, that everything's in compliance with the accreditation of the laboratory, correct?
Objection exceeds the scope of direct, which was.
There it is again.
This is something the witnesses testified both under direct, judge, and cross.
Your Honor.
Sustain.
See? I hate it.
Your job as the quality control officer, of course, is to ensure that the integrity of the evidence is handled in its most efficient manner, is it not?
Objection exceeds the scope of direct.
Sustain.
Ma'am, as you testified, the entire maternal line in mitochondrial DNA cannot be excluded as to either piece of evidence that you handled, correct?
In general, that is true, yes.
Okay. And
StreamYard, no.
the item of evidence, specifically the Q12.1 item, that there is no indication as to, or you were not given any information as to its history, correct?
That is incorrect. I was presented with information as an examiner in a caseworking unit. I do get the communications that come into our laboratory about the case in general, and have those to review during when I'm conducting my casework.
So you were informed then that Lee Anthony once owned the Pontiac Sunfire, correct?
I did.
Hearsay.
I think this witness has testified that she was given information to help base her conclusions, Judge.
Well, she was, no, hold on. She was offered as an expert, so she's allowed to rely on hearsay.
That she indicated that was the basis of any conclusions she drew.
That's what he's making a distinction. Okay. So I was wondering if he was going to say that. So as soon as I said she's an expert, she's allowed to rely on hearsay, I thought, oh wait, hold on. I should have. The complete part to that is that they're allowed to rely on hearsay if it's to help form their final, opinions and conclusions. And so that was a correct objection from Mr. Ashton. I hate to say it, but that was a correct objection.
Use this information to assist you in carrying out your work?
No, I do not.
Okay. So it's just gratuitous information that you read because you like to read up on those topics? Or do you find that useful in your work?
I wouldn't characterize it that way. All of our case files are required to have in them by our policies what we call our incoming letters of communication, the letters that come in with the evidence that describe the case. It is a requirement, and we do read those. It's not used as a basis for my conclusions.
But it is still used throughout the course of your work, is it not?
I guess
because you read a file before you actually go on and do the work, do you not?
I certainly do read their letters, yes.
Okay. So in those inclusions, as you read your file, did it include the fact that Lee Anthony once owned the Pontiac Sunfire before Casey Anthony did?
Objection, hearsay.
Sustain.
Were you given any further information about the potential people who could not be excluded, such as Cindy Anthony and her maternal line?
Objection to hearsay because the question is vague.
I don't think the question's vague, Judge.
That was a good one. What type of objection is that? Objection to hearsay because the question is vague? What? Mr. Ashton, are you okay?
The question can be answered simply by yes or no. Objection overruled.
Could you please restate the question?
Sure, I understand. Were you given any other information as to the other people who could not be excluded on the maternal line, such as Cindy Anthony and other relatives?
I'm not sure what you mean by information. It may have been in the communications, the names of the parents of Casey Anthony.
Okay. And other relatives as well who couldn't be excluded?
Would be, excluded?
That could not be excluded, excuse me.
I don't recall specifically the mention of a Lee Anthony in the particular communications that I have.
Okay. No further questions. Thank you, ma'am.
Any redirect?
No, sir.
May the witness be excused.
Interesting. No redirect. Interesting.
As far as the state's concerned, yes.
Thank you, ma'am. You may be excused.
Thank you, Your Honor.
I'm Alina Burroughs, Alina.
The hair nonsense. Now we're back to the duct tape.
Burroughs.
You may proceed.
Thank you. Please tell the court and the members of the jury your occupation.
I am a crime scene investigator with the Orange County Sheriff's Office.
How long have you worked for Orange County?
I've been with Orange County since November 18th of 2003, which is approximately 7.5 years.
Were you working for the Orange County Sheriff's Office as a crime scene investigator back in December of 2008?
Yes, I was.
Right. Did you assist other crime scene investigators in the collection of evidence at the recovery site of Caylee Marie Anthony's remains in December of 2008?
Yes, I did.
Did you also assist other crime scene investigators during the execution of a search warrant on the Anthony home on Hope Spring Drive on December 20th of 2008?
Yes, I did.
If I may show the witness what has been marked as BT for identification. Can you see that on your monitor, ma'am?
Yes, I can.
Okay. Are you familiar with the location shown in the photo?
Yes, I am.
Okay. Does this photograph fairly and accurately depict the distance between the two locations, that being the Anthony residence on Hope Spring Drive and the scene where Caylee Anthony's remains were recovered on Suburban Drive?
Yes, it does.
Right. Ms. Burroughs, we have a notation on there as to the location of the Anthony home. Can you...
So remember, we looked this up, we Google mapped it. I think it's like 1/4 of a mile, something like that away, which is pretty crazy. I mean, I can actually see it, I think, in this picture of where the house is labeled. They haven't labeled the crime scene yet, but because we did the field trip there, I'm pretty sure it's actually in this picture. We'll see.
Circle the area. The screen is a telestrator. Can you circle the area where the remains?
Yeah. So it's right where the big the foresty thing is there. It's right there. But again, it was really close to the edge of the site. I think it was 10 feet from the road, actually, and like 6 feet from the grass line.
Were located.
Yes, the approximate area was.
There you go. How close?
Now, you had indicated that you also assisted during the execution of a search warrant on December 20th of 2008. What role did you play during that process?
During this process, I facilitated the location, collection, and documentation of evidence pursuant to a search warrant at the Anthony residence.
Right. If I may, did that include your seeing items before their collection?
Visually seeing the items before I handled them.
Yes.
In some cases, I might see them in their present location, or in some cases after they had been discovered, they had been brought to me.
All right. Are you familiar with whether or not there were heart stickers located in the bedroom of Casey?
So again, we're going through the whole thing about, remember, breaking it down one by one. Again, just to recap, the information that had been relayed to me that would be clearly the popular or the general consensus opinion of what people heard. It was, it's misinformation, whatever, was that there was a heart sticker on the piece of duct tape that was found on the remains, and that the heart sticker matched exactly a sticker from Casey's room. And so far, we're going in order. I'm not getting ahead. Going in order, the first thing that's incorrect about that was, from what we heard, well, there's two things actually. From what we've heard already, it wasn't a sticker. It was the outline of a heart. And of course, there's no photographs of it. We already heard that. But the second thing, and that's a big thing, is it wasn't on the duct tape that was found on the remains. It was in between the two pieces of duct tape that were stuck together, and they were 7 feet away from the remains. So next, we're getting into the next part, which is, what did it match any heart stickers that were at Casey's house or whatever?
See Anthony during the execution of that search warrant.
Even if it did, this isn't, I don't know why. The thing is like people seem to point to this like it was a smoking gun, and the only reason you do that is when you don't have anything. Because it's like I'm thinking to myself, even if it was, that shouldn't be enough.
On December 20th of 2008.
Yes, there were.
Okay. If I may show the witness QV for identification.
You may.
Do you see QV?
Yes, I do.
Is QV a fair and accurate photograph of an item that was located in Casey Anthony's bedroom?
Don't worry, guys. We're going to get more pictures of these stickers. And this is going to get into the part where the state tries to hide the ball from the jury.
Yes, it is.
Investigator Burroughs, where was this item located?
This particular item was located inside a yellow type of box, inside a dresser along the north wall of Casey Anthony's bedroom, just east of the head of the bed.
Okay. The box where that was located, did it contain other items?
Yes, it did.
Did the other items include an envelope?
Yes.
Okay. When the item was photographed, was the envelope just part of the background of the location where the sticker or the part of the sticker was found?
Yes, it was.
Okay. Is the sticker affixed to the envelope in any fashion?
No, it is not.
Okay. Do you see that item in front of you?
Yes, I do.
Okay. Is this a close-up of the same item that was displayed in 306 in evidence?
Yes, it is.
Does that also accurately depict the condition of the item when it was discovered during the search warrant?
Yes, it does.
You would take a look at the packaging on that item and tell me if you recognize it as something that you've had contact with in the past.
Yes, I do.
What do you recognize it to be?
This is the same red and white heart-shaped sticker backing that was shown in the previous pictures.
Was that collected and packaged by you and sealed in that envelope?
Yes, it was.
Your Honor, do you see QX?
Yes, I do.
Are there other stickers in that photograph that were collected and seized by you?
Yes, there are.
Where were those stickers located?
This is a sheet of heart-shaped stickers that appeared to have been cut in half. It was located inside of a black binder in that same cabinet as the previous sticker, which was located along the north wall in Casey Anthony's bedroom.
Right. Can you indicate by circling the item that you were speaking of? If I may approach the witness with what's been marked as QP for identification.
You may.
If you would take a look at the packaging associated with that item and tell me if it's something that you believe you've had contact with in the past.
Yes, it is.
What is it?
This is the sheet of heart-shaped stickers cut in half that was previously shown in photographs.
Were those collected by you, placed in that envelope, and sealed?
Yes, they were.
If I may have QY for identification. Can you see QY?
Yes, I do.
Okay. Do you recognize that as an item collected from the bedroom of Casey Marie Anthony?
Yes, I do.
Does that photograph fairly and accurately depict the item collected?
Yes, it does.
If you would take a look at the packaging associated with that item and tell me if you believe that is something that you've had contact with in the past.
Yes, it is.
What is the item in QO for identification?
This is a sheet of metallic red heart-shaped stickers with 3 stickers remaining on the sheet.
If you look at QY, which has been introduced as 311 in evidence that is still on your screen, can you circle the item that is contained in QO? Thank you, Ms. Burroughs. Your Honor, I have no other questions of the witness.
Okay, get ready for this
Cross-examination.
Y'all ready?
Good afternoon, Ms. Burroughs.
Afternoon.
The photograph on, can I see QV, please? 307. Your Honor, may I publish number 307 to both the witness and the jury?
You may.
Can you see it, Ms. Burroughs, the photo?
Yes, I can.
Can the ladies and gentlemen of the jury see it? Oh, now. Okay. Can you see the stamp on the right-hand corner of that item?
The postage stamp?
Yes, the postage stamp.
Yes,
Do you see 37 cents?
I do.
Okay. Do you know how long ago it's been since we've had 37-cent stamps?
I couldn't recall.
Okay. So obviously this is a very old letter, is it not?
The date of the letter with a 37-cent stamp, but I couldn't say when that was actually mailed.
Right. I understand. There were items in this box that were significantly old.
I wouldn't feel comfortable making that statement.
Did you see scrap items, like baby shower items?
Yes, I did.
Okay. And did you see other items for a scrapbook?
In that box or in the cabinet?
In the box.
No, I believe mostly baby shower items.
Okay. May I publish item number 311 to both the jury and the witness, Your Honor?
You may.
Can you see that, Ms. Burroughs?
Yes, I can.
Can the ladies and gentlemen of the jury see it as well? Okay. Now, there are also star stickers here.
Yes, there are.
There are a whole bunch of different stickers.
I mean, I knew this was going to happen because when the state put this part in, I'm like, oh, come on. You just need, why didn't you just not just leave it with the one sheet of the heart sticker? Like, because look at this. Look at all the different stickers. I mean, but don't worry. I mean, it's like there's more problems than just this. It's like, oh, look at all the different stickers. But yeah.
I see star stickers and the heart stickers.
You see Mickey Mouse stickers?
I don't recall if those are stickers or if they're just on a paper.
Okay. Do you see Pluto and other Disney characters? Minnie
Yes.
Mouse?
Yes, I do.
Okay. And do you see other scrapbook items in the room?
In
Or
the
did
room?
you see? Yes.
Yes.
Okay. This was a room that had a lot of children items in there, correct?
Would you define children items?
Scrapbooks for kids, things like that.
I don't recall seeing scrapbooks for children.
Did you see artwork of a child?
I don't recall.
Okay. You don't recall on the walls seeing different pieces of artwork that might have been done by a small child?
No, I don't. I recall seeing pictures, but no artwork.
Did you also search other areas of the home for stickers?
Yes.
Okay. And did you find any stickers in Caylee's room?
I don't recall if they were stickers, but there was a scrapbook page.
Okay. And did you take photographs of those of that scrapbook?
Yes, I did.
Okay. And they're not listed here or introduced into evidence?
No.
Okay. And what about in Cindy and George Anthony's room? Did you find anything in there? Or did you search there, I should ask first?
Yes.
Okay. And did you find any sticker type items in that room?
No stickers were recovered from the master bedroom, no.
Even ones that were actually placed on items? Or did you not consider those?
I honestly don't know what you're referring to.
I'm asking, did you find anything stuck to a piece of paper that would be considered a sticker in Cindy and George Anthony's?
No.
Okay. Now, I'd like to show you Defense Exhibit W which is a photograph of an item introduced into evidence in this case. May I approach the witness, Your Honor?
May I approach?
Yes. Since it's not introduced yet, I just want to ask you, do you understand that item to be something recovered off of Suburban Drive?
To my knowledge, yes.
Okay, and that is what you believe to be a sticker, correct?
I never held this object. I've seen photos of this object, so I wouldn't be comfortable determining whether or not it had an adhesive side.
Okay. Did you find anything remotely, well, did you find that item?
So in other words, that
the end?
they don't even know that it had adhesive
Anthony
on it.
Home.
This exact item?
Correct.
Because I have never actually held this item and I've only seen it in pictures, I wouldn't feel comfortable with that.
Okay. From what you see there, do you recognize what you see there from any item that you saw in the Anthony home?
Your Honor, I'm going to object. She's already indicated she's not comfortable giving her opinion about this.
She can answer the last question.
Can you repeat the question?
Sure.
We're getting into one of the most incredible parts, I think, of the evidence in this case in terms of the last efforts on behalf of the state and this thing about the heart sticker that apparently everybody just completely missed it. So we're going to get to it here.
Did you find that item at the Anthony home?
Not to my knowledge without actually holding the item.
I left that in there for that long pause for a reason because that was very interesting.
Okay.
That is not typical when it comes to something like this. You're an FBI agent. Let's hear it again. Interesting.
Giving her opinion about this.
And there's objections.
She can answer the last question.
Can you repeat the question?
Sure. Did you find that item at the Anthony home?
Not to my knowledge without actually holding the item.
Okay. We'll follow up with that later, but from what you can see, you didn't find that item at the house, right?
Again, I'm really not comfortable because I don't have measurements. I haven't held this item. I wouldn't be able to say in what size and if it was comparable to other items found in the house.
Okay.
Don't worry.
We understand. It's
the item in question, we will find out what it is, but right now it's an unknown item.
have limited knowledge. You've just seen it in photographs.
Yes.
But from the items you've seen in photographs, you never saw that item
Wait till we get to seeing what it is. It's shocking.
at the Anthony home, correct?
Sustain.
Okay. How far away from an elementary school was Suburban Drive?
There was one in the vicinity.
Okay. How far would you say the
Really
vicinity?
close, actually.
Don't like to make estimates.
Just a very rough estimate. Was it next door, across the street?
There was
Down the
one
block?
not directly across the street, but it was on the opposite side of the street, some distance away.
Okay. Closer, about 100 yards? away?
Like I said, I don't feel comfortable making estimates on measurements.
Okay. Can we have that picture up? Can you see that, Ms. Burroughs?
Yes.
I apologize. Can everyone see that? Okay. Would it be fair to say that approximately 30 yards from here is an elementary school?
Again, I'm not going to make an estimate as to distance, but there is an elementary school in the vicinity and it is not present in that picture.
Okay. But my question is it fair to say that it's about 30 yards from there? Or if you want to give it more, you can say 50, 100, however.
Because I've never been to that elementary school nor walked the distance from the crime scene, I'm not going to make an estimate
It's like,
of distance. I will say that it was in the vicinity.
Okay, so you can't help us any more than that.
Objection, Your Honor. This has been asked and answered 4 times.
Right here, ma'am. If you go further, that's a dead end, isn't it?
If you continue all the way down, that road does dead end.
Okay. And there is nothing, no homes or anything else but an elementary school there, correct?
I did not travel to the dead end of the road to be able to say there weren't residences.
Okay.
you know, how was she able then to just like circle on the map so without any hesitation where the crime scene was, but she didn't go there?
You were involved at the scene at Suburban Drive?
Yes.
Okay. And
She did go there.
you were there for how many days?
Roughly 9.
9 days. And you're aware that right
She's like, I'm not comfortable saying where the school was.
here, it was cut off from the public.
Wow.
Correct?
That's correct.
And you're also aware that the only traffic that was allowed through were school buses, were you not?
Yes, that's correct.
Okay. And that is because no other cars other than police cars were allowed through there, correct?
I believe families that were picking up children from that school were allowed that down
Well, there you go,
that
right?
road as well.
Okay. And no homes, no people, there was nothing else but a school there, right?
Again, I didn't travel that road to be able to answer that question.
Sustain.
Could you see anything other than a school there? A home, a barn, a shack, anything?
Objection asked and answered.
I don't believe that. Is there anything to give you any indication other than there was a school there, madam?
No.
I have no further questions.
Any redirect?
No redirect, Your Honor.
Thank you, ma'am. You may be excused.
Your Honor, at this point, I would introduce KV for identification of evidence, an item previously identified by Robin Maynard.
What says the defense?
I would object. The proper foundation, and we wait till this witness leaves the stand before we introduce that, so I couldn't ask her about it.
We have some questions you want to ask her about it?
That's the item.
This is the item. Remember when they were saying they were just that witness that just left the stand, right? And it was like, and I was saying, we don't know what the item is yet. The reason that they couldn't be more specific about it is because the state did not enter it into evidence. And so he couldn't ask her more specific questions about it. Remember how she was like, not without holding it, not without picking it up, I couldn't say. He couldn't ask her to do that because the state did not put it into evidence. The witness who they would have put this in through was Robert Maynard, who already has testified. This right here goes to show you that the state is trying to fucking gaslight the jury. Because here's the thing. This item, we're about to find out what it is. This is the item in question that it's like this unknown thing, right? They should have put it in through that witness who testified several witnesses ago. They didn't. And now they're trying to sneak doodle it in without any witness on the stand. But it gets worse. Just wait.
Of the photograph?
Stop the witness before she
She's like, oh, let me just hold it up and show you. What?
leaves the floor.
What is wrong with you, dude? You should be like, I resign and I surrender my bar license right now. Like, seriously, this is if this didn't get handled quickly the way that it does, only because of the jury eventually at some point, I feel like this would have been a huge, like, this is prosecutorial misconduct. Like, this is insanity.
You wanted to ask no questions, so just in case.
Bad. This is not, yeah.
I have no objections. Someone has asked the witness about
Asked who?
the last witness about the evidence.
So what he's saying is that because he wanted to ask about this, remember, again, the unknown item, he's like, and he wanted to ask her about it, the one who just testified, and he couldn't because it wasn't evidence. What he's saying is, okay, if we're going to bring back the other witness and get this into evidence, then does that mean I can get the next witness, the one who just finished, and ask her questions about it because I couldn't? That's his question.
And return the last witness to the stand.
Get her back.
Ms. Burroughs, you're still under oath. Mr. Baez, you may proceed, sir.
My apologies, Ms. Burroughs. We happen to have the item that you looked at. The photograph.
Oh, lucky you. He's like, look at how happy he is. The state had to, the state could have not put this into evidence. And, you know, they kind of took a gamble because it's like by putting it into evidence. Well, that's why they tried to sneak doodle it in, right? They wanted to get the dude. This is crazy though. I mean, when you see this, you're not going to be surprised that they try to sneak doodle. I mean, they shouldn't be doing it. Like, but if you're if you're them, you can see why they did it that way.
Graph of, and so that way I wanted you to see it. May I approach the witness, Your Honor?
You may.
So now,
What is the item's number?
Yes, the item is states
It's like you wanted to see the item. Here we go. Now we have it.
identification KV, which would be
KB, it's not in yet. That's what she had offered.
Remember,
She had offered it, and there was an objection that you wanted to question the witness, so.
I'm withdrawing our objection so that I can ask her about the item.
Okay, and since there's no objection, that item will be received into evidence. The state's numbered.
okay. So this is exhibit 313. Keep that number in your minds, guys. This is exhibit 313, and watch what happens.
Ms. Burroughs, can you cut that open? I'll see if I can get you some of those.
Thank you.
Have you had an opportunity to look at the item?
Yes, I have.
Now you have it. It's not in a photograph, right?
Yes, correct.
Okay. Did you find that item at the Anthony home?
I did not find this exact item.
Okay. Did you find that appears to be thick, does it not?
Yes,
Not a flat sticker?
correct.
Something that would be called, I guess, a bevel?
Yes, it's a raised surface.
Raised surface, yes.
As soon as I heard that, I was like, are they talking about a heart sticker that has a beveled raised surface? I was like, you've got to be fucking kidding me. Because you know what didn't have any of that? All of the stickers, whether it was a heart sticker, a Mickey Mouse sticker, a star, all of the stickers that the state showed that were from Casey's room, they're all regular stickers, like akin to a stamp. They're flat. And I'm like trying to picture, what does this item look like? Don't worry, we'll get to see it. But it's like a beveled edge. What? And it's like, you've got to be kidding me, especially because this outline, if it ever existed, right? Because the outline was never photographed. It was sandwiched between two pieces of duct tape.
You didn't find anything like that at the Anthony home, did you?
No.
Well,
No further-
so that right there already, it's like, okay, but the jury hasn't seen it yet, right? Because what happened was now it's been admitted into evidence. He could ask her about it, but it has not been published.
Any questions
Normally,
about the item?
as we know, normally things are published after they're been, right?
May Ms. Burroughs be excused. Mr. Baez?
Yes, sir. Thank you.
Thank you, Ms. Burroughs. You may be excused, ma'am.
Thank you.
Cynthia Anthony, CYNTHIA ANTHONY.
You may proceed.
Thank you, Your Honor. Mrs. Anthony, when you testified last, we had gone up through the time periods involving July of 2008. Do you recall?
Yes.
Okay. When your granddaughter was found on December 11th of 2008, where were you?
We were at the airport in Los Angeles getting ready to board a plane to come home.
Okay. So you were not present then when the Orange County Sheriff's Office executed a search warrant at your home on that date?
No, ma'am, we were not.
Between the end of July of 2008 and December 11th, had you noticed whether or not any items had been removed or not at the house? Things that normally would have been there that belonged to Caylee.
From July, July what date?
Anytime in July of 2008 through December 11th.
July 3rd, I remember Caylee's teddy bear, Teddy, was missing.
All right. Did Caylee also have a blanket with Winnie the Pooh on it?
Yes.
Do you recall during that time frame noticing that the blanket was missing?
No, prior to that time frame, it was missing.
All right. When did you notice that the blanket was missing?
I hadn't seen it since the end of May. It had been a while since I had seen that blanket.
I just have to say something. Is she wearing like a wig?
Now, we've seen some video of you and your husband, as well as your son and your daughter, taken in July of 2008. Is the hairstyle...
Oh my God, this is the dumbest thing. This is when they get, like I referenced this earlier. I forgot. I thought we were done with the hair and then okay. This is when they get into all the hairstyles. This is just all so that they can try to prove that that one hair that was found in the trunk came from Caylee, which again, doesn't even matter because as we know, post-mortem banding is not actually post-mortem banding. It's just banding and it's found on all types of hairs from living people and dead people. And they can't. Ugh. I have to say, this might be the weakest case I've ever seen in terms of the state. Like I'm trying to think like versus like Karen Reed. It's hard to put them side by side because there were so many other issues. You know, like for me with Karen Reed, it's like the red solo cups. It's just hard. You can't get past that. So it makes it harder to assess it. You know, when like in this case, there wasn't really problems with the investigation in terms of the way the evidence was handled, you know, and all that. Right. So like different thing, but like in terms of the case, I don't know. In other words, my point, I guess, is kind of this. There's way more evidence in this case than there is in other cases. Like take Delphi, right? Take Delphi, take Karen Reed, or other cases, right? Like there's many circumstantial cases that have way less actual like physical evidence or forensic evidence than this case, and didn't have nearly as much done. Like they went all out with this, right? They brought in 2 medical examiners. You never see that. Anyway, despite all of that, this is still, in my view, one of the weakest cases I've seen from the state. Like, if not the weakest. Despite all of the efforts, despite all of the negative media, despite all of the FBI, despite, I mean, you know, they pulled out every single stop and then some. And still, anyway, let me just keep playing the video.
That you had in the videos taken when you visited at the jail, the same hairstyle that you had for a significant period of time.
No, it's funny that I just made a comment about her hairstyle because I was just thinking, and I was looking at it, I'm like, God, it looks weird. Look at the way it is on the edges, like next to her eye. And I'm like, is that a wig? And you know what's really interesting is that if it's a wig, these questions about the freaking hairstyle are completely irrelevant if she wears wigs.
What's a significant period of time?
6 months to a year.
6 months to a year, yes.
Okay. How about the length of your hair over a period of time, a year or more?
My hair grows very fast, so prior to that, my hair was longer.
How long?
Well, even in the last several years, my hair's been down here ever since Caylee's missing. So my hair grows very fast if I don't cut it. I have to cut it every 3 weeks.
And do you do that regularly?
Yes.
Okay. Do you keep it in the approximate style or length that it is currently?
Great. What style would you call
until
that?
Recently, you know, I just started wearing.
Wow, what style would you call that? What style?
My hair like this again for the summer, but all through the winter months, I had grown it out again.
To how long?
It was probably past my shoulders around Christmas time.
The length of hair that we see in the July and August of 2008 videos, how long was it at that length?
Probably maybe a year and a half. Prior to that, I remember in 2006, my hair was long again. It was as long as yours.
Like no one remembers this shit. This is insane. Like she starts out like, yeah, my hair is pretty much always the same, but then it's like, listen to how many changes. Like what? It's like you made them. Like I made all these years ago. I remember I made this change. It was long here, and then I cut it, and I cut it every 3 weeks. But then I grew it out. Like this is insanity.
It is.
Now, has your hair been processed?
Yes.
In what way?
2001, I started, or actually 2002, I actually started putting hair color on. Prior to that, I just used highlights. I just would take strands of my hair and highlight it. I actually was brunette back in 2004.
Great, wonderful.
As we move from 2004 through 2008, did you continue to either highlight or dye or otherwise process your hair in some fashion?
Yeah, since 2002, I quit highlighting and I just would color my entire hair.
Ma'am, can you see two in evidence?
Yes.
Your Honor, may I publish to the jury?
You may.
Do you recognize that to be a photograph of your granddaughter, Caylee?
Yes.
Okay. Do you have any idea when that photograph was taken?
I'm not sure the exact date, but I believe it was early in 2008, like the first couple months of 2008.
Do you see the length of Caylee's hair in that photograph?
Yes.
As we moved into the spring and early summer of 2008, before June 16th, had her hair grown?
Yes, but I would trim it every couple months. I would trim the ends off just to keep it healthy.
Okay. Aside from trimming her hair, would you subject the child's hair to any sort of processing?
Absolutely not.
Do you have knowledge as to what processing your daughter Casey had done on her hair in 2008 or earlier?
Casey started doing different things after Caylee was born. She never really did much with her hair as far as color treatment or anything, but after Caylee was born, she started cutting it shorter, and once in a while she'd either highlight it, and occasionally she'd dye it back to its natural color and then let it grow back out.
Okay. And what is your daughter Casey's natural hair color?
It's a brown.
Ma'am, can you see QQ for identification?
Yes.
Okay. Do you recognize the individuals in that photograph?
Yes, it's Casey and Caylee.
Do you know when that photograph was taken, approximately?
I believe in the beginning of 2007.
Why do you think that?
You know what's so crazy?
Because Casey...
Like, when you look at that picture, look at the smile, and look at, like, that picture. You know, it's so funny because when people try to describe her as the way she was, you know, they try to describe Casey's demeanor, right? As, like, there's something off, she's cold and callous, blah. You know, I think they're missing the part that she's crying a lot during the trial, and also during the video jail call, she's crying all the time. So in terms of if that's what they're expecting to see, the grief or what, you know, there's plenty of that. But in terms of like the joy of being a mother or the love for your child, this picture to me expresses that sentiment, like of what it is to be a mother and loving, like this, like of all the testimony, we've heard so much testimony, witness after witness at the beginning of the state's case came in and said, Casey and Caylee had a special relationship. They loved each other. I mean, one after another, just all it was just like beautiful relationship. But, you know, the state would try to fish for something negative. They couldn't even find anything, but nothing says it better than this picture where that is not a smile that you make for a camera. She's not looking at the camera. You know, I think anyone that looks at this is going to see what I mean if they're being honest with themselves, because I know some people would have a hard time doing that. But that's them smiling at each other, and that is like that bond that, you know, I don't know. It's just very genuine.
Her hair was short then, but it's because of Caylee. Caylee was a little bit chunkier, and you can definitely tell that she was a lot younger. Plus, I remember the clothing that she wore, and that her hair was a lot shorter and curlier, and her hair was a lot curlier when it was shorter when she was younger.
Ma'am, when would Caylee's second birthday have been?
August 9th of 2007.
If I may show the witness page 497 of her deposition. Ma'am, if I could direct your attention to lines 1 through 6.
I don't see it.
Object. I don't think there's a question pending, and
Yeah, I thought
she hasn't asked. This witness has not
I
expressed.
remember so this was really interesting because I don't know why. So with Miss Drane-Burdick, she doesn't have much going on up top, like in the brain. So it's entirely possible she just forgot that, oh, I'm supposed to ask a question. Like that's what you do when you're like, you like she just forgets how to do her job, like the rules of evidence, you know, all that. The year or the decade, actually. Every day we've seen her do that. But I remember thinking, wait. Because she asked for the deposition. I'm like, wait, what? Because there was no there was nothing, you can't just ask for that. Like there was no, do you remember saying something different at the time? Or do you think if you take a look at your deposition, would it refresh your memory? And not only that, she didn't say she couldn't remember. Let me back it up because this really matters. Check it out, right? Because we know that the way that you can ask for stuff like that is if they say they don't know the answer or they can't remember.
2007.
If I may show the witness, page 497.
More, sorry.
Definitely tell that she was a lot younger. Plus, I remember the clothing that she wore, and that her hair was a lot shorter and curlier, and her hair was a lot curlier when it was shorter when she was younger.
So the next thing that should happen is, do you remember saying something different? And then you cite the date of the deposition, or, would it help your memory? Those questions, right? But instead,
when would Caylee's second birthday have been?
August 9th of 2007.
Oh, okay. So the last question was, when would her birthday have been? And she answers, I have no reason to think that she got the birthday wrong. So there's literally no question pending, because that last question is actually like, that's a softball, right?
Show the witness, page 497 of her deposition.
For what purpose? That makes no sense.
Ma'am, if I could direct your attention to lines 1 through 6.
I don't see it.
Like, what are you doing? What are you doing? You just
Object. I don't think there's a question pending, and
no question pending.
she hasn't asked. This
There's no
witness has
question
not
pending.
expressed any inability to recollect.
Yeah, not only that. No question.
Your Honor, the witness has given a statement regarding when the picture was taken, and I would like to ask her about a prior statement she made regarding the same issue.
Overrule at this point.
I don't think the statement is inconsistent.
Well, she hadn't asked her a question yet. She's just showing her something.
Ms.
You don't
Anthony, do you
know.
recall
You don't show them the thing and then ask the question. You gotta be kidding me.
making a prior statement in deposition that the photograph was taken around Caylee's second birthday?
She's asking that having already seen this. This is bizarre.
Basis of objection.
It's leading. And this is improper impeachment.
Yep.
No impeachment yet. Objection overruled. You may continue.
I don't understand how this Judge Belvin is doing it, because he said there's no impeachment. Yeah, well, how is there? If you show her the statement first and then ask her about what she remembers or what she remembers the statement being, how is there going to be impeachment? She's already going to know the answer. This is ridiculous. Sorry, guys.
Ma'am, do you recall making a statement that the photograph was taken around Caylee's second birthday?
Yes, I remember making that statement.
Her second birthday being in August of 2007?
Correct, but I don't think that we qualified, months prior or anything.
Okay. What hairstyle has your son Lee had in 2008 and before?
Lee usually keeps his hair short for the most part. We would shave his head, not bald, but shave it down to just, the smallest cutting on the
So stupid.
electric trimmers. And occasionally he would let it grow out, and about every 4 to 6 weeks we cut it. But it would never get more than like an inch long.
Do you know if your son Lee processed his hair in any way?
No, he never has.
Does your mother live in the area?
She lives in Mount Dora.
Do you have knowledge as to whether or not she was ever in the Sunfire?
I believe she was.
When?
We've had that car a long time, and I know that both Lee and Casey had driven the car up to visit my mom, and I know that they've taken her places when they were up there.
All right. Prior to June.
I just, first of all, none of this matters because, again, it's the one hair, and again, the post-mortem banding isn't what it's just banding and just doesn't mean anything. But anyway, the thing is that why is it they just relying on Cindy to describe everybody's hair and no specific dates? This is like when not only can they bring these people in to testify, Lee Anthony will testify again. And I don't think they ask him these questions. They're asking her instead about what his hair was like. And instead of relying on Cindy's memory of other people's hairs at certain months of certain years, there's ways that could be found out, like, say, I don't know, a picture, or asking them themselves, so at least it's coming from them. I just don't. This is so much like the descriptions of the measurements in the backyard, where the only thing that they asked, that Miss Drane-Burdick would ask Cindy to use as a measurement, was how tall is this in relation to you? And she kept talking about things being as tall as her boobs. I mean, it's like, why are we not measuring things? Like, I don't understand. I just don't understand. It's like
of 2008. When was the last time that you recall your mom was in the Sunfire?
I can't recall a specific date, but I know, that she had been in it before. I mean, George and I drove the car as well.
See? There's that again.
So I know a lot of times we would trade out cars. The kids would trade the Sunfire for my 4Runner if they needed a bigger vehicle. So I would drive that car quite a bit. And I know I drove it up to Mount Dora as well.
All right. The question pending is, when was the last time your mother had been in the car prior to June of 2008?
I couldn't say for sure.
So she didn't like that answer because they would so much rather, I mean, it's not the reality. They would rather that car have been only Casey's car, right? For obvious reasons. But as I've mentioned before, it clearly wasn't. And we know that, but that's why she didn't like that answer.
What kind of hair does she have?
She's had it different lengths, but never longer than her shoulder in the last 10 years. It's always been shoulder length or a little shorter.
And what color is her hair?
She's got blonde and a little bit of brown and mostly gray and white.
No way of verifying.
Do you have knowledge as to whether or not any of your brothers have been in the Sunfire?
The only one that could have possibly is my oldest brother, but I don't think he has. But it's possible he could have ridden with either my son or
I don't think he has, but it's possible he could have.
Casey to the store or something.
Okay. And what sort of hairstyle would he have had at that point?
He keeps his hair very short, and his is
Why
blonde.
is she supposed to be the person who remembers everybody's hairstyles for years? This is just so. I don't even have a word. I don't have a word. I don't have a word.
In 2008, were you aware of whether or not there was any duct tape in your home?
Hey, duct tape.
I recall black duct tape that we had, and
Notably, note that they don't call George back to ask him about the duct tape. Anyway.
I think we had blue at one point and possibly silver. I'm not sure. I'm not.
I love this answer. I love this answer because she's been through this entire trial. She knows, everybody knows the duct tape that matters is silver and it has that distinctive brand on it. Everybody knows this. I love how she's like, we had black, we had blue, like as if she's like knows for sure they have this. But then we may have had silver. Like we know you had. I
wanted to really use it. I know I did use the black when we had protesters because I used it to wrap the no trespassing signs.
Was any of the duct tape that was in your home kept anywhere other than the garage?
Not that I'm aware of.
Was any duct tape that was in your home used at a
that kept anywhere other than the garage? So my understanding is that duct tape was either kept in the shed or the garage, and we know that George was very possessive over that shit, right? We've talked about that.
And center that was set up by the family.
Not ours. I know that the Kid Finders Network and George had.
Her answers around this duct tape are. I mean, I can answer my own question. Why didn't they call George? Because it would have been even worse. They should have called him because obviously. Like, imagine if you're on this jury and you're like, George is sitting in the gallery right now, right? And it's like the state is choosing to ask her the questions about his duct tape instead of him. It's a disaster anyway. But like, I don't know what the state was expecting, you know? They see him sitting over there. He's there every day. He's already testified a bunch of times, but if you're going to bring anybody back for this purpose about the duct tape, why are you asking her?
Purchased supplies for the command center, and I know that they did use duct tape to hold up some of the other children's posters and some of Caylee's posters at the command center. But that, I don't believe that came from our house.
Do you recall making a statement that duct tape from your house was used at the command center? Have you ever made a statement?
Sustain, rephrase the question.
Have you ever made a statement that duct tape from your house was used at the command center?
If I did, I don't recall it. I could have.
All right. Remember giving a deposition in this case back in July of 2009?
Yes, ma'am.
At that point, you were placed under oath and you answered questions for a period of time?
Yes, ma'am.
Okay, I was present as well as Mr. Baez.
Yes.
All right, if I may show the witness page 511.
I remember telling you about that episode. Yes.
Okay.
Episode?
What do you recall saying about the duct tape that was in your house?
I remember George telling me about putting a piece of duct tape on the gas can.
Okay.
I never saw him do that, but I remember him telling me that when the gas can came back from the sheriff's department that the little vent cover had been missing and he placed a piece of tape over it.
All right. If I may refer you to 512, line
When George testified about the gas can, he didn't say that.
24.
Like in trial.
If we can get the question before that.
He said that he put the tape on there because of the fact that like it had a hole in it. That's what he said. He didn't say anything about because it came back like that from the sheriff's department.
As well. Do you recall my asking when you explained about the use of the duct tape that was in the home on the gas can? Do you recall my asking where the roll of duct tape was currently at the time of the deposition in July of 2009?
I'd have to look at line 26 to be able to tell you that.
The complete answer.
Can I have the, yeah.
I do appreciate that she is asking for that. I do appreciate that because it's like, that's good for her. Good for her. She could have tried to get just answer.
Sorry.
Good.
All right, can you give her the whole answer? It spans 2 pages.
That's fair.
You might as well go through line 12 on page 513. Read that to yourself and tell me if that refreshes your recollection.
Okay, I'm going to pause it so we can read this. Finish the roll while we were there because we used duct tape to hold certain things up. We had signs. Now, remember, we've heard about this from opening statements as the first we heard it, right? But that apparently George had used that same duct tape, the Hinkle duct tape, to put up a sign at the command center or whatever, a missing flyer. And at that time, Casey's in custody. Okay. So finish the roll while we were there because we used duct tape to hold certain things up. We had signs of children's photographs and stuff, and we started using we started using tape, and then we ended up using zip ties to hold them on. Okay, question. Okay, when was the last time you all believe you used duct tape in association with the command center? Answer. We were ongoing using duct tape at some point. We had black duct tape, so we were using it as long as we had the command center, and we took the command center down after December the 11th. But her remains weren't found until the 12th? Huh. That's interesting. I mean, everything we've heard so far has said the remains are found on the 12th. So, I don't know. Maybe, I don't know. Will they get into that? Is that I don't know. I'm like, should I? Interesting.
I recall that, but again, I recalled using duct tape at the command center, but did not know the origin of the duct tape if it came from our house. I think it was, I didn't specifically say who got the tape, but I know at some point that they did go and purchase duct tape.
May I show the witness QT for identification?
You may.
Ma'am, do you recognize anything in QT for identification?
I reckon.
Okay. This is it. They have a picture. So I wish I could pull up. So here's the thing. I was gonna say, can I pull up? I'll make sure I can do this. I don't think it's really that necessary, but I'll make sure I can have this. I'll make like a composite for the next episode of the duct tape, because what we have is we have the tape on the gas can, right? I'll do a side by side of all the. So we have the tape on the gas can, and then we have the tape, the piece of tape that we've seen isolated that was found with the remains that's still in good condition, and then we have this. And you know, again, I'll do a composite so we can verify, but I don't think there can be any question that it's the same tape, because even though you can't really see the brand name, the fact that it has that circle and that is very distinctive, and I have little doubt that it's the same brand. But again, we'll do a composite for next time. But you know, that is allegedly, you know, the Henkel brand duct tape that no one's ever seen before. And it's like, I think they looked it up at one point. This came in earlier that it was like manufactured in Ohio, which is also where George is from, and like was made in a number of years ago, and it's like really old or whatever. And anyway, it's only found there. That to our knowledge, it's found on that poster. It's found on the gas can, and it's found with the remains.
Nice. Caylee signed her poster for
in custody when this happened.
from the
I've been using it.
Kid Finders missing the children's poster that they made for her.
Okay. Do you know where that poster was?
I'm not sure if it was on the inside of the tent in the middle part or on the one of the outside legs of the tent.
Why is she even asking this question? It doesn't matter at all. It's like she's trying. I feel like with this question, Miss Drane-Burdick is trying to she's trying to distract from the tape. It's like she's showing the poster. She's not asking about the tape, and so she's asking other questions that don't matter.
That tent was moved so many times that I don't recall, and I wasn't there as often as George was, so I'm not sure if that was in the center post or on the outside post on that picture. I can't tell.
And when you're referring to a tent, are you referring to a tent that was used at the command center?
I'm going to back it up because I want to verify that I'm right about that she does not ask her about the tape, because that is something else. And I feel like that's what it is. Let me just back it up just to make sure.
You may.
Ma'am, do you recognize anything in QT for identification?
So that question, when I heard, okay, I'm just going back and thinking, when I remember editing this video, when I heard that question, I was expecting the answer to be yes, the Henkel brand duct tape. That's what I was expecting.
I recognize Caylee signed her poster for from the Kid Finders missing the children's poster that they made for her.
Okay.
I mean, the way she could have answered that is, I recognize the flyer.
Do you know where that poster was?
Yep. Nothing about the tape. I can't. It's like a jet plane could come crashing into that courtroom, and these two people would pretend it's not there. That's what this is like for me.
I'm not sure if it was on the inside of the tent in the middle part or on the one of the outside legs of the tent. That tent was moved so many times that I don't recall, and I wasn't there as often as George was, so I'm not sure if that was in the center post or on the outside post on that picture. I can't tell.
And when you were
she doesn't like that answer, I'll tell you why, because you hear what Cindy said. I wasn't there as much as George was.
referring to a tent, are you referring to a tent that was used at the command center?
Yes, in the beginning we had those little pop-up tents that you purchase at the store, and then at one point Kid Finders had a very large tent donated that had center poles, And that one we used at our last center on Goldenrod up by East Colonial. And I can't tell where this one's taken. I can't tell from this if this is one of those pop-up ones with a large tent.
Do you see an individual in the background?
I see someone, but I don't know who that is.
I don't know why. I don't know what the point of that is. That's George. That's supposed to be George. I don't know. Why are they not talking about the fact that they're not talking about the tape when we all know that's why that picture is there? That's why that picture is there. It just blows my mind.
Ma'am, do you recognize QZ as something that you've been shown before?
Yes.
Okay. And what do you recognize that to be?
Those are pictures of similar canvas items that we had purchased and had at the home.
All right. Do those pictures on that item accurately reflect?
So this is the canvas bag thing. I just want to remind you guys for anyone that missed it. So I think it was in the last episode, the guy whose last name was Murdoch, he was the one who took pictures of the garages and the shed. The thing that was so wild to me was I don't remember if it was the garage or the shed, or probably both. He found the exact same black trash bag as like what Caylee was found in. There were a lot of those, but they weren't just like in a roll like a normal person. They were stowed away in weird places, like inside of other things. And one of the things that was found that way in either the shed or the garage was they found, and we saw a picture of it, that's one of these canvas bags, like what she's about to talk about here, laundry bag thing, like inside of a black trash bag. They found that exact situation. How often does that happen? Okay. They found that. And that's exactly how Caylee's remains were found in that same situation. And they found that. And remember, George Oles had locks on the sheds in the garage. It makes me I don't even know what to do. I just feel like I don't know how this trial is even happening the way it is. I don't understand, again, how as they went along and got more evidence and things, because they didn't have their remains. And then the thing, and I know I've said it before and I feel like a broken record, it's just so shocking because they shouldn't have been so tunnel visioned anyway. But even if they were, when they found those remains, there were the things that were found with the remains were the Henkel brand duct tape, the stone patio pavers, and then you had the canvas laundry bag inside the black trash bag. And all of that shit is George's shit. That's kept in those sheds and those garages, with the exception of, well, I guess the pavers at that point would have also have been inside because they hadn't done they hadn't made those changes yet. So yeah, all of it would have been inside. George's domain, as I've been calling it. At that point, if you've been tunnel visioned before, how do you not pivot then? I just don't. This is not good enough. That's such an understatement. This is not how it's supposed to be. And had she not had this team of defense attorneys, she very well could have been and would have probably been convicted and then executed. Now, and not just her. This is true for so many people. And the thing that makes this so much more devastating is just that there's so many people that just don't have any clue, and they still, the number of people. Casey Anthony's guilt. This is bigger than her. That's my point. This is bigger than her. This is not just about her. This is bigger than her, because this could have been anybody. And this happens to other people. We've seen it with other people. It's just that literally she's just more hated than others. But it's not about her. I mean, this is the system. And this is what you can be up against, even when it's a death penalty case. And it's just not how it should be. That's all.
Items similar to what you had in your home at one time.
The top item, I can't tell the size. It's blurred. I can't see it. The bottom one, It looks like the one that we used in Kaylee's room for her stuffed animals by her bed.
All right. Can you testify that you had items similar to both of those items pictured in your home at one time?
The bottom one with the measurements for sure. The top one I don't know because I can't tell the size. I'm not sure how big it is.
I have QZ for identification. I'm going to show you QZ and Exhibit 29 from your deposition. Tell me if those are identical.
Yes, they appear to be.
Can you see the size designation of the top item, number 2516?
I can on this one, not this one.
All right. On the one that was attached to your deposition as Exhibit 29, can you read it on
the one with the holes in it?
Yes.
Yes.
All right. After reviewing that, does that size that's indicated in that photograph comport with your memory as to the size of an item similar to that one that you had in your home at one time?
Yes, it's similar.
Okay. All right, Mrs. Anthony, the item at the top of the screen, would you describe as cylindrical?
Yes, ma'am.
Did you have an item like that at your home in 2008 or 2007?
Yes, we did.
Okay.
Deleting, though, also, too, right? Is a lot.
Where was it
already
kept?
have that.
At one point, we had it in one of the sheds. I remember storing some.
I don't even know, guys. One of George's sheds? Great.
Kaylee's little plastic balls for a ball pit. And then at some point, I got a laundry bag that had a zipper so the balls wouldn't fall out. And then I put that in the garage.
Why do we don't.
Up over the laundry area on one of the shelves.
Is that the last place that you saw the item on the top, the cylindrical bag?
Yeah, I hadn't looked for that item or seen that item in a very long time since I used that, and it probably had been maybe 8 or 9 months prior to the summer of 2008.
Now, the item at the bottom of the exhibit, which is labeled 2213, did you have an item such as that at your home in 2008?
Yes.
And where was the last place that you saw this item?
We had recently removed it from Kaylee's bedroom. We had stored her stuffed animals in it, but then I found a hanging storage thing for stuffed animals where she could actually see them. It was like a tree. And at that time, we moved her stuffed animals to that and then put that in the garage area.
Do you recall, or did you ever make a statement that the last time that you saw item 2213 or the similar item that was in your home, the last time you saw it was in Kaylee's bedroom?
Yes, I remember stating that because that's where at the time I thought I had remembered seeing it, but I recalled that the reason why I got the other thing was to put that away, and I had forgotten I had switched it out. There's a space between Kaylee.
Honestly, what? This is like, jury doesn't care. The jury doesn't care.
His bed and the wall where we had kept that. And after a while, when I was going into Kaylee's room, I remembered certain things, and I remember taking that one out.
And all of that bullshit is to try to explain why she's changing what she initially thought and why she suddenly remembers that, it's just bullshit. That's all.
So you agree that your memory in July of 2009 was that the last time that you saw this item 2213 or the similar item in your home, it was in Kaylee's bedroom.
I'm sorry, repeat it. I didn't follow you.
Do you recall making a different statement in July of 2009 about the last place that you saw the item in your home that resembled 2213?
Yes, I recall making that statement that I last had seen it in Caylee's bedroom.
Do you recall, or did you make a statement that after the police had executed the search warrant, you believed that the item was no longer in Caylee's bedroom?
Again, that whole period of time, it was very difficult for me, and at that time I thought it was still in her bedroom. But as I stated in a previous questioning with you, that my memory has gotten better
Over
on
time.
certain things. Yes, over time.
Okay. May I publish, since this is already admitted into evidence, Your Honor?
Yeah, because we all know memory improves over time, right?
The two bags that we were just referring to, the white.
By the way, guys, you can also see you can see some of, I mean, there's a bunch stowed away, like I said, but if you look up next to that cooler, you can see there's black trash bag. There's like, or there's at least one. You can see the yellow handles. But then they found others that were stored weirdly. Like there's like a suitcase and that had one inside of it. Actually, I think you can see the suitcase underneath those laundry hamper things. It's just weird.
Bags that you kept stuffed animals in at one point, and then
like if I could question George and get him on the stand, I would want to ask him, like, why did you like store black trash bags in weird places? Like that would be maybe like, let's just get that out of the way, right? Like, why are you so weird about your trash bags?
plastic balls that you made reference to. Were they stored? Were either one of them stored in this location in the garage?
Yes.
Can you circle and let the members of the jury know where they were? Okay. What is that they are being stored inside of?
We would put anything that would collect dust, something that we couldn't wipe off, like fabric, or we had like the cat carrier and dog carriers up there. We would store the items in a trash bag.
Ma'am, do you recognize the close-up of that portion of the garage in 291 in evidence?
Yes.
Okay. Is the type of container that you would have those white bags in consistent with the container shown, the black plastic bags in 291?
Yes, it would be in either one of them. I wouldn't know which one it would have been in.
After the execution of the search warrant on December.
Again, why they're asking her, not George, is, I mean, I know why, because they know it's a disaster. But again, that does not bode well. That doesn't look like you're doing the right thing as a prosecutor, because what they're asking Cindy about how George was storing his shit in the sheds, right? Anyway, her explanation, they're asking her to try to explain basically why they found that canvas bag inside a trash bag. Because again, Casey was in custody. That was not found until well into December when they did the search. After December 12th is when they did the search of the sheds and the garage, the rest of the house, and they found all that other weird shit I kept referencing. And again, it's stuff that all points to George. And it can't point to Casey. So, and lo and behold, in his stupid shed, they got, a laundry bag and a trash bag in the same fashion. And so they're having her try to explain why. And that's her explanation, is that it keeps it from getting dust. The other thing I will say is this. So that suitcase, when they found one of the black trash bags inside of a suitcase, so what's that about then? Are you saying that you want this? Because she just said, we don't want fabric. You don't. So the suitcase, you're fine with the suitcase getting dusty. But even weirder, you're saying you want to protect the trash bag from getting dust on it? Like if what she's saying is going to be consistent, which even though it doesn't make any sense, but some people are cuckoo, right? Even if, so let's say it's true, then you would have found something like that suitcase also inside of a trash bag. And instead you have a trash bag inside of a suitcase. And you also had another one. We saw all this with Mr. Murdoch on the stand. You had one of those black trash bags inside of a large trash can, not with trash in it, just the bag. So it's not just there's things in the trash bags. There's also the trash bags that are empty in other things. So just wanted to point that out.
November 11th of 2008. Did you see either one of those items again?
No.
Do you see the item that you were referring to that used to be kept in the cylindrical
Yes.
bag?
Yes.
Can you circle that and point it out for the jury? Okay, what is inside of that?
Little plastic balls that you'd find in a ball pit.
Mrs. Anthony, do you recognize 13 in evidence to be a photograph of your daughter and granddaughter?
Yes.
The shirt, and if we could zoom in on Caylee, please. Do you recognize the shirt that Caylee is wearing?
The first time I had ever seen that shirt was during my deposition.
Did you do the laundry at the home?
Yes. Most of the time. George and Casey did it once in a while too.
Would it be fair to say that you've never seen that shirt at your house?
I don't ever remember seeing that shirt.
And you never saw the picture of Caylee in the shirt until July of 2009?
No.
Thank you, Mrs. Anthony. I don't have any other questions of the witness, Your Honor.
Okay, be a good time to take our mid-afternoon recess. We'll be in recess to 3 o'clock.
I think this is when it comes up about Exhibit 313.
Members of the jury, please do not discuss this case
This is
among
insane.
yourselves.
This is insane.
And please remember all of my previous admonitions. We have a question from the jury.
Oh, boy.
Can we see Exhibit 313? We did not see it after it was introduced. I think 313 may have been that heart-shaped item.
Go figure, right? Fuck me.
You may
I
want to
just-
take out the overhead document.
Judge Belvin, it has a name and its name is Elmo. It's the Elmo.
No.
We're going to get to see it.
They asked
We're going to get to see it. We're going to get to see it.
for Exhibit
And
3.
the question will be, does this match? The whole point of this is this the same sticker as all the stickers? Remember how many stickers they showed us from Casey's room and whatever? And remember how they looked? And again, they're different shapes, but remember that they had that one sticker they especially seemed to like. It was on the envelope. Then they had others. They were all normal stickers, right? Flat, like a stamp. Sorry. We're going to get to see this. And the question really becomes, I mean, it doesn't really matter because there's no proof that it existed anyway. It was just this, someone's imagination. They saw the outline, or, but there was a sticker found elsewhere, right? Not on the duct tape. Okay. And the question becomes, is this a sticker that looks like the stickers that they found at the house, or is this a different sticker?
313.
So we'll get to see it.
The other question, I can't answer them now. It has to do with deliberations. They want to know during deliberations, will we get a type list of all the exhibits? So what they want is an exhibit list which we can provide them.
Did you say which we cannot provide to them?
I say which we can.
Okay.
Sorry, y'all. StreamYard again. Hold on.
So how do y'all want to handle the request to see 313?
I don't have any objection if they want to pass it around. I don't have gloves available for them at this juncture.
Look at her trying to make excuses. You know they can get
Well,
gloves.
they asked specifically for Exhibit 313. So pull out the document camera.
The Elmo. The fact that she says that, oh, I don't have gloves. Here's the thing. The state wants to be able to talk about this item, this heart, without having to show it to the jury. And why? Because they want to try to trick, sorry, that's too nice. They want to lie to the jury and try to, and so that the jury will assume it's the same sticker. They want the jury to assume that this sticker is the same stickers that they found in Casey's room. without showing them this evidence. This to me is beyond. Because if this piece of evidence is supposed to be good enough to convict her, it should be good enough to also be exculpatory if in fact it doesn't match. And the fact that they tried to hide it from the jury, I can't even tell you how upset this makes me, because how dare you try to lie to the jury? Really? How dare you try to lie to the jury? And what does that even say? I mean, the big picture there is huge, right? Like, what is this? Like, where are we living? Like, this seems like some, dystopian situation, or like, I don't know, Soviet Union, like, it's bizarre that this is what we're dealing with. And that, thank God, the jury paid attention, and they heard it get introduced, and they realized they paid attention to the exhibit number and realized they never saw it. Incredible. And the fact that they have to ask the state to see it, just. Is it playing? Come on.
And put it on that so they can see it. Once they see that, then you can begin your cross-examination of Miss Anthony. Well, we have, Madam Clerk, make sure we have enough gloves to send back into the jury room. More than 12 pair, because they will probably discard them and use them, so they need a box.
It's in a form that it can just be passed to them.
Problem I have, Judge, is that
yes, sir.
Is through the handling of the evidence, the sticker has now fallen off of the cardboard.
Right.
And it was stuck to the cardboard, and I'd like it to be shown in the condition of which it was when it was collected, which I think would be the fair and more accurate representation of the action.
I'm just going to remind everybody what's going on here. So remember from earlier, we learned about this. Actually, it was the first time that Jennifer Welch testified. Oh, glad you're back. This is a good part to join, because this is the part with the sticker. If you haven't seen this before, prepare to just lose it, because I mean, I've been ranting for anyone who's just joining. So this cardboard, okay, remember from like earlier on when Jennifer Welch testified the first time, and Flash Fan's back too. Yay! Glad you guys are here. So there was a time where Mystery and Burdick asked her and said, "What is that?" And she said, "Oh, it's a sign for a kindergarten or something." And I didn't really know what they were talking about at the time, but we saw more pictures of it later. So what it was because there was a little school over there or whatever. There was like a sign that was related to the school or the daycare or something. And it was like cardboard, right? And it was like just in the area where the remains were found. But it was close to that area. And that sign is the kind of the decrepit cardboard situation. Now, just again, to remind you guys that if there was the outline of a heart, because it was like, again, there's no picture of it. There's no evidence. It's just the whole business about the camera. Anyway, if it ever existed, right? The testimony of where that was seen was in between those two pieces of duct tape that were 7 feet away from the remains. You know what that also means? Those two pieces of duct tape that were stuck together were also near where this sign was found with the cardboard. Okay? So keep that in mind as we take a look and see.
Item.
Yeah, I was here too. Yay!
State comments.
Yay!
Yeah, y'all are evidence is in the condition, as I understand it, that it was. There's no testimony that it was stuck to that cardboard. It was photographed on a.
She's completely fucking lying. It was stuck together. This is insanity.
Piece of cardboard. If Mr. Baez wishes to call the witness back who collected the item, we have no objection to that person clarifying at some point in time whether or not this was actually stuck to the item that it's with. But there was a photograph that was taken. I have no objection to that, since I believe That may not be in evidence, but
we haven't gotten to whatever that is yet. I don't know if you're referencing Roy Kronk, but the thing that is crazy is that this whole time I kept expecting the state to call Roy Kronk because he found the remains, and in literally every trial of all time ever, the person who finds anything is called. I don't care if they're a lay witness and they're walking and they see a shoe somewhere and they find this shoe and they don't know what the shoe means, that person comes in and testifies. If you're law enforcement and you see whenever evidence that is related to a crime scene is found by law enforcement or a layperson, whatever the case is, it's like that person testifies. This is the only exception, apart from someone being dead, where Roy Kronk is alive. He found Caylee's remains. He called 911, and the state does not call him to testify. I don't even know. I didn't even think that was legal, like, or allowed. I didn't think that was even allowed. So, but yeah, he has not. But I mean, I know that he does testify at some point, so I think he might be called by the defense. Wouldn't surprise me. Supposed to be the state's key witness, and they're too afraid to call him.
obviously at the appropriate time, I have no objection to them reviewing that.
Be the better solution.
But this is not in evidence yet.
We can stipulate to that, this item being in evidence. I don't have an issue with that.
There's specific case law that provides that when a jury asks.
So for anyone who missed it, Uncivil Law joined us the other day. I died. I'm actually a ghost of myself because I died. So Uncivil Law was here, and he was in the chat, and he stayed for a while. I don't think he hasn't come back yet, but I will say this much. You have to be just like in every chat, right? You have to be a subscriber to be in the chat. So, assuming he has notifications turned on, maybe we'll see him again. I would love that. I don't even have the words, but yes, for anyone who'd missed that, Uncivil Law, and actually I did timestamp it. So if anyone wants to watch with live chat replay, you can see where he comes in. And it's on it was related to the Shanna Gardner case. It was not yesterday's episode, but the day before. So yeah. The conscious machine, if we start with the list of things about George that are suspicious, we will be here until this time next year. And I don't think we will even be complete with that list, to be honest. I actually have a document. Maybe I'll pull this up at some point when it's a good document. I have a document that I've been making called The Case Against George, and it's based off of only the evidence from the state's evidence. Okay. There was so much evidence submitted by the state that they thought was evidence against Casey that was actually evidence against George. So without even using what the defense suggests, just going off of the state's theory, their theory that they think points to Casey, there was so much I had to make a document for the case against George, and so you can compare them, because there's more against George. Just, that's just, there you go. Yeah, it was the Friday steering. No, dude, this is the whole point, is to interact, and I'm happy to do it for sure. Yeah, no, I mean, it's not distracting at all. I'm only saying, I really am saying it. Feel free to make all the comments you want. I guess kind of what I meant was that I get so upset about this. And for those of you guys who were gone and came back, I've been ranting, and you guys have missed my ranting about the same topic, by the way. I've been ranting about George, and I've been ranting about the prosecution, and I've been ranting about justice and the big picture. And this is bigger than Casey and all kinds of things. Okay. I've been ranting. And so it makes me so upset that I have to, for my own sake, because I could go on and on and on and on and on. And I'm trying to be reasonable. So yeah, but you guys are more than welcome. I'm literally just trying to put limitations on myself so that I don't just turn into a crazy person ranting about George Anthony all the time, and this particular prosecution. I mean, and also for anyone that missed it, I also had a whole little thing where I was saying that I think this might be the weakest prosecution case of any trial I've seen, potentially. So.
A specific question, you answer that question. What they specifically asked for, can we see Exhibit 313?
Everything
we
you guys
did not see it after it was introduced. Now, if y'all want to introduce something.
Okay, that is from the jury saying that they did not see Exhibit 313 after it was introduced. Again, this is where I'm like, okay, rein it in, because I could go on about how these prosecutors should be in jail for I don't have words. Okay.
something else and show it to them subsequent to that, then that's fine. But they will see 313. That's what they asked for.
I think we're going to reach a mutual agreement here, Judge.
Do you want it on the document camera?
Well, you know what? Put it on the document camera, and if they want to see it on their hands, they can see it on their hands. Later on, you can pass it to them, but that wasn't what they asked.
I would ask if it comes to the point where they're requesting that it be handed to them, that we have an instruction that at the time of collection, it was stuck to a piece of cardboard.
Is there record testimony that it was stuck to a piece of cardboard?
I believe that in the collection
That's the sign.
of this, it does say heart-shaped sticker stuck to a piece of
It
cardboard.
did. And remember, that was when I said she was lying.
Yes.
She is lying. Because I remember when that happened in the testimony, I noticed it and I was like, huh. I even commented on it because I was like, wasn't there supposed to be a heart or something stuck to duct tape? And that was before we'd heard about the rest of this with the duct tape. This is from a while ago. And I was like, so I commented on it. So she is lying. Ugh. Dude. First she's like, y'all. First she's like, we're not gonna publish this to the jury. We're gonna sneakadoodle it in after the fact, after the witness is off the stand. We're gonna sneakadoodle this in and not publish it to the jury. Then when the jury sends a note, her first response is, well, we don't have enough gloves for them all. Then now she's at, well, the testimony was that they were separate. No, the testimony was that they were stuck together. What else is she going to do? How can she get any worse? I don't even know.
Is there record testimony that says that?
Yeah, well,
I believe that the record testimony is that it's a piece of cardboard material, and then there's a symbol for what is with pink raised heart-shaped material attached.
Okay. Who was the witness that predicated the exhibit?
Robin Maynard.
Okay.
That was last Saturday.
Okay. When we take a break, we will have Ms. Peters, who covered that day, pull her testimony and see what the record says.
It's really nice though when
Let's see. You got to turn it on.
they prove her wrong. It's really nice.
You got it on now.
Oh man, I know. Okay. So wait for it.
Why don't we do this?
They're gonna get the lighting
Let's
better.
bring the
Okay, so we'll see it better when the jury comes in. The way that this moment when we see it in here up shortly, a better picture of this. When I was going through and editing this video, I can't. Let me explain it when we get
jury in. We can let them see it on the document camera, and then I can inquire as to whether or not they want to pass it among themselves to take a look at it. Okay?
Yes, sir.
and will we be having argument outside of the presence of the jury?
Argument about what?
Well, the problem is, Judge, is that we have an item of evidence that is altered as it is being shown to the jury that was not, that is not how it was when it was collected. So I think in fairness, they must be made aware that this item was stuck to this piece of cardboard.
Oh my God,
They
I'm
wouldn't
sorry. Their Elmo Has a Bed
have included the cardboard if it wasn't stuck to it. I mean,
right.
That may be true, Mr. Baez.
It was stuck to the cardboard, the sign.
Just a second. Let's go off the record. Call Ms. Peters up, ask her to pull up that testimony and find it.
I'm going to point out the Elmo
And
here.
then we'll see whether or not it was testified to that, because if it was no testimony,
It's so funny because as I was editing this and hearing this, I'm like, look, I already know how is it that I'm not in this trial? I've only ever watched this once as we're doing it, right? But like as I'm editing the video, that's the first time I'm hearing this, and I'm like, hey, how is it that no one else remembers? Like they seem to genuinely not remember. I'm like, I remember the testimony. They were stuck together. I already know where this is going. Like I don't need the court reporter.
then all we have are assumptions. So we'll go off the record now. Okay, folks, this is what I'm proposing to do. I would tell them that we would get that exhibit and give them opportunity to look at it, but we will continue with the cross-examination of Ms. Anthony, okay? By that time, we should have an answer to Mr. Baez's.
Right. Okay, that's right. I forgot they do it this way. So they go ahead and do Cindy Cross, and then because they're waiting on the court reporter to find the transcript thing. And then it's the moment of truth. So we have to wait a little bit longer for the moment of truth. But I'm going to back it up just for a second to show you guys this with the Elmo. Because the Elmo has a special Betty By. You're probably like, what are you talking about? Here, hold on. There you go. There you can see it perfectly right there. So see the Elmo? They have the fancy modern Elmo. See how it's got a little Betty By? Because when the Elmo's gets time for bedtime, they can fold the Elmo over and then they tuck him in and then they close that drawer up and then he goes to sleep. And if you're wondering, like, why are you talking about the Elmo like that? Because the Elmo has become like a thing with every trial, and they all have their own different Elmos. And I love it whenever they call it the Elmo. And if you guys have watched me before, I'm always like, yay, Elmo! But the other thing is this. Where is it? Let me find this. So then there was, this was during one of my coverage of Ezra McCandless. And I was like, because, I also love Nightbot, right? Obviously. I'm going to show you guys something here. I'm pulling it up. And I was like, oh my God. And then I had a moment where I was like, what if Nightbot and Elmo like met in real life and they were like BFF friends? Like they were like BFF friends. So hold on, let me pull this up real quick. Hang on. Here we go. There we go. Let me zoom in. So this is what I made. Elmo and Nightbot forever. Like I tried to make it like, and well, then we had a whole discussion about who wrote it. Did Nightbot write it or did the Elmo write it? I can't remember who I decided. I might have decided, what did we decide? So you've got the factors to consider here, because Nightbot has the tiny hands but a big heart. So the tiny hands, right? So did he write it with his hands? But then, of course, the Elmo is also known as, at least Judge Belvin calls Mr. Elmo. They calls him the document reader. So with that in mind, well, maybe the writing would be, I don't know. What do you guys think? Did Elmo write it or did Nightbot write it? But that's what I made, and that is the actual Elmo. That's the actual Elmo from the Ezra McCandless trial. That is the actual legit Elmo, and that is the courtroom there in Wisconsin for that trial. Nightbot is the guy with Nightbot's there on the right hand side. That's the Nightbot. Nightbot is a Nightbot. Oh my God! Hold on. You don't know I don't know even how to answer this is the first time I've ever been asked like what's Nightbot. I don't even know how to answer that. I don't know how one explains Nightbot. Nightbot has little hands but a big heart. All the commands for Nightbot are found here. Here, Nightbot's doing things in the chat. So there's Nightbot. Nightbot is so cute. Yay! Oh, look at how cute that is. That's cute. That's super cute. So that's Nightbot. But that specifically is DJ Nightbot. That's a long story. Anyway, it's not, well, it's similar. It's different, but similar. I know. In other words, yes, it does a similar function, but Nightbot is the OG. And what's really funny is like Runkle, whenever, like during Karen Reed and stuff, like whenever you'd have people that were like, I don't know, pushing it in terms of things where you might need to kick them out or whatever. Well, not just Runkle, other people had to do this too, where they're like in preparation for Karen Reed. I remember hearing other law tubers talk about how they were going to have to go through and like edit their Nightbot settings to make it more restrictive and to kick people out for stuff. And that at that point in time, Runkle started calling Nightbot Fightbot. Like Fightbot is like when like he has to be like doing his job, like kicking people out or whatever. And then he's like back to Nightbot. So it's just funny. Every now and again, you'll hear Fightbot if he has to get cranky with people. Like I think of him like a little robot bouncer, you know, but really most of the time he just wants to give hugs. That's it. Okay, so now let's get back to this. Oh yeah, so what we were doing is we were talking about how that's their Elmo. So what a big difference, right? That's like a super modern Elmo, which is funny because this trial was in 2011 and the Ezra and Canlis trial was in 2022, and they have the really outdated Elmo, and it's 11 years difference. That's crazy to think about, isn't it? Wow. But anyway, this Elmo has a bed, and he can go and snuggle up, and that's so cute. And I love you, Elmo. Okay, so now let's go to where we were, though. That's why I wanted to back it up, though, just so I could celebrate the Elmo because I love Elmo so much. So we're going to get into Cindy's cross exam.
Is that acceptable to both sides? All right. Let's return. Let's have Miss Anthony back on the witness stand. All right, let's return the jury. All right, state recognized presence of jury.
Yes, Your Honor.
Defense.
Yes, sir, we do.
Okay, Mr. Baez, you may proceed with your cross-examination.
Thank you, Your Honor. May it please the court. Good afternoon, Mrs. Anthony. I want to
Say anything back.
try and take things back into perspective if I can.
She's shaking her head no.
Your granddaughter, Caylee, was found on December 11th, 2008, correct?
Yes.
Okay. So here, I wanted to make sure I make a correction. So earlier I was confused. I was like, wait, she was found on December 12th. What it must be is that she was found on December 11th. But I guess where we kept hearing December 12th would have been when like this CSI people were out there at the crime scene. So it must have been that it took them a day to get out there. I find that hard to believe, but that's what it must be, because I know that I have written down December 12th. But they're saying she's found December 11th. So I don't know. Is it because of Roy Kronk? I don't know. Maybe they just came the next day. Something like that.
And on December 11th, 2008, the police executed a search warrant of your home.
Yes, I found out after that, yes.
And you weren't home.
No.
In fact, you didn't go home for a couple days later.
We went home the next day together.
The point's going to be here, I can already see where this is going to go, is that if they didn't find that roll of Hinkle duct tape, George got rid of it before they searched the house.
Our dogs.
But it was a couple days before you actually went back to the house, correct?
Yes.
Okay. And after that, you were home for a few days and you got to see what the police had done in your absence.
Yes.
And then on December 20th, the police came back and executed a second search warrant of your home.
Yes.
And during that second execution of the search warrant, well, actually, let me backtrack for a moment. When you got home, you saw a copy of the search warrant there and the items that they had confiscated from your home, correct?
No.
Okay. Did they give them to your attorney at the time?
I'm not sure at what point we got them. It took us a while to get the copy of the items.
Are you talking about Elmo from Sesame Street or Elmo like the Elmo?
The 20th, when the police arrived at your home, it was a difficult time for you.
Absolutely.
And the rest of your family as well.
Yes.
You know what's so interesting? That of all the millions of times that Cindy has testified, you know who has never said something like that to her? Like in an empathetic way, like it was a difficult time for you and for the rest of your family. You know who has never said that? Is the prosecution. But you know who has said it every time? Is Mr. Baez. Every time she's testified, he has been empathetic towards her. And it's interesting because you can actually tell she's like nervous. She'll be nervous starting out on cross. This happens every time she testifies. She'll be like nervous starting out on cross, but you'll notice that she actually ends up way more comfortable on cross versus on direct. She's like, I don't understand the question. She's like fidgeting. There's a lot of like obvious signs in her behavior. But you can tell that she ends up feeling oftentimes more at ease on cross.
And there was somewhat of a confrontation when the police arrived. Isn't that correct?
Oh boy.
Relevancy?
It relates to the items listed. It relates to the issues raised during direct examination. I can tie it in fairly quickly, Judge.
Overall, for now.
For now.
Fair to say it was somewhat of a confrontational moment.
Yes.
Okay. And in fact, George had to be taken to the back area, correct?
Of course he did. That does not surprise me. You know what? George wanted to be fight bot for a day. That's what it is.
I'm going to tie it in within a matter of 3 questions, Judge.
Sustain this to the last question. Next question.
Mrs. Anthony, at that point, did you tell law enforcement that that's when you told them there was a missing blanket?
I don't know when I told him about a blanket.
Okay. Are you aware that that's a statement you made to them at that time on December 20th?
Not until you're telling me right now.
Okay. Are you aware that on the search warrant of December 11th, there was mentioning on the actual warrant for Winnie the Pooh blankets?
Your Honor, I'm going to object. He's asking questions based on the items not in evidence.
These are direct lines of questionings by Miss Drane-Burdick.
Approach. You may proceed.
Thank you, sir. Mrs. Anthony, when you came back home a couple days after December 11th of 2008, your house was a mess.
Yes.
And
That happens
the police had basically turned the house upside down.
And they don't put it
Yes.
back together. They don't do it.
And they didn't put anything back.
Yeah. Yep.
And
Yep, Purdue.
they took items, did they not?
Yes.
And included in the items was Caylee's bedding set, correct?
Yes, at some point her bedding set was taken.
So you were aware when you came back that they were interested in her bedding material?
I wasn't sure what they were interested in. They opened just about every drawer and looked under every little thing.
Okay. The Ms. Drane-Burdick may I publish this to the witness, Judge?
That's deposition.
Yes, this is testimony that she was shown during her direct examination. I want to ask her some questions about it.
Go ahead.
Okay. Can you see that, Mrs. Anthony?
Yes.
Okay. On line, I'd like for you to read for a moment lines 10 through 15.
Yes.
I'm pausing it to read it. Question. Okay, did Casey remove any duct tape from the house when she was out of jail for that period of time, the 2 periods of time? Answer. As far as I remember, no, because I think we only had 1 roll of duct tape and George was using that. So remember, I pointed it out at the very beginning of her testimony under direct earlier, when she was asked, did you guys ever have any duct tape? And the answer was just, she goes, yeah, I think we had I'm doing my impression of her. I think we had a blue roll, we had a black roll, and, we might have had a silver roll, but I don't really remember because I didn't really use the duct tape all that often. And then she goes on and it's just, yeah. When we all know they had the Hinkle duct tape, right? But the thing that's important to me here is fuck the colors, right? She's saying they only had 1 roll and there's no blue duct tape, black duct tape found anywhere on anything in the home or anything at all. There's the only duct tape that is seen anywhere in anything that's in evidence is that 1 roll of, it's the Hinkle duct tape. Okay. And because of the fact that here she's saying he only had 1 roll, it has to be that right there is really, really good evidence for the defense. They only had 1 roll of duct tape. And by the way, also George was using that. There you go. Remember, we just saw that flyer with the duct tape, the Hinkle duct tape on it. George was using that. Yeah, he was using it at the command post. I mean, this basically contradicts everything she tried to say on direct. That was such a mess. Ugh. Sorry.
During direct examination, when you were asked along this lines of questioning, what exactly was the question asked to you during this?
I'm going to object. It's the lawyer who has to ask the question. This is improper. There's no impeachment going on with this question and answer.
I'm not impeaching her. I'm asking her questions that she was asked during direct examination. She was shown this item and discussed it.
They have to go here with this. He's got to
The
let
page that he's referring to is hearsay, and we would object on that basis.
The page
From the deposition.
hearsay in terms of who was the person who was being questioned.
Right? It's an out-of-court statement. If he wants to ask her it independent of it rather than reading from a hearsay document.
What is wrong with her? It's a deposition. A deposition is literally not an out-of-court statement. You're under oath for deposition, so that counts as an in-court. A deposition is by definition an in-court statement. Even though if you're not in court, that's how they work. That's why depositions are taken. They are equal to testimony from the witness stand. They are not hearsay.
That's one thing, but it would have to be impeaching information.
This is what I'm saying.
He can ask the form of the question and the leading question, so you can read the question and give an answer. You're on cross-examination. Go ahead.
Mrs. Anthony, were you asked by Ms. Drane-Burdick if Casey removed any duct tape from the house when she was out of jail for the period of time, the 2 periods of time? Were you asked that question?
I don't remember, but if it's in my deposition, then I must have been asked that question.
Does that refresh your recollection that you were asked that question?
Good answer,
You see that there?
No, I don't remember talking about, I don't remember them asking me if Casey removed any duct tape, but if it's in there, then I had a 2-day deposition, so I don't remember every single thing that she asked me.
I understand. It's a couple years later.
And look at how this is another example just to what Flash Fan is saying about Mr. Byes being so kind. This is a great example of that.
You respond as far
because he could be I would want to rip her apart. Instead, he's like, I understand it's hard because it was, you had a lot of depositions, blah, blah. He must be empathizing with how awkward this is for her, right? Because the odd thing is you don't usually have parents of, like that want their daughter to get the death penalty. Because, what you see with her and with George and with, like, you can tell that they, like, are, like when you have witnesses that are kind of wanting to say an answer that supports one theory of the case or the other, like oftentimes people, you see that they want to give answers that are good for the state, which is essentially giving answers that are going to lead to the Casey being executed potentially, right? So there's that. But anyway, so in other words, she doesn't want to admit that she said this, but it's in her deposition. So she's like, well, I don't really know because I had a lot of deposition. And instead of like calling out her bullshit, he's like, yeah, I totally understand. And I agree, because the thing is I love it when defense attorneys come in swinging and they're like, fired up. But you know what? I had not seen an example of anybody like this until Mr. Baez. And I like this even better. And I think this is more successful, to be honest. Because we have seen so many witnesses in this trial come in that end up smiling and laughing. I mean, every single witness, he's turned into a witness for the defense. He puts them all at ease. Even, I don't know. I've never seen an attorney with a demeanor like this. And it's interesting because it's not like, it goes without saying, it's not a pushover. It's not like that. What he shows is like, you can be totally in control. You can be assertive. You can be like, he's getting the job done and he's very effective, but I feel like he's just so easygoing, right? It's the same thing even when he's dealing with the judge and with all this other stuff. Like, he never gets worked up. And I've pointed it out so many times because it blows my mind when the shit the prosecution's pulling and he just, lets it, roll, like, what do they say? Roll off your back or whatever the saying is. Anyway, it's incredible to watch. So yeah.
As far as I remember, no, because I think we only had one roll of duct tape.
For impeachment, the witness said she did not remember if he wanted to try to refresh the recollection. Right? But at this juncture, she says she does not remember the question.
So I object to counsel reading it as improper impeachment.
Mr. Baez?
This testimony was elicited by, we're in a little bit of a unique situation because Miss Drane-Burdick had questioned her
Go
about
ahead and
this.
establish the predicate for past recollection recorded.
Sure. If I can have just a moment, Judge. May I approach the witness, Your Honor?
You may.
Do you recall giving a deposition in this case, ma'am?
Yes.
And if you could look at the first page to give the date. No, the first, hold on. Yeah, the very front.
July 29th, 2009.
Okay. And were you placed under oath at that time?
Yes.
Okay. And can you read that 10 through 15, lines 10 through 15?
10 is question, okay, did Case remove any duct tape from the house when she was out of jail?
Wait, slow down. She can't hear you, Miss.
She's trying to get it over with.
Question was, okay, did Casey remove any duct tape from the house when she was out of jail for that period of time?
Sorry. I don't know if you guys can hear that probably. I was just picking up my coffee and I have it in like a, one of those, what do you call it? Like a, oh my God, a tumbler, like where you can take it with you to go, like, a washable, like EDB has a bunch of really cute ones. Anyway, I have it in there, and then I had it on a coaster, and somehow the coaster got stuck to it. And when I picked it up, the coaster hit my hardwood floor. That was what that was, if you heard it.
2 periods of time.
Can you give the answer?
As far as I remember, no, because I think we only had 1 roll of duct tape, and George was using that.
So it was your.
Can you imagine being George Anthony sitting in that gallery? Sorry, let me rephrase that. Can you imagine being anybody in that room, including the jury, and with George Anthony sitting in the gallery? And can you imagine not looking over there like, why are you, anyway, you guys know.
Understanding when you took the deposition that you only had 1 roll of duct tape, correct?
Yes, during that time period when Casey was out of jail, we had a black roll of duct tape, and we were using it all the time to repair our signs that the protesters would knock down in front of our house. Okay. So yes.
And your understanding was that the only one using that 1 roll of duct tape was George.
That was her trying to fix that by saying, yes, we did have only 1 roll of duct tape, but it was black. Good luck.
Well, I would be using it too for those signs.
The answer you gave in the deposition was that the only person using that 1 roll of duct tape was George Anthony, correct?
Probably. Again, it's the context of the questioning.
And the thing is that because again, we saw the sign, we saw the tape on the sign. She can talk about black duct tape all she wants. The tape on the sign is silver. There's no question about, it's just, it's sad really. Flashline is saying you should look into the Aaron Hernandez case. So I know that case. I don't think that was televised. I know that case though. I feel like it wasn't televised, but if it was, I'll cover anything that Baez is involved in for sure. That's a given at this point for sure. As long as he knows wherever we can see what he's doing, or even if it's I guess like court filings, pleadings, like I guess we could do that even if it's not televised. Well, it depends on the state. Some states are hard to get stuff, but yeah.
I understand, ma'am. Now, I'd like to talk about the photograph.
Is it only on Law and Crime? Because here's the trouble with that. They are what's the right word? They are like really hardcore about the copywriting. Like, they have, they have their huge logo or whatever. They're as far as like all the stuff that I've ever done on YouTube, this is the only issue I've ever had. And it's with them, like where they will give you a copyright strike. And it's so funny. I can tell you exactly what it was, because when I was covering one of the times, I don't remember one of the times I was covering Duct, we heard, for whatever reason, there was like whatever feed that was usually going like messed up, but the Law and Crime feed didn't. So I only needed to like insert the Law and Crime. It was for like less than 2 seconds. It was like really brief, but it was just because otherwise we missed that word or whatever it was in the testimony. It was so brief, right? And that was enough to where I got like, and it wasn't like the type where it takes down your channel or whatever, but it's like the type where like, I don't really know how it works. This is the only time it's ever happened. So I don't really know how it works. I just know that there's like, you get so many, I don't know. But the thing is like, so they are like, in other words, that's their attitude. Like Court TV does not have that. Like they have it set so that they want to get people in trouble, even if it's like a 2-second thing, you know what I mean? Even though it's repurposing, it's not like it was with people talking, right? It was just literally the same court feed that everybody else has. Anyway, because that's really kind of not cool, you know? It's like, it's trial watching. It's not like I'm trying to play Jesse Weber commenting on something, right? It's just the trial. So that's really, you know, you would hope for better considering. Trial watchers know how that goes. It's public, you know? But anyway, so that's why you'll notice that none of the other law tubers use law and crimes feeds. The only exception to that is Peter Tragos, but I can tell you exactly what he does and why. If you notice, Peter Trago uses law and crime. I don't know why, but he does. But he positions, if you ever pay attention, he positions his camera box from StreamYard. He makes the size of it and he positions it so that it covers the logo. But like you can usually still see the outline of like the navy blue box, but you can't see the lettering. And that's how he gets around any problems. But that's why everyone else doesn't use it. So. Uh-oh, hold on. Am I having StreamYard? Can you guys hear me? Hopefully you can hear me. StreamYard. Okay. Oh, what is it doing? Okay.
May I show the witness, Your Honor, states evidence 314 and publish for the jury as well.
You may.
Okay, cool.
Can you see that photograph, Mrs. Anthony?
Yeah. If you find it somewhere else,
Ladies and gentlemen of the
I mean,
jury.
I can look for it somewhere else. As long as it's
Prior to me.
as long as it's not a law and crime. I mean, because it's hard to get around that logo unless you really, you can do what Peter does, right? But the reason I don't do that is because then you lose such a big portion of the actual video that you're watching, right? That's why I prefer to have it full screen where you get to see everything versus having a background or that's why I don't use the camera, right? Because you guys don't need to see me, right? Whether it's watching the trial or reading court documents, either way, what's important for you guys to see is what we're talking about, right? So, that's the thing. So anyway, the only way around that with the logo is to kind of do what Peter does and cover it up. But in order to do it, you have to cover up such a huge portion that, for me, I just, I feel like it's more important that you can see the witnesses and see the exhibits and see the documents and all that. So if it's on any other feed, though, it should be fine.
Getting into the photograph, Mrs. Anthony, I'd like to ask you, how long have you owned the Pontiac Song?
This is the picture I commented on saying, like, boy, talk about like this. If a picture can say 1,000 words, like this picture is the epitome of the love between a mother and a daughter. Like when you just look at their faces,
I think since 2000.
Okay. So you had owned it for 8 years in total, correct? Prior to it being confiscated in this case.
Yes.
And your hair length has changed numerous times throughout that time period.
Yes.
And so has that of Casey.
Yes.
And so has that of Caylee.
Yes.
And I know we touched on your mother as well, having access to the car, but I presume her hair has changed as well.
Her length hasn't ever gone past her shoulders.
Okay. And how many inches would you say the length of her hair was?
The longest, maybe just right to here.
Okay. Can you give us a guesstimate?
5 inches.
Sorry, I don't know why StreamYard's doing that.
Lee's
Sorry,
hair
guys.
is also varied in length, correct?
I feel, for me at least, I feel like as long as the audio, because that matters a little bit more, but it just does that thing where the video glitches. I thought it was kind of working better, but anyway.
Yes, his hair is usually very short.
Okay. Now, turning your focus to the photograph, this photograph was taken in early 2007, correct?
Yes.
And Caylee would have been, at that time, younger than 2 years old?
Yes.
Okay. Approximately 15 months, would you say?
I would say maybe 18 months.
Okay. And the shorts are 24,
Correct.
correct? And in June 16th of 2008, a year and 3 months later, Caylee has grown significantly, has she not?
Yes.
In fact, Caylee no longer fit into these shorts, did she?
I don't believe so.
Okay. She had outgrown these shorts.
She was in 3Ts.
Okay. And these are 24 months, correct?
I think so.
So would it be a fair statement to make that whoever put these shorts on her were not familiar with her size?
Your Honor, I'm going to object. He's asking me what to speculate.
Sustain.
But as you testified under direct examination, ma'am, that, oh, never mind, I'll withdraw the question. Thank you, Mrs. Anthony.
Redirect. Okay, thank you, Mrs. Anthony.
No
You may
redirect.
stand down.
Now we're on to the sticker.
Okay, members of the jury, you had asked earlier
Oh my God.
to have an opportunity to see Exhibit 313. We can publish it via the document camera, and we can also pass it around for you to look at. Would you like one or both of those methods?
What do you guys think they're going to say?
Okay.
Both.
So we will publish it on the document camera. Please read the writing contained on the exhibit so the jury would understand when this item was originally taken into custody, how the exhibit currently was brought into custody.
Exhibit 313 is identified as a piece of cardboard matting with pink raised heart-shaped material attached.
Raised.
You will also notice now that it has separated.
Okay. Before they show it, here's what I want to do. So remember, what the general consensus and what I had been told by someone in the chat, I don't know, like 2 weeks ago, was that they found the same sticker, one of Casey's stickers, okay? Again, I'm just reiterating, on and that they found it on the piece of duct tape, and it was the piece of duct tape that was on the remains. Now, what we heard from the testimony was that none of that's true. They didn't find a sticker on any duct tape. They found there was the outline, right, and then it disappeared. Whatever. They didn't get any pictures of it. And the duct tape that it was that was supposed allegedly seen, right, was in between the two pieces of duct tape that were 7 feet away from the remains. The only last question that we still had was, is it the same sticker or is it a different sticker, right? Because again, I was told it's the same sticker, right? So now we have a sticker on a piece of cardboard, and remember, the cardboard is that sign for the daycare. And remember, this piece of cardboard was found in the same location, like 7 feet away from the remains, near where those two pieces of duct tape were. So my thought is, if that outline even existed, right, and there's no photos of it because she didn't take any, if it existed, maybe could it have been, this same sticker, and then with rain or whatever, and then it washed off and then got stuck to something else? Or could it have been that there were two of these stickers? But the question really is this the same sticker? So before we see it, we're going to take a quick look at the stickers in question from her room that were from earlier. I'm just going to jump right back to it. Hold on. Let me see if I can find it. Okay, it was after this lady. Okay, so here's one sticker, but then they showed up close. Let's see.
Is that as an item collected from the bedroom of Casey Marie Anthony?
Yeah.
Okay, so there's those stickers. I think it's before that. Hold on.
Yes, I do.
Are there other stickers in that photograph that were collected and seized by you?
Yes, there are.
Where were those stickers located?
So the sheet there, we're going to see a close up of it. It's the one on the left.
This is a sheet of heart-shaped stickers that appeared to have been cut in half. It was located inside of a black binder in that same cabinet as the previous sticker, which was located along the north wall in Casey Anthony's bedroom.
Right. Can you indicate by circling the item that you were speaking of? If I may approach the witness with what's been marked as QP for identification.
You may.
If you would take a look at the packaging associated with that item and tell me if it's something that you believe you've had contact with. Were those collected by you?
This is a sheet of metallic red heart-shaped stickers.
Red ones.
The postage stamp?
Yes, the postage stamp.
Yes.
Do you see 37 cents?
Okay, there's another part.
Okay. Do you know how long ago it's been?
Okay, let me get
Minnie Mouse.
I'll find it and I'll make sure that we can have that in the recap. But anyway, but you guys saw, right? The point being those heart stickers are all flat, right? They're like the light purple flat ones. So now we're going to go back to where we were, where they're going to bring in the heart-shaped sticker that the state tried to keep out. Okay. That was found at the crime scene. Let me find where we were here. Before this, hold on. It was right after her cross. Okay.
As a piece of cardboard matting with pink raised heart-shaped material attached.
You will also notice now that it has separated.
Okay, here's where we were. Thanks, Flash fan. If you want to link those in the Discord. All right. So take a look at that sticker, guys. And remember, we already heard that it was raised. It's like a jelly type. You know what it reminds me of kind of is like a stick-on earring in a way. You know, they have this press-on stick-on earrings for kids. Kind of reminds me of that. This is despicable because the prosecution was hoping to suggest that this was a matching sticker. And in fact, again, that was apparently what the general, still is, the general consensus, because again, what I was told was it was the same sticker, that it was one of her stickers. There is nothing like this that was found in the home. And they even testified to as much. There was nothing, they were all flat like a stamp. This same sticker was not found. And remember, this came attached to the cardboard, and the cardboard was the sign for the daycare or whatever, the school. The fact that people really wanted this to be the same sticker, it's just infuriating. There it is.
Okay, please let us know when you're finishing it. We will pass it around.
I mean, it's not.
Ready?
Not even.
Okay, please pass it around.
Oh, okay.
As evaluating the evidence, they should consider it attached.
Ladies and gentlemen of the jury, when this item was taken into evidence, it was one complete. The heart was attached to the cardboard liner.
I thought this was funny because they're waiting for the jury to see it. And Mr. Ashton's making all kinds of noises over there.
State may call in next witness.
Your Honor, at this time, after consultation with the defense, there were several stipulations.
We need your microphone on the front. The court reporter hear you.
After consultation with the defense, there are several stipulations that we'd like to announce at this time, if I may approach.
You may.
With those, and there are two exhibits that go with this first item. I'm sorry, QT and RA.
You want me to read them?
Yeah.
Go ahead.
Not only the stipulation, but there is an affidavit as it relates to one of the items, actually to both of the items, QT and RA.
You want the affidavit, and do you also want the notice of intent to rely upon the affidavit of professional journalists?
Yes.
Okay. Ladies and gentlemen of the jury, the following stipulation between the state of Florida and the defendant. The copies of the video and still photographs from the video taken by WF-TV on July 20th, 2008 are true and accurate representations of the business records of WF-TV Television Incorporated. The parties have agreed to this fact, and it should be considered as true in your deliberations, bearing the signature of Ms. Drane-Burdick, Mr. Baez, and Ms. Anthony. Second document is notice of intent to rely upon affidavit of professional journalists. This document serves as notice to the above listed defendant that the state of Florida intends to introduce the document described in the attached affidavit of a professional journalist into evidence at a hearing or trial of this matter pursuant to section 90.803 paren 6, 90.5015 paren 6, and 90.902 paren 11 Florida statute. The document described in the attached affidavit of the professional journalist WF-TV Television Incorporated were previously provided to the defendant's counsel as discovery. Signed by Ms. Linda Drane-Burdick. Affidavit of professional journalists. I, Daniel Criswell, am a professional journalist currently employed with WF-TV Television Incorporated. Attached hereto are true and correct copies of video.
Okay, I'm going to go ahead just a little bit because he just goes on and on about it's just stipulations and it's the many journalists and whatever. So let's just go ahead and I don't even know if I don't even think they publish anything with it, which is pretty crazy.
And that's the exhibit that the affidavit is referring to.
Correct. One is a photograph, and
Okay, so now we're getting to
the other is a very brief video.
What says the defense?
No objection.
May we publish 317 first, followed by 316?
You may.
Look at that duct tape go. Look at it go.
Have Mr. Perez zoom in on the area inside the red.
Here we go.
And that's exhibit what?
It pixelated. That would have been 316.
Okay.
The other thing I'll do is a side-by-side.
We have several additional stipulations.
I'm going to do I'll make two composites for next time. I'll do all the different stickers lined up, and then I'll also do the different various duct tape with the angle duct tape. I'll align it. We'll have that next time.
For the court at this juncture.
Okay.
Recap.
Ladies and gentlemen of the jury, the following stipulation has been entered into between the state and the defense. In 2008, Cindy Anthony was employed by Gentiva Health Services. The attached documents are true and accurate copies of the business records of Gentiva Health Services regarding Cindy Anthony's employment from January 1st, 2008 through July 16, 2008. The parties have agreed to this fact, and it should be considered as true in your deliberations. Signed by Linda Drane-Burdick, Jose Baez, and Miss Anthony to defend that. The second portion is a business record certificate. And then the third portion, which I will not read the entire thing, but it is a time card history report.
There's an additional stipulation which we've asked the clerk to label as RW.
It's RC.
Oh, I thought the first one was RB. RC.
In 2008, George Anthony was employed by Security Forces Incorporated. The attached documents are true and accurate copies of the business records of Security Forces Incorporated regarding George Anthony's employment from January 16, 2008 through July 4th, 2008. The parties have agreed to this fact, and it should be considered as true in your deliberations. Bearing the signatures of Linda Drane-Burdick, Assistant State Attorney, Mr. Jose Baez, counsel for Ms. Casey Anthony, and bearing the signature of Ms. Anthony, business record certificate, and then the weekly time reports of Mr. Anthony. Now, do you wish to publish any of those two exhibits by the use of the document camera? Or are you just gonna?
Not at this time. They can,
Okay.
They can go to the jury during deliberations. We have an additional stipulation that I would present to the clerk that has multiple documents attached to it.
Okay, stipulation regarding State's Exhibit RD. Okay, let's approach.
There are two additional stipulations.
Okay, let's finish this one here. We haven't finished this one.
Yes, sir.
Okay, with those modifications, what says the defense as to what's the identification number, Madam Clerk? RD.
No objections.
I will read the stipulation into evidence. The attached documents are true and accurate records of the business records from Photo Bucket
Okay, the tax. I'm going to go ahead a little bit. Some of this
relating to photographs from May 24th with second stipulation deals with the identity of the defendant.
Yes, sir. We have no objections to the identity of Miss Anthony.
Stipulation.
The state would call Jenny Welch.
Welch, W-E-L-C-H.
Back again. Jesus.
You may proceed, Mr. George.
Thank you very much, Your Honor. Good afternoon, ma'am.
Good afternoon.
Ms. Welch, you are a CSI investigator for the Orange County Sheriff's Office?
Yes, that's correct.
All right.
So every other time she's been on the stand, she's had Miss Drane-Burdick, and now she has Mr. George, and she looks elated.
I want to draw your attention to August 13th of 2009. On that date, did you come in contact with the defendant, Casey Anthony?
Yes, I did.
And why did you come into contact?
This is really stupid. All this is the pictures she took of Casey's tattoo. I'll just jump ahead. That's all this is. She's on the stand really quick. It's as you can see, like I went ahead like 1 minute and already.
13th of 2009.
Yes, it is.
Yes, the tattoo.
Cite no predicate.
Overruled.
Okay, I'm now showing you what's been previously marked for identification HG.
There it is. All they're going to say is that was her tattoo. That is indeed Casey's shoulder. It's not someone else's shoulder. That's the tattoo.
Did you recognize that afternoon?
Go ahead a little bit.
13th of 2009.
Yes, it is.
On August 13th of 2009.
Yes, it is.
Thank you very much.
No
I don't have any further questions of this witness at this time.
Cross-examination.
No questions.
Okay. May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
So
Bobby Williams.
this guy is the guy who did the tattoo.
BOBBYWILLIAMS.
You may proceed, Mr. George.
Thank you very much, Your Honor. Good afternoon.
Good afternoon.
Mr. Williams, how are you employed?
I'm currently employed at Cast Iron Tattoos.
So they go through like how long does it usually take to do a tattoo and all this other stuff. I'm gonna jump ahead a little bit because again, this is just it's so funny. This is the end of the state's case in chief, right? And it's like getting in this evidence about the tattoo. And they don't cross him either. So
What's been previously marked for identification HJ into evidence.
We would renew all previous motions and objections.
we're only a
Approach
couple
the
minutes away. We're only a couple minutes away from the motion for a directive.
Sidebar.
How did she pay you?
Cash.
Okay.
Great.
Did she immediately leave the store at that point?
I mean, it's like
No,
here.
sir.
What happened?
Co-worker and I, we ended up ordering pizza, and she actually had a couple slices.
Okay.
I mean,
Who paid for lunch?
She did.
All right.
who cares?
Directing your attention to July 15th, did you have the occasion
like-
to see the defendant again?
I feel like
Yes,
it's
sir.
almost like it would just be kind of awkward just to like literally ask him the one question about it. So they like try to make small
Did you
talk
see
or
her?
something.
Inside the
So
shop.
stupid.
When she came into the shop, why did she come in? Did she came in on the 15th and made another appointment? How was her mood?
Great, wonderful. Okay, I think we're good. I think we're good. We're good.
Of the photograph of the
So
tape.
there actually is cross-exam. Let's just jump to that. It's probably one question. Let's just see what happens here.
Did you have any other interactions for tattoos for any other members of the Anthony family?
Your Honor, outside the scope, irrelevant.
Oh, I forgot. There's actually something interesting. Look, I forgot about that. Okay.
Is it customary in your business that people get tattoos to remember their loved ones that have passed?
They do, yes.
Okay. And that's something you do quite often?
Yes, sir.
Okay. And did you do the tattoo for George and Cindy Anthony that they've had to commemorate Caylee Anthony?
No, sir.
Irrelevant, outside the scope.
Doesn't matter.
Sustained.
The jury heard that. That was, I think, the thing I was thinking. The jury heard the question. The jury heard the question.
Did you have any other interactions for tattoos for any other members of the Anthony family?
Your Honor, outside the scope, irrelevant.
Sustained.
I have no further questions.
All right.
When she came in on the 2nd and got her tattoo, did she appear to be mournful?
Excuse me?
Was she mourning?
Again of the.
We are going to just.
Today, I will see you in the morning at 9 a.m.
Okay.
Wants to renew motion for mistrial on several grounds. One, to renew the one we made the other day regarding the morphing of the photograph of the tape and the skeleton and so forth. Additionally, now today we have issues regarding the heart-shaped sticker that did not match anything whatsoever that was described by FBI agent Fontaine as being.
There it is. That is why I wanted to try to find, and I couldn't find it, the close-up of the heart shape. I'm thinking again that it might have been from when Mr. Murdoch was testifying. That was from the last episode. I will find it again. I'll find it and I'll make a composite. But we're hearing him say it, but there's nothing like seeing things for ourselves, right? But that's the point. Because wrap your heads around this, guys. That what I was told, and again, this is probably the general consensus, and this is probably put out by Nancy Grace and in the mainstream media, what I was told was that there's a heart-shaped sticker that is from Casey's room. That's one of her stickers, okay? Even if you just leave it at that, never mind where it was found or whatever, just that it's the same sticker. How? It literally is not, it's not even a sticker. I think it's one of those press-on earrings. It's not even sticker material. It's not paper. Like, it's not even made of paper. It's not even made of paper. It's made of like that gel. I mean, you guys saw it. And he's saying the same thing. He's like, how is this? And remember the fact that the state didn't want the jury to see it. I don't know how to even.
Dime shape. We've objected that. We did pretrial motions on that, and it caused speculation. And then, of course, the last thing, the prosecution trying to introduce the issue of remorse. You did, of course, sustain the objection, but the jury heard the question. So on those basis, and indeed reminding you again of the motion, the consciousness of guilt argument, for what it is worth to you on that, the Florida Supreme Court ruled in Mena versus State that the behavior has to be susceptible of no prima facie explanation except consciousness of guilt. The state has not met that burden, and with respect to that, the post behavior of this defendant, that the Mena court says it should not be admissible, and we're asking for a mistrial on that basis. Thank you very much.
Reply from the state of Florida.
Your Honor, as to the superimposition video, there's no new arguments presented, so I'll make no new response. As to the tattoo, at this point, the only evidence presented before this court as to the defendant's
okay, it's all done. That was the fastest I've ever done it. So I made the thread for Casey Anthony. By the way, I just wanted to give a great big shout out and a big thanks to FlashFan, who has been providing me with all kinds of stuff while we're live streaming, and he knows that I'm live streaming. He's like, don't worry, I'll find it and I'll put it in the Discord. I just appreciate that so much. You're like my little assistant with not little, you know what I mean? You're like my assistant with like finding things and, researching and providing, I just really appreciate it. So thank you so much for that. Also, Flash Fan is going to be appearing on a live stream tomorrow at 10:30, I believe, and talking about a cold case out of, oh my God, where was it from? Nebraska? Was it Nebraska or Mississippi? Nebraska, I think. I'm sure he will let us know, but a cold case, and he's going to be on the channel, Alternate Juror channel. So y'all, if you're available, check it out and show him some love and support. Nebraska. Okay, cool. I thought so. I was like, it's that end state that I never think about. there it is. So that narrows it down. So yeah, anyway, just, you're going to do great. I'm really excited for you. So yeah.
Version of these events is that her daughter was alive and absent from her custody against her will. The fact of her obtaining a tattoo that says something which the court may eventually take judicial notice means the good life or the beautiful life is certainly inconsistent with the stated defense. Obviously, counsel's opening statement presenting an alternative version is not in evidence before the jury yet. The only version of the defendants we have so far is the various versions of the Zanny story. So I would submit that that is relevant. As to the question asked by counsel that was not answered, the defense asked the question, quote, is it customary in your business that people get tattoos to remember the loved ones that have passed? Clearly, we would submit that it was an appropriate question of the court to sustain the objection to ask about whether the demeanor of the person requesting a tattoo was consistent with someone asking for a tattoo because loved ones had passed. We don't believe that that was a question that went to the remorse issue. It was a question that went to a response to the defendant's question. The court sustained the objection. It wasn't answered. And I would submit that there's no grounds for mistrial in this case as to any of these grounds.
Motion for mistrial will be denied.
Shocker, not.
Okay, I guess the only housekeeping matters we need to take up is the state is making a request for the court to take judicial notice. My suggestion is that area that you're going to use, that you get a copy of that page, cover, sheet, etc., to the defense so they can have an opportunity to examine it tonight. It would not hurt if you got me a copy of that also. We will do that. If the court takes judicial notice, then the court will give the meaning of that phrase. Then I take it at that point the state of Florida will rest.
Yes, Your Honor. There are two items that have been marked for identification and identified, State's Exhibit IP and IQ, which we will be formally moving into evidence. These are two of the canned samples of the spare tire cover. They've been fully identified. I just realized we haven't actually formally moved them in, so we would be doing that. And aside from that, I believe we would be resting.
Okay. As we discussed earlier, I believe at sidebar, despite the efforts of the defense, they were originally told to be prepared on Thursday. They tried to move some witnesses up to Wednesday, but they could not do that. So then we will start out on Thursday with the defense's presentation. And I take it that after the state rests that the defense will be prepared to make its motion for a judgment of acquittal.
Fuck yeah, it's ready. I'm ready.
Okay.
And I would make, to lessen the inconvenience to the jury, we will commit to the court that the only things that we have left to do are the judicial notice and put those two candidates.
I'm so ready for that. Let me go. They're almost done with this housekeeping. I'm just going to jump ahead. Mr. Ashton's just whining about whatever the fuck. Oh, what's
o'clock schedule?
That's fine. The only reason I asked is if you go beyond that, I have to make arrangements.
Just talking about schedule. We're going to hear him talk to the jury about that anyway.
Let the court know as soon as I know if that's going to be an issue.
that he is planning to rely on, that he provide those to us this evening, since we've provided ours to him 2 days ago.
Mason, since he will be
First
addressing it.
thing in the morning, now that you've finished your stuff,
Okay,
I'll work
they're
tonight.
just
and I'll
talking
get it
about
to you
the
in the
case
morning.
law for the.
The
we're gonna
law is
hear
the
it.
law, folks.
We're going to hear it. It's the case law for the direct and verdict. Okay, let's do.
So we won't get one last thing. The grief expert, have y'all arranged depositions for that?
I believe it's set for Saturday afternoon, as I recall.
Okay. I think I had given y'all two cases.
He's going to give them some more
Since
case
it-
law to look at. Yay! Here we go. Next day.
Okay, before we bring the jury back in, there is one issue. I think the state had some exhibits it needed to introduce. And then there was a request that was pending that you were going to make a request for the court to take judicial notice.
As of yesterday, that was correct, Judge. As of this morning, the defense and the state have come to a stipulation in regards to
They're gonna
that
have more
issue, if I may approach.
Okay, I'm going to
You
go
may.
for it. They're going to just do the stipulation. again for the jury. They're going to do it again for the jury. So.
Provided these are just being entered into evidence, this is not going to be going into the sniff test area.
They're talking about the stupid.
Yesterday.
Of smell.
They viewed 313 yesterday.
And our concern was how the jury reached that consensus to make that inquiry unless they were discussing the case and they're not supposed to be.
I'm not.
Munitions,
Okay, here we go. Now we're getting.
including but not limited, not discussing the case among yourselves or the other things I've admonished you about. Okay. State recognized presence of the jury?
Yes, sir.
And the defense?
Yes, sir, we do.
All right. State may continue.
Thank you, Your Honor. At this time, the state and the defense have entered into a stipulation, and we would ask that the court read that stipulation.
Okay. Any objections from the defense?
No, sir.
Stipulation between the state of Florida and the defendant reads as follows.
We're getting so close,
On
guys.
July 2nd, 2008, Casey Anthony obtained a tattoo with the inscription Bella Vita.
Okay, this is just the tattoo.
This Italian, but says the defense.
Subject to our previously mentioned limitations, yes.
State may call their next witness.
Your Honor, at this point, the state of Florida would rest.
Ladies and gentlemen of the jury, the
Yay!
state has now rested
Guys, we
its
did it.
case.
We did it, you guys. We did it. They rested. It's done. Thank God.
May the attorneys
Yay!
approach the sidebar for
Go
a
squirrel
minute
through.
along with the court reporter. Okay, ladies and gentlemen of the jury, there are going to be some legal matters we're going to need to take up outside of your presence.
Okay.
That
We
will
know.
be fairly
He's going to dismiss the jury.
proceedings. Please remember all of my previous admonitions
Let's go.
to
Let's
make,
go.
but prior to doing that, you handed the court
I'm so excited.
some documents, a number of cases, and you also had a
So I'll just summarize this. This is the beginning part. He's just going to talk about. They just handed him the case law. Do they want him to read it? Blah blah. I have it labeled when it gets to the actual thing, the actual motion. All right, let's go to here because again, this is just preliminary chit chat, if you will. So.
conclusion of business, and I did read the entire book that they presented, even though there were some cases I was
A little bit further. No, back.
Title to present.
Oh my God, why did it do that? Hold on. Okay, why did it jump? Sorry guys, let me just go. My slider bar thing just jumped. So let's just go back to where we were. Okay.
opportunity to review their cases. So what is the defense's pleasure?
First, I had
I have not seen those.
I'll just prefer to go on and make the argument, get finished with this, and let you take under whatever advice you think necessary to read the cases and formal order.
Okay. All right, you may proceed.
Buckle up, guys. Buckle up. This is, oh man.
It is well established in the jurisprudence of this country and in this state that at the close of the evidence by the state and or again at the end of all of the evidence that is presented, we are entitled to present an argument to the court seeking a judgment of acquittal. In Florida, is codified in the Rules of Criminal Procedure 3.380. And the burden, as you well know, and I won't belabor that, is if the evidence is insufficient to warrant a conviction, then the court is supposed to step in and shall enter a judgment of acquittal. We know, and as I put in the memorandum, that if you view the evidence in the light most favorable to the prosecution, and there are elements that are not proven or not been established beyond a reasonable doubt, then it is the court's obligation to enter a judgment of acquittal as to the various charges affected. And for that principle, the Florida Supreme Court, in the case of Reynolds, R-E-Y-N-O-L-D-S versus State, found at 934 Southern 2nd, 1128 in 2006, enunciated that rule. No surprise, not academically new to any and all of us. Most recently, the Florida Supreme Court a couple of months ago, while affirming conviction and death sentence in the case of Serrano versus State, S-E-R-R-A-N-O, the only cite so far is 2011 WL904071. The Supreme Court in this case, which I know the judge knows that I'm intimately involved in,
Seems like he was the attorney
in
on that one.
this type of case, capital cases, murder cases,
Here we go.
the Supreme Court reaffirmed that there is a special standard of review that is required. The court said, at page 1, citing another case, a Darling case, a motion for judgment of acquittal should be granted in a case based solely or wholly upon circumstantial evidence if the state fails to present evidence from which the jury could exclude every reasonable hypothesis except that of guilt. Where the only proof of guilt is circumstantial, no matter how strongly the evidence may suggest guilt, a conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. The question of whether evidence fails to exclude all reasonable hypothesis of innocence is for the jury to determine where there is substantial competent evidence to support that. And the court will not reverse it. The Supreme Court has further stated in Cox v. State, 55 Southern 2nd 352 in 1989, that one accused of a crime is presumed innocent until proven guilty beyond and to the exclusion of every reasonable doubt. It is the responsibility of the state to carry this burden, and when the state relies upon purely circumstantial evidence to convict an accused, we, the court, have always required that such evidence must not only be consistent with the defendant's guilt, but must also be inconsistent with any reasonable hypothesis of innocence. Our current rules and the circumstantial evidence instruction promulgated by the Supreme Court says as follows. Circumstantial evidence is legal evidence, and a crime may be proven by such evidence. A well-connected chain of circumstances is as conclusive in proving a crime as is positive or direct evidence. Its value is dependent upon its conclusive nature and tendency. Circumstantial evidence is governed by the following rules. 1, the circumstances themselves must be proven beyond a reasonable doubt. I'll digress momentarily and direct the court's memory to Dr. Garavaglia saying that she concluded
guys?
that she would label this case as a homicide by indeterminate means, choosing the word homicide because in her view the circumstances established that by preponderance of the evidence.
Ready?
So, by my experience and by what is known about the way homicides occur, I felt that the preponderance of evidence and that there was no other logical conclusion could be found.
Preponderance of evidence. So this bothered me before, but I didn't say anything about it. But it's interesting that she says preponderance, right? Because that's a legal standard that is the same as the greater weight of the evidence, right? And greater weight of the evidence is 50% plus a grain of sand. And it's interesting that she offers that. He didn't ask her what the burden was here, what the legal standard was. She offers that. She says by the preponderance of the evidence. And that's a problem because this needs to be beyond a reasonable doubt.
That is directly contrary to the law.
Fuck yeah.
2, the circumstances must be consistent with guilt and inconsistent with innocence. And 3, the circumstances must be of such a conclusive nature and tendency that you are convinced beyond a reasonable doubt of the defendant's guilt. If the circumstances are susceptible of 2 reasonable constructions, one indicating guilt, the other innocence, you must accept the construction indicating innocence. And that is the jury instruction, which, if this case proceeds on to that level, then we'll be reading that to the jury, and that is the law in the state of Florida now applying as to whether a judgment of acquittal should be considered. The state, in presenting its evidence, I will suggest to you, has established in the light most favorable to them that Miss Anthony has a history of untruthfulness among family members and friends. And apparently the untruthfulness and representations for whatever necessary reasons to her regarding the existence of a nanny began in 2006.
Yes, I've been saying
They have established by stipulation that the child is dead. There is no evidence to establish when the child died other than in a monthly window of possibility, where she died, how she died, who, if anyone, was with her in attendance when she died, and they have failed wholly to rebut the reasonable hypothesis of innocence, that is, that there was accidental death
Yes.
and inappropriate efforts by those unidentified as of yet to cover up that accidental death.
Wow, that was powerful.
With respect to count 1, the first degree premeditated murder, the evidence fails to exclude a reasonable hypothesis of innocence. And that is, that there was no premeditation, even if there's a determination that there was a murder at all.
Right.
When the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon...
Is the state supposed to be trying to prove premeditation? Because, I mean, I feel like that hasn't even entered into this at all in this trial.
...by the state must be inconsistent with every other reasonable hypothesis. And I cite in the memorandum to the court the case of Smith versus State, 568, Southern 2nd, 965. First District Court of Appeal case of 1990. I'm going to talk about some of these cases after I get through the preliminaries. Yep. There has been, in this case, no evidence of premeditation presented to this jury or this court.
Thank you. That's what I just said. I was like,
there's a stacking of inferences, a stacking of speculation, but no evidence. The Smith case, Your Honor, is of particular interest, I suggest, also in this case, because of the nature of the facts involved. In Smith, the Tampa Bay police found the body of Judy Smith floating in the bay, the body having been wrapped in chains and a blue bedspread taped around it. Despite the fact that the Lady was missing for some period of time. The husband defendant did not call the police and report it.
That's not Donald Smith, is it?
I'm sorry?
You said the Smith case. That's not Donald Smith versus State.
Donald Lewis Smith versus State.
First District Court of Appeals, 56872nd 965.
Yes.
Okay.
Yep. You have it in the text I gave you there. The court ruled in this case that even though premeditation can be proven by circumstantial evidence, where the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable inference. And the court ruled in that case that, in fact, the conviction for first-degree murder had to be reversed, directing the court to reduce to second-degree murder because the state was unable to prove beyond a reasonable doubt the manner in which the homicide was committed if there was a homicide.
Wow.
In that particular case, there's no question of the fact that this woman died in that capacity, wrapped up in chains, in a blanket and tape, and in the water, drowned. There was no mistake. There's a major similarity to the case that we have in a light most favorable to the state, except here we don't have any cause of death. We have clear admissions from the experts that do not know the cause of death. And by the preponderance of the evidence, we have the speculation of Dr. Garavaglia that
say it.
it was a homicide because she claims that 100% of people report things, some such thing.
You know, 100% of the time that accidental deaths are reported unless there is a good reason not to be. That's partly behavioral science.
I'll ask you to read that case further.
It makes me want to.
It's interesting also that, just digress again a little bit, in the Serrano case, the prosecution has submitted that case also, where a circumstantial evidence case tried and resulted in a conviction. What a world of different set of facts. Nelson Serrano was convicted.
What he's doing is he's presenting, this is what you're supposed to do. He's presenting also adverse case law, which is the case law that would maybe go against what they're arguing, but then he's also, but see, this is why it's great, because then you're highlighting how it's actually completely different, right? Like he's saying, a different set of facts, right? For example.
Of the execution style shooting murder of 4 people.
Wow.
3 prior business associates engaged in litigation and fighting over millions of dollars, in which he had been expelled from the office, and a history of fight. One, that victim number 4, purely the epitome of wrong place, wrong time. The young woman came to pick up her husband. And of course, the case got the notoriety in the appeal because she was a prosecuting attorney. But the fact of the matter is, there was no question as to the cause and manner of death of I won't say their name because of the publicity, but the victims shot execution style on their knees. Blood spatter, ballistics, unequivocal statement of fact as to the death. The issue of circumstances, whether or not Mr. Nelson Serrano was the shooter, and went on for weeks and weeks and weeks and weeks and years to this point in the appellate courts, in the Supreme Court, that is, of Florida, regarding issues of alibi and so forth. But of course, as I said, the Serrano case reiterated the special test and a requirement in these type of cases that every reasonable hypothesis be excluded, or they cannot be a conviction. Another issue for the court to consider regarding count 1, the first-degree murder, is whether or not, despite the indictment charging premeditated murder, that can be satisfied by the proof of felony murder. Ms. Burdick handed me this morning the case of Brooks versus State, which we already had and rely on also. Florida Supreme Court 2005, BROOKS versus State 918 Southern 2nd 181. The merger doctrine. that is the law in this state as of this date. Indeed, the underlying alleged felony of aggravated child abuse is merged into count one as a matter of law, because if there's an act, there's a single act. You may recall, and perhaps it did not ring loudly enough for the uninitiated, but the fact of the matter is, with every evidence that we could cross-examine and touch, no evidence of any prior trauma, injury, or act of violence whatsoever with this child. No heel fractures of any description, closed, open, or otherwise. No bone torquing, and so on. And the first 18 witnesses called, while they besmirched the character of the defendant with history of misrepresentations and lies, all confirmed that she, Casey Marie Anthony, was in fact a dedicated, doting, loving, caring mother. Always saw them happy, always saw the great reaction between the two of them. And I'll talk about why the aggravated child abuse count fails in a minute. But clearly, the evidence before this court mandates accepting the merger doctrine of Brooks.
One question, Mr. Mason, about that. Are you familiar with the First District Court of Appeals decision in Lewis versus State, found at 34 Southern 3rd Edition?
I am.
183, 210.
Seeking to distinguish the merger doctrine of Brooks.
Yeah.
Yes, sir.
Which is
you got it.
Pending, where they claim that the Supreme Court's decision in Brooks was dicta, and they talk about the legislative intent, and it's been certified to the Florida Supreme Court. How would you square Lewis' interpretation of Brooks?
The same way you have for the last 6 weeks. The Florida Supreme Court says, and until they change, they're the boss on that issue, aren't they? And they say, what they say, and Lewis is trying to undo it. Okay, nothing new about that. We've been saying that for decades and decades, but the law today is Brooks. Let me move ahead on the aggravated child abuse as count two.
Gotcha, flashback.
And I have cited and provided to you the case of Kennedy versus State, found at 59 Southern 3rd.
Yeah, and for anyone who's on replay crew, I also have everything timestamped, as I'm sure you all know. Because I will say that it's still worth watching the state's argument, because it's for obvious reasons. But then the defense rebuttal is short and it's really powerful. So so definitely, I'll have those timestamps too for anyone who does miss any of this, because it's really worth it. We don't ever see stuff like this. I mean, in trial, Again, usually it's more like a formality. This gets really intense. So
376, 4th District Court of Appeal decision 2011, actually dated last month, May 4, 2011. The Kennedy Court said, and it's important to your consideration in this case as well, talking about the standard for aggravated child abuse. And it basically defines what it is. And it talks about the court making an error and not properly identifying what is meant by aggravated child abuse and reversing that case. Let me say this to you and read from the opinion. The complete definition that's required with the statute of maliciousness is where it comes down to. It may be established by circumstances from which one could conclude that a reasonable parent would not have engaged in the damaging acts toward the child for any valid reason, and that the primary purpose of the act was to cause the victim unjustifiable pain or injury. And there is absolutely no evidence whatsoever for this court that if there was an act which the state alleges variously as, I think, I interpret, perhaps chloroform and or duct tape.
Did y'all hear that? Let me back that up. Well said. The shade, the well-deserved shade on behalf of the state there.
Was an act which the state alleges variously as, I think, I interpret, perhaps chloroform and or duct tape.
Right? We don't.
That evidence substantially subject to question in different interpretations, but nevertheless, all of the witnesses that knew and testified were asked about any history of torture, inappropriate discipline, any actions like that at all by the defendant against her little girl. In the absence of evidence proven beyond a reasonable doubt that the primary purpose of an act was not to cover up or not to conceal, but was to cause unjustifiable pain or injury, failing that, the charge of aggravated child abuse must be adjudicated not guilty in this case. As to count 3, aggravated manslaughter of a child, the state is required to prove beyond and to the exclusion of every reasonable doubt 3 elements. Caylee Marie Anthony is dead, proven. The death of Caylee Marie Anthony was caused by the intentional act
So he's going through the elements of the
or
charge.
culpable negligence of Casey Anthony, not proven, and that Caylee Marie was under 18. It's the age that shifts it to aggravated manslaughter rather than
So it's like the only things they proved was that she died and that she was under 18.
ordinary.
Incredible, right?
It is our position, our argument to this court, that what has been presented to you and this jury is the mere presence of duct tape on or near
Wait for it.
the remains, which is not dispositive of any intentional act and furnishes nothing stronger than a suspicion. And I cite the court's reference the case of Ballard, B-A-L-L-A-R-D versus State 923, Southern 2nd, at page 482. There has been no evidence presented as to culpable negligence on the part of the defendant, which is defined as a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. That's standard jury instruction 7.7 and Florida statute 782.07. There has been no evidence whatsoever that could be considered at that standard of culpable negligence. And of course, there is no evidence whatsoever, none, as the causation of this child's death. Lawyering as to counts 4, 5, 6, and 7. I'm not going to belabor that. I suggest to you that, of course, you may not know this, but as of my last look, there's not a single appellate court case on this statute. It's first and only time it's ever been pulled out to be used somewhere.
What he's talking about is the charges for false. So you know how people will always ask, like, right, like if someone perjures themselves on the stand, right, or whatever, or make a false statement in police reports, and people will threaten and say, okay, you know what happens if you don't do this or that, and then people will always ask, like, are they going to get in trouble? We know they lied on the stand. Like it's clear. There's evidence that they were not telling the truth. And everybody says the same thing. It's never prosecuted. It's never prosecuted. It's never prosecuted. It's never prosecuted. That's what he's referencing, is that her charges for the false statements to law enforcement, he can't provide any case law about this because it's never been done. It doesn't exist in the appellate courts because no one's ever charged someone with this before and prosecuted it. It's never happened. So essentially, it makes it a case of first impression.
And I think it is constitutionally deficient because it doesn't even have a requirement of materiality. And we have materiality in every other similar type statute, perjury, false swearing, and so forth.
But isn't that argument a little late in the day? Shouldn't that have been done?
I'm sorry.
To dismiss.
Well,
Isn't that argument a little late in the day?
I think there was a motion filed on this before I was involved in the case, but I'm just raising the issue to you.
Go ahead.
I'm raising that issue and saying that in addition to that, by way of argument, it's based on statements attributed to the defendant. And we filed pretrial motions to suppress, and hearings were held on various aspects of that. Was she in custody and entitled to Miranda, which was not done? Were statements obtained as a result of inappropriate agency in violation of various case law? We went through all that, and you ruled on that. But there's another aspect of it.
Okay.
There is a standard jury instruction that I reasonably anticipate that you will give, and I don't have it committed to memory. But it's essentially this: ladies and gentlemen, statements attributable to the defendant have been introduced as evidence in this case. If you find that those statements were involuntarily made by the defendant, you must disregard them. And I submit to you, I don't know where we're going to get, we hadn't got to that part of it yet, but I'm going to be requesting the rest of that statute, of that standard instruction, to include reference to the evidence. The witnesses in the form of Detective Yuri Melich, can't remember, none of the others came in here yet.
No, they didn't.
Or such that she clearly was never advised of her Miranda warning rights.
She was not.
Despite having been surrounded by law enforcement officers on the 15th of July of 2008, put in the cage of Detective Acevito's patrol car and driven around and questioned in various aspects, reiterating her positions that were contained in the motions to suppress. Coupled with that jury instruction, I suggest it may give you some food for thought. At least it's not quite as simple as it might appear as to those 4 misdemeanor counts of lying. The other cases that I've cited for you to read, Your Honor, you have there the Bow case.
Also the nerve to have a death penalty murder case and also to throw in those false statements for the misdemeanors. It's just really, I don't even know. It's incredible. Yeah, I've heard of it. I love the name, the Velvet Hammer. Have you read it, Flash Fan, Judge Belvin's book?
BAUGH, 961 Southern 2nd 198. In that particular case, there's various issues of lack of corroborating evidence and reiterates the proposition that the state is required to prove every element beyond a reasonable doubt, and it cannot go to a jury unless they have done that. Not alarming law for you to have. Reynolds versus State is another important case, I think, that we rely on. REYNOLDS, 934 Southern 2nd 1128. The issue in that was, again, considering whether there was wholly circumstantial evidence, and the standard, which I know that you are aware of the law, even though there was no evidence in that case directly. There were 2 women murdered without any indication of defensive wounds and by the defendant, claim of whether he did it or did not. But there was no question as to the cause of death. These victims were bludgeoned to death with cinder blocks by their bodies and stabbed multiple times in the neck and torso with a knife and or.
He's making the distinction that in some of these other cases, what's different between them in this case is that the cause of death is clear, right? Regardless of whatever, like it's not in question, right? This person was shot, this person was stabbed, this person, whatever. And that, I mean, I think he got really lucky. And again, I commented on earlier when Dr. G said preponderance of the evidence. That was not elicited by him. That was like a gift, When she said that, I was like, what? Why is she saying that? But he's so far, he's cited it twice, and he might even cite it again later. He's already referenced it twice. And I think that's part of why I think that really inspired him for this, because in other words, all this case law that he's pulling up is really heavy on the cause of death being a factor, right? And because the cause of death from the medical examiner was established by a preponderance of the evidence, right? You can see why that would be a really good thing to kind of lean on. That, if nothing else, look at that alone. And just never mind the facts of the case, right? Just that statement alone, and then the law should be enough for a directed verdict, right?
Scissors. A violent struggle had gone on in this whole process. There were multiple stab wounds, a broken neck and a severance of spinal cord as to one victim, Christina Razor. There were questions of fingerprint evidence and whether it was sufficient or not, of course, in the case. And if you read it and go through the facts and you think about the last 18 days of evidence we've had in this case, you got to say,
Yeah, right.
Yeah. Well, where is any similar evidence in this case? And it reiterates in that particular case as well. Wholly circumstantial evidence and the special standard of review applies. And I think that you'll see that, wait a minute, there are some serious questions raised here, because the state, despite the outcry, the notoriety, the emotions, so forth, the case is not here.
Okay.
I cited for the court the case of Cochran, C-O-C-H-R-A-N versus State, found at 547 Southern 2nd 928. Again, this is an evidence, a case where there was a confession, there were fingerprints that were important. The execution of the lady was a shot at close range. The body had been dragged out of the car, you'll find it particularly interesting. You make a note for yourself to read page 2 of that, the site contained in that case historically. That case stands for the same type of proposition, Your Honor, that the circumstantial evidence and it has to so severely establish the no other explanation. In that particular case, the court's decision of a death penalty was reduced, and because he overrode the death penalty. Ballard versus State, B-A-L-L-A-R-D, is another interesting case that discusses significant amounts of things. You might say, how about this case? They're talking about hair, talking a lot about hair evidence, and whether it is or is not. They talk about the anagen phase, the catagen phase, the telogen phase, and all the things that we heard about in this case. And the Supreme Court in Ballard reversed a conviction and death penalty for acquittal.
Let's listen to that one again. That's a big one. And after he finishes the sentence, he looks directly at Judge Belvin in the eyes.
You might say, how about this case? They're talking about hair, talking a lot about hair evidence, and whether it is or is not. They talk about the anagen phase, the catagen phase, the telogen phase, and all the things that we heard about in this case. And the Supreme Court in Ballard reversed a conviction and death penalty for acquittal. There was not just the hair evidence, there was a bloody circumstance and a crime scene that cried out for the fact that indeed there was a homicide. It wasn't just speculation as we have.
And then his point is, and even still, they had way more evidence in that case than this, and even still, it was reversed for acquittal.
Another case of importance.
Judges hate that. Judges hate that. That's why you want to bring up these cases where they talk about reversals, because they don't want to make a reversible error. That's the thing, right? So if something's reversed, that's like, judge, you don't want to be like them.
What I'm sure. There's a case of Cox, C-O-X, versus the state of Florida. It's found at 555 Southern 2nd, 352. It's a decision from 1989. Mr. Cox was convicted. He was sentenced to death by our recently departed mutual friend. And the Supreme Court reversed for acquittal.
Yes.
The state had relied totally on circumstantial evidence.
Wow.
And the Supreme Court in Cox said, insufficient.
Wow.
They had evidence of hair, blood, boot prints. Important part of the case is, though, recognizing that here again, a death sentence, not just commuted to life, but a reversal for acquittal.
Wow.
And Randall versus state, R-A-N-D-A-L-L, found at 760 Southern 2nd, 892. The Supreme Court reversed yet another death penalty.
I'm thinking about this. So guys, think about this as we go along, especially as it pertains to Florida, right? Because the states that, with death penalty, they're going to rely on their own case law. So think about everything that he's saying, right? Think about this as it pertains to, keep in the back of your minds for Shanna Gardner, because, this is all going to be relevant, right? And the thing is that, of course, it's going to be different case by case, but a lot of what he's saying here is, in terms of these death penalty cases where they were convicted and they're on death row, and then they're not just commuted to life, they're reversed for acquittal. What he's saying is these are entirely circumstantial cases. And so let's just make sure we understand the difference, right? Because the flip side of that is if you have direct evidence, right? And so what is direct evidence? Direct evidence is actually quite limited to basically witness testimony, which is funny because we all know how reliable that can be, or like somebody doing the thing on video. That's basically it. Or a confession. So if you've got an eyewitness, a confession, or a video of them doing it. But that's what I was thinking is like in terms of Shanna Gardner. Now we don't know all the facts yet or the details, but it'll be interesting to see because that whole thing with Henry Tenon, right? Him testifying against them. We don't know what he saw, right? Of course, we know he did the shooting allegedly. But because of the fact that he's not on the hook for the, we all know he's not getting, they just reduced it to some sort of like, manslaughter. If he testifies truthfully in the eyes of the prosecution. So in other words, because of the fact that it would in trial, right? It'll be accepted that Shauna and Mario didn't actually shoot the gun or whatever, then in other words, the potentially important testimony that could come from Henry wouldn't be him saying he saw them commit the crime as in shooting. It could be he saw them do, I don't know what, but in other words, it wouldn't have to be the shooting. It could be, I saw them write me the check or whatever, right? I don't know. I'm just thinking of an example. So that's going to be a challenge. Probably, right? We don't really know. It's going to be really interesting to see what all the evidence is. But yeah, just something to keep in mind, right? That circumstantial versus direct evidence. And so that is why though, when you've got a case where you've got the witness testimony part being crucial, right? Because when you've got someone who took a plea deal, who's going to testify against somebody else, right? Then right there, the reason the state does that is for that reason, right? Because that is potential, direct evidence. Should the jury find their testimony credible, right? As a witness and all that, that counts as direct evidence. And it's crazy to think about, right? But like, in other words, testimony from a Henry Tenon, right? By the standards of the law is actually considered to be direct evidence, whereas DNA is not. DNA is still circumstantial. And And it's just so funny, right? Because again, if you take someone like Henry Tennant, who's taken a plea deal, how much can you really trust their testimony? Compare that to something like hardcore DNA evidence, right? That's sometimes you can find problems, but let's just say it's like really solid DNA evidence, and like that is still considered more circumstantial. Now, again, that's where the law needs to play catch up in some ways potentially, right? Because everyone will know, no one will disagree that witness testimony or eyewitness testimony is really some of the least reliable, right? It really is some of the least reliable, but yet under the law, when they talk about things like circumstantial and direct evidence in the case law, direct evidence means witness testimony still counts as that. Eyewitness testimony still counts as that. So anyway, just things to think about. In other words, that testimony from like a Henry Tennant, maybe not for the jury, right? Maybe not for the jury, but in terms of the law is considered to be more important than something like even DNA. So yeah.
Case, and this time, vacating the death sentences and reversing it and saying that it can proceed on a second-degree murder because of the absence of evidence of premeditation.
Oh, yeah.
The court said in that case some controlling language. In cases in which there is no underlying statutorily enumerated felony, premeditation is the essential element that distinguishes first-degree murder from second-degree murder. Where the state's proof fails to exclude a reasonable hypothesis that the homicide occurred other than by premeditated design, a verdict of first-degree murder cannot be sustained. And the reasonable hypothesis, of course, in this case, is accident.
And again, to compare to Shannon Gardner, from what we know so far, from what we've heard talk about text messages, like insofar in the hearings, that there's text message communication, that like the checks, writing of the checks, things like that, right? We'll see what happens, but if indeed they've got things like text message communications where there's the planning, and if they've got pictures of the checks that was written back and forth, or to pay Henry, stuff like that, again, what have we got there? Premeditation. Again, contrast that to this case. Literally, I don't even know. I mean, it blows my mind that the state even thinks, like, I don't even know. I can't even think of an example, even with the state's theory and what the state, like, even if you try to it's like imaginary, right? Like the heart sticker, like that's just not, or like the post-mortem hair banning, that's not a thing. Or the smell of the trunk, things, even if you try to imagine something, I don't even know what you would point to in this case, because they've not even suggested anything that could be premeditation at all. So anyway.
In fact, accidental drowning.
Yeah, I don't know.
The court
very unusual.
discussed in reference to this case and others, the absence of history. In the Serrano case,
and like,
as I said,
do you know what state this was from? Because like, for example, just recently we were reading over the Florida statutes, and like what it says there, because we went over it, is that the judge can overrule the jury if it means that if the jury finds death, the judge can overrule the jury to say, no, it's going to be LWOP, but it can't go the other way around. So like what we see here, and it could be that this was before, they might have changed something in the legislation. I don't know. But yeah, in Florida, that's the current standard. Like the judge cannot overrule the jury and give death if the jury goes with life.
A while ago, there was a history of bad blood, lawsuits, physical threats, physical confrontation, expulsions, lockout, execution, shootings, millions of dollars involved. Now, in this case, there is not any evidence of anything other than a caring and loving mother-child relationship. There is no confession. There is nothing but the circumstances that the state is trying to expand into some proof. As with yesterday, a piece of cardboard was found in the vicinity of the body, 9 or 10 feet away, as I recall the testimony of Dr. Michael Warren, anthropologist from the University of Florida.
Yes.
And that had a heart-shaped emblem stuck on that piece of cardboard. Nothing like anything related to this crime scene specifically. Remember, let us not get confused about what may be nothing more than media hype or whatever. The only evidence related to anything to do with a heart shape was the testimony of Miss Fontaine, if I recall, from the FBI, saying she had observed an image of a partial similar heart shape on the edge of duct tape, but somehow, poof,
yes,
they couldn't photograph it in the FBI crime lab at Quantico, Virginia. So,
so good.
We have no evidence then that connects that circumstance. The only
Wait for it when he gets to the duct tape.
evidence that we have about duct tape is severely questionable.
Here it is.
Was it on the hair that when the
This is maybe one of my favorite parts.
decomposition occurred, and it would have been identified appropriately as slippage, but that the hair mat fell down and therefore positioned the tape near the mouth,
Love how he says near the mouth.
in the vicinity of the mouth.
Yes,
And the only person
here.
shown to have had access to, use of, familiarity with the subject duct tape, unfortunately, was the grandfather.
I'm clapping. It gives me goosebumps because that is it right there. This duct tape is like the whole case, and it just, thank you for saying what we're all thinking. Thank you for saying what we're all thinking. And what I'm also thinking is two things. How is the state not sitting there like, oh my God, we need it. We're like, how are they not hiding their heads? Like, I'm going to go live in a cave now. Bye-bye. And then also, how is Judge Belvin not hearing this? And like, yeah, no kidding. Let me fix this mistake. Go home. You know, that's what I'm like. And you know what's so crazy? He's not even saying all of the problems. I pointed out, like, there are so many more problems that we would be here for a year if he fully went through all the problems in the state's case. So he's highlighting the most, maybe, or some of the most significant issues here in terms of the evidence. But the delivery, I just think this is so brilliant.
Testimony yesterday from the grandmother. Now, since I have a moment of your attention on this, I want to direct my thoughts to some of the case law that has been provided to me by the state of Florida.
One question before you proceed to that. You've mentioned accidental death, correct?
Yes, sir.
What record evidence is there of an accidental death that the court can look at that's in the record?
As of this point, there is no record evidence of accidental death. There is no exclusion, however, of the reasonable hypothesis
and
of
that's
accidental.
That's an important distinction. Now, remember, Cindy testified all the stuff about the pool, but again, the record evidence would have to like show that something happened in the pool, and it's circumstantial. Now, you gotta love, I'm being sarcastic when I say you gotta love, how the circumstantial evidence is enough to convict someone and send them to the death chamber or death row, right? But it's not good enough to also include another completely reasonable hypothesis, right? Like, it's not enough. Like, they're saying, oh, we can exclude the swimming pool because we have circumstantial evidence as to something else. Honestly, they don't, but they're saying they do, right? but it doesn't work the other way around, which that's nonsense. However, what he's saying, he knows the case law, because he's saying, he's not being tricked. He's like, I know there's no record evidence, but that doesn't matter. Because, like, here, let me back it up. This is really important. He's making an important distinction here.
It's in the record.
As of this point, there is no record evidence of accidental death. There is no exclusion, however, of the reasonable hypothesis of accidental death that was suggested and was the basis of some of your rulings, sidebar. And remember, the state has the burden, not the defense.
Okay.
Yeah. So remember, all the case law he's been studying so far, that's why he's been using this, right? It's very important. So he's bringing up things that talk about where it's holdings where they say, it's all about, did you exclude the reasonable hypothesis, right? Of something else. And that's the thing. So it's like, we're not at the part where we have to show there's evidence of it. It's just, it can't be excluded as a reasonable hypothesis. So It's like the difference of like evidence of versus there's not evidence it didn't happen type of thing, I guess, if you could say it that way.
State of Florida has cited a case of Law v. State 559 Southern 2nd 187, a 1989 Florida Supreme Court case. In that particular case, the facts and the establishment of the cause of death was not in dispute. The court found that each and every claim asserted by the defendant was contradicted by some testimony presented at trial, either by experts or other witnesses. The main variance in that case, and there can be, I suspect that if it were to be a contest of who can burn up the LexisNexis or Westlaw the most and find a plethora of cases and separate factual deals, that all of the cases relied upon by the state, there is no mystery as to the cause of death at all.
Wow.
They cite the case of Darling v. State, which has some interesting holdings in it that are referenced in the cases that I really provided to you. Well, in this case, the victim had been shot in the head, sexually assaulted, fingerprint was connected to the defendant, DNA evidence related to the sexual assault was admitted. The court, in denying that the trial court had failed or had erred in not granting a judgment of acquittal, found that the defense apparently propounded of some consensual sex had not been established at all, and that there was ample physical and forensic evidence of forcible sex. The cause of death, again, was clear, which is not only not clear in our case, it doesn't exist in our case.
Yes.
And they refer also to a Reynolds.
This is such a strong argument. And actually, what he just said is that he's look at all these cases he's showing where it's like they have all these things and even still. And the thing that he just said is that there was the case that went it was reversed on appeal because the trial court failed to grant the judgment of acquittal, which is exactly the circumstance they're in here. Now, here's the thing. None of this, the thing is like, we didn't get to see the fallout of this case because she was acquitted. I mean, in terms of the law, right? She's still considered the most hated woman in America, and I'm sure she gets death threats every day, and that makes me disgusted. But in other words, had the jury convicted her, right? I'm sure the general public would have been like cheering and whatever, which is just disgusting. But I'll tell you what would have happened. The fallout of that would have been a sight to see, right? Because if ever there's a time for the appellate courts to like, I mean, I can only imagine, right? I mean, but this motion for a directed verdict that we're watching right now, it's almost like he was foreshadowing because this happened in this other case, and he's saying, and it's like, I think that's what would have happened here. If they didn't find something else sooner, it would have been reversed. And then this trial would have become case law for subsequent cases, and it would be, yeah. So, it's interesting to think about. But it's just unfortunate in a way that we just didn't get all that, what we could have, the case law that could have, happened, or, appellate courts, it's just none of that happened because of the fact that she was acquitted, which is awesome. Right. But it would have been interesting to see how much this would have been ripped apart, I think, to be honest.
Reynolds case 934 Southern 2nd 1128. That particular case, the defendant was convicted of 2 counts of capital murder, second-degree murder, and burglary of a dwelling. They determined that much of the evidence could not be deemed wholly circumstantial. Confession to a cellmate, eyewitness testimony, prior history of dispute, DNA evidence, substantially different. And of course, the Serrano case I've already mentioned to you. The cases that Ms. Burdick provided this morning, I've not had a chance to digest, but I did scan them while we were waiting. And it appeared, again, that there, in each of those cases, was no question as to the cause of death. And therefore, the major concern of circumstantial evidence rule related to the principal issue could not really exist. In our case, there's no other way than circumstantial evidence. Circumstantial evidence, by the way, of what? How was this child killed? Where was this child killed? Was she killed at all?
Scare quotes.
Or was
Love
it an accidental death?
Love the scare quotes.
Now, I submit to you, Your Honor, I know you're burdened. I know the circumstances, as you well know, not my first time. Trying murder cases for 40 years.
Wow. Not many people
The
can
fact
say
of the
that.
matter is,
Dude, imagine that. Imagine that. I've been trying murder cases for 40 years. What a G. Dude.
there's no evidence of the main things that have to be. All the suspicion in the world, all the could haves, the probablys, the may haves, which was the quality of the testimony we heard from every single expert witness. Could have, may have, might have been. We have no evidence to exclude a reasonable hypothesis that there was no murder at all, that there was no premeditation, there's no history to suggest culpable negligence, there's no history in this case to establish any basis of aggravated abuse, and counts 1, 2, and 3 are not just ripe for, but screaming loudly and demanding judgments of acquittal in accordance with all of the authority that I presented to you and that the state of Florida has presented to you. Thank you very much.
Thank you, Mr. Mason.
Bravo, Mr. Mason, bravo.
State.
All right. Great.
Good morning, Your Honor.
I would rather
As
get a root canal or stab myself in the eye with a pen than listen to her. I mean, pretty much.
the court so succinctly stated yesterday, the law is the law.
So this is where, as we were talking about the other day, where I find her really annoying, like nails on a chalkboard. This is where now it's a different type of, I say hate. I'm not serious. I don't actually hate her, but this is where I can't stand her in a different way because this is just so offensive. So she goes from usually it's with witnesses, she's dumb and she's just annoying. And it's what are you doing? And inept, I would say inept, very much inept. But now it's this is just offensive to me.
And while a great portion of defense counsel's argument dealt with a recitation of what the law is, he spent the majority of it trying to distinguish specific facts of cases and comparing them to the unique facts and circumstances of this case. The cases that I had provided to the court the other day were not provided because they were factually similar, but because they quite clearly stated what I presume and believe the court and counsel already know, that at this stage of the proceedings, all inferences to be drawn from the evidence must be resolved in favor of the state of Florida. In fact, that the defense.
So here's the thing. So when I was editing this video and I was like, what is she going to say? Because honestly, what are you going to say? And I know that that's the standard. I know that that's the standard. But at this point, you have to go with the light most favorable to the state, right? But I was like, oh my God, is that what she's going to do? Is she literally going to just basically, is she not going to address any of the issues that he raised? Is she going to just provide case law one after another that says the same thing, which is you have to look at it in the light most favorable to the state? Is that what she's going to do? Let's see.
Defendant admits all of the facts and inferences to be drawn from the evidence that has been presented. The reason Serrano, a recent opinion by the Florida Supreme Court, was included in the case packet was for the proposition under the law that the state is not required to rebut conclusively every possible variation of events which could be inferred from the evidence, but only to introduce competent evidence inconsistent with the defendant's theory of events. In Serrano, the defendant's theory of innocence was an alibi. The state, in that case, presented ample evidence to establish that Mr. Serrano's alibi was lacking. In this situation,
I feel like, did you see how she said that? Like being so condescending and dismissive of like a person she doesn't even know, a case. Like, I don't know who that person is. I don't know who that case is. But the way that she said that is so disgusting to me. Like, that's like the way you would try to do it at like a closing argument when you're in front of a jury to like in your own case, right? But to make that comment about some other case, like, you gotta be kidding me.
Record evidence of a defense in the form of Ms. Anthony's statements to family, friends, and law enforcement was that an individual by the name of Zenaida Gonzalez kidnapped her child. And at that point, she had no contact with the child and obviously did not know what happened to the child. The evidence in this case has conclusively rebutted that hypothesis of innocence. Now, the suggestion in opening statement that there was some sort of accidental theory to be propounded at some juncture is exactly what I would argue Serrano is designed to avoid, that this is a possible variation of events that the state does not have to conclusively rebut. However, if the court accepts that the argument, or even perhaps some of the cross-examination of the witnesses, establishes that accident is a possibility. In this case, Dr. Garavaglia has stated unequivocally that this was not an accident. The suggested witness to this accident and its aftermath, Mr. George Anthony, has conclusively rebutted this hypothesis.
See, this is where, for me, can you see why? Can you see why I've said what I said? The fact that how do you even do this with a straight face? Honestly, how with a straight face do you sit there and be like, Mr. George Anthony has rebutted, like as if he's like, it just blows. You know what it would be like? It'd be like in Karen Reed, if in their closing arguments, Lolly was like, here's the best thing we can say. It's like, Michael Proctor, and then blah, blah, blah. And like, as if that's like their whole case, like right there. Or like, I don't know, pick any of them, I guess, it's like, I don't know. I honestly feel like that's not even a good enough example, because I feel like George, I can't even think of a comparable thing to George, because George is like just an absolute utter disaster in every way, and in ways that are different than we usually see. Like, I think even more so than like the McCabe's, I think George screams, I don't know. It's just, there's just everything's off about him. He had even if you just look at like the contradictions, right? Or like lying. There's no comparison if you were to do a count of George versus like the McCabe's. There's no comparison. George just takes the prize for like the biggest disaster ever to take the stand, honestly.
Hypothesis that at the judgment of acquittal stage, the defendant is proposing the court accept.
Somewhat helpful for anything other than the defense.
I would ask the court to turn its attention to a case that I admittedly did provide this morning in some follow-up research that I had done yesterday. That's the case of Jackson versus State, found at 25 Southern 3rd, 518. An opinion of the Florida Supreme Court from 2010 out of Volusia County. In that case, it's on page 17 of the printout.
Right?
I can't.
You know what else dawned on me tonight? that like, you know, because I'm still, of course, there's other things I'm like Carrie Reed, for example, still covering because it's like there's still things happening. But in terms of things that are like I'm in the middle of like, I guess, pre-trial or like we're watching the trial, right? Like right now, the three things that are getting the most coverage just because of their situations. You know what else is wild? That they're all death penalty cases. That's another thing. So that's so interesting is like, I feel like it's not planned, right? But like, but yeah, that's another funny thing about, right? You got two bias cases streaming at the same time. I know, right? I love it. Yeah. And I mean, it's wild because I'm just like, again, it wasn't planned, but I'm kind of becoming like quite well-versed in how it all works with the death penalty. And, you know, there's just very specific stuff that goes along with that. And, you know, anyway, I guess in a way it's a good thing, right? Because it's like, again, I feel like I already have so much knowledge going into like the Shannon Gardner case, just because, you know, it was really, you know, Chad Daybell, I guess I kind of started delving into it with that. Well, I mean, I already knew about it, right? But in terms of really covering stuff related to it. But then the big one was, of course, BK, because there were so many motions filed there. And you guys know. So.
Quickly tell you on what page of the opinion it is. I believe it's at 532.
In Florida.
The defense challenged that the state did not present sufficient evidence that the victim died based on the criminal agency of another. In that circumstance, Dr. Beaver, who was the medical examiner in Volusia County, in that judicial circuit, testified that because the body was badly decomposed, he was unable to perform a normal autopsy but examined remaining tissue and bones. He was unable to find a definitive injury to the victim and classified the victim's death as homicidal violence of undetermined etiology, which is almost identical to the verbiage used by Dr. Garavaglia.
Yeah, but see, here's your problem, though. Did Dr. Beaver also say he believed in his findings by a preponderance of the evidence? Because I highly doubt that.
In this case, homicide by undetermined means. There were a multitude of possibilities, hypotheses of innocence that were propounded in that circumstance by the defense, all of which were rebutted by Dr. Beaver, who, according to the opinion throughout his testimony, stressed that his opinion was based on his significant experience as a medical examiner, as well as the characteristics of the grave site, information he learned about the victim, and common sense. The opinion goes on to state that the credibility and weight to be given that testimony.
You know what pisses me off too? So far, no one's even commented on the fact that Dr. G said 3 times that Caylee was found in the middle of a field. I don't know. I think that what happened probably is people did so initially I was just confused. I kept thinking she was like just giving some sort of example, but not talking about this case. But I realized when I was doing that recap, like whatever, 2 episodes ago, I realized she was talking about this case because she mentions the trash bag. She's talking about the facts of this case. And so she says it 3 times. I think that people must think, oh, she must be talking about something else because it's so completely opposite. Like it blows my mind because the wooded area is the whole thing. The roots and the vines, right? And then how much water was around. She said in the middle of an open field. So, but no one's mentioned that yet. Blows my mind. I mean, what?
Evidence or determinations for the jury. It is our position that a reasonable jury in this case can conclude that Caylee Marie Anthony died as a result of the application of 3 pieces of duct tape to her nose and mouth.
Okay.
That a reasonable jury can conclude that Caylee.
Here's where I lose it. Let me rewind that. Why are you misinformationing right now? That's where my brain can't even compute. Why are you misinformationing? Listen to this, guys.
Ability and weight to be given that testimony and that evidence or determinations for the jury. It is our position that a reasonable jury in this case can conclude that Caylee Marie Anthony died as a result of the application of 3 pieces of duct tape to her nose and mouth.
I don't even have words. I don't know how you even say stuff like this and then not get, I don't even know. I don't even know what first out of the courtroom, right? I mean, because it was only 1 piece of duct tape. And you know how many pieces of duct tape were on the nose and mouth? 0.
That a reasonable jury can conclude
the fact that this is the government representing the government and they have the power to take your life away and they can just blatantly lie. Do you see why I get so upset?
Caylee Marie Anthony died as a result of poisoning by chloroform.
There was no evidence of that. Stop. There was no evidence.
That a reasonable.
There's no evidence. I don't understand what is happening because the toxicology showed no chloroform, no Xanax, no poisons, no drugs of any kind. A
reasonable jury can conclude that Caylee Marie Anthony died as a result of the combination of the two based on the evidence.
So what she's saying, okay. It's like, so, just in case you think either or both of our suggestions are shitty enough, don't forget, you can combine the two and see if maybe you've got like an F- over here and an F- over here. She's like trying to suggest that you can combine them and get like a C+ or something, which that doesn't even make sense. But never mind that. If you have to compare beyond a reasonable doubt to a grade, it's like A+++++. And she's like, take F- and add another F- and you get A+++++. Sorry, I don't think you know how to do math.
That was discovered in the trunk and the evidence connected with how her remains were discovered. It is our position that a reasonable jury can conclude that the relationship between the parties in this case, specifically Mrs. Anthony and her daughter Casey, could provide or did provide a motive for Casey Anthony to eliminate the child.
What? What are you talking about?
It is our position that a reasonable jury can conclude that.
Idiot. I don't. There's no evidence that has come in. Okay. There's no evidence that's come in about that. There was some talking. Okay. There was mentioning in the Orange County Sheriff's Office investigative report, not about Casey, okay, but about her mom. What was in that report was that Cindy said Casey was jealous of her. Not Casey said it. Cindy said it. Cindy told them that she thought Casey was jealous of her, but Casey didn't say that. Second of all, that was only in the sheriff's report, and that has not come in at trial, ma'am.
Ms. Anthony began preparations for the elimination of
You can't just invent and make up premeditation.
The child as early as March of 2008, when she conducted computer searches for how to make chloroform.
Stop it. Dude, this is the thing. So that's what it is. Remember the question I had? Where I was like, I don't even know what I could think of if I tried about premeditation. Their premeditation is the searches for chloroform. You've got to be kidding me. That's it? When we saw that, remember, it was a total combined of 13 seconds or something? And it was proven through the testimony of their expert that the tabs refreshing in the background could have made it look like it was that many searches, and that's why it was 76 searches, but only totaled 13 seconds or something ridiculous like that. But the page was only viewed once, and that when it was viewed, it was right after she got that picture from what's his face, her ex-boyfriend on I almost said Instagram, on MySpace, and it had the picture, and it was killer with chloroform or whatever it said. It had that picture. You guys have seen it. And then right after that, that was when it first started searching. I have no words. That's your premeditation?
And other means of weapons and how to create injury.
Also, hang on. The logical next question is, if you think that she was killed with chloroform, and if you think that anyone was looking up how to make, I don't even care who, it could be George, it could be anybody, think someone was making up how to make, then what you're saying is someone looked up how to make chloroform, learned how to make it, made it, and used that to kill somebody? You know what's crazy is we're missing all those middle steps, right? They've somehow conveniently left out if someone's looking up how to make chloroform, right? And then someone dies from chloroform. Well, where is the parts? Where are you showing that they bought the equipment? Where are you showing that they actually made it? How are you showing it's even possible? Because I looked it up actually, and I don't think it's possible to make it home. So like if someone, like, okay, let's just say that someone even wanted to do that. Let's just say that somebody wanted to kill someone with chloroform, but they really wanted to make it homemade, and they Googled up how to make it. You know what they would learn? You can't make it at home. That's what they would learn. So then I don't understand. Because then the next thing you should be looking for if you're the state is a purchase of chloroform, right? Like a purchase of chloroform because they learned they couldn't make it at home. Like I can try to fill in the blanks of how this could look if someone was actually doing any of this, right? They would try to figure out how to make it. Okay, they look and they're like, okay, yeah, you can't be, you would see a subsequent Google search, right? We didn't see any of this. You would see a subsequent Google search for whatever the chemicals are, whatever the type of machine or equipment. You would see Google searches for that. Is it legal? Can I purchase it? How big is it? How much does it cost? You would see that shit. And then you would either see them buying those things or you would see them seeing, oh, wait, that's not possible. And then you would see them doing another search for where can I buy chloroform? This is what, you guys see what I mean? I can't.
Jackson goes on to state,
I know
that the state does not need
that she is just the worst, right? Like she's just the worst.
Need to present evidence proving the exact manner of the victim's death or the location of the murder, citing Crane versus State, found at 894 Southern 2nd, page 50.
Here's the thing. Despite the fact that there's no evidence of any chloroform in terms of the death or any of that, right? Because it was all completely insignificant. All of that came out from the experts when it was on cross-examination, of course, right? Even if you say, okay, fine, let's pretend in an alternate universe that they did the toxicology and they found chloroform. Let's just say that happened. If you're trying to say that your theory of premeditation is that they made a search for how to make chloroform, and then after that, there's no evidence that they actually made it, how do you tie that person to the body, even if that body tests for positive for chloroform, which it didn't? Like how, like someone can Google anything. I Google how to do stuff all the time. It doesn't mean I'm going to do it. It's just, I just don't know how you get around what's missing, right? Because if you're like, in other words, if you're trying to say someone did intend to make it, they Googled it, that's my point. She's saying that Google search was made because someone was intending to make chloroform, but there's no evidence that anyone made any chloroform or even tried to make it or even looked into making it. Even if you could prove, which you can't, that chloroform was involved in the death. I'm going to lose it.
54, Florida Supreme Court case from 2004, which affirmed a murder conviction based on circumstantial evidence, despite the fact the state did not establish how the murder occurred or even present the body of the victim. The only real issue as it relates to the judgment of acquittal at this stage has to do with the case of Brooks versus State. The defense presented only that case to the court, although it is apparent from the questioning that the court is familiar with the litigation that has ensued as a result of the Brooks opinion, which was issued in 2005 by the Florida Supreme Court. The first that I could find pronouncement as it related to Brooks actually came out of the 5th District Court of Appeals in 2006 in the case of Dorsey versus State, which is at 942 Southern 2nd, 983. In that case, Dorsey does not address whether or not the language regarding the merger doctrine between aggravated child abuse and first-degree murder would require a judgment of acquittal on the felony murder theory. In Dorsey, the 5th District Court of Appeals questioned whether or not shaking, in that circumstance, shaking a child to death could ever be considered a single instantaneous act. The act, of course, in Brooks that was under consideration was the stabbing, a single stab wound to an infant. And the 5th District Court of Appeals distinguished Brooks on the basis that the mechanism required that did result in...
Mr. George, it's probably Mr. George. It has to be Mr. George, because it's got to be Mr. George. I like Mr. George also. I really do. And, he's not in with them, right? These two, Mr. Ashton and Mr. Drane-Burdick, they stuck together like glue. They're cronies, right? Mr. George is the nice one who's not shitty. And, I actually was talking about him earlier. But, yeah, he seems like a good dude. He's not trying to be shady. Yeah.
The death of the child in Dorsey was something that was more than a single instantaneous act. The court had mentioned Amanda Lewis.
I think she's almost done. And then there's a really short rebuttal, really short but very powerful rebuttal from Mr. Mason. And then there's the judge's ruling. And so this is that'll be the end. This will close out the episode, because we're going to start fresh with so the next episode is called The Defense's Case in Chief. So we're going to begin the defense's case in chief on the next one. But also, I'm glad I said that, because I wanted to ask you guys. So let me just tell you this. If you had to try to guess who the defense, don't look it up. If you had to try to guess who the defense's first witnesses of the entire case in chief, who would you guess? And let me give you a hint. The reason I'm saying that is because it's not some person we don't know. It is someone who has already testified for the state many times. Okay. Now I know that doesn't narrow it down. It's everyone that testifies like a bazillion times, right? So it's somebody, it's somebody we know, somebody you guys know. They've already testified. Okay. So if you had to try to guess, you have some time to think about it. Who do you think they call as their first witness without looking it up?
Which came out of the 1st District Court of Appeals in May of 2010. In that case, Ms. Lewis was convicted of drowning her daughter by holding her under the water.
She said drowning. Well, that proves my point right there. What more needs to be said? She said drowning. Let's hear that again. Drowning. Right there.
Which came out of the 1st District Court of Appeals in May of 2010. In that case, Ms. Lewis was convicted of drowning her daughter.
Yeah, the D is there. It's not my imagination. She said drowning. Good guess. That's a really good guess. It's not Lee Anthony. So but that's a really good guess. So you might, you feel free to guess again. There's no limit, no statute of limitations, or no limit. But yeah, drowning.
By holding her under the water in a swimming pool. And again, this is where the 1st District Court of Appeals has indicated that the language in Brooks was dicta, not essential to the conclusion, and therefore they weren't going to apply it, and also questioned whether the act of holding the child under the water was a single act of aggravated child abuse. What's interesting is that subsequent to Lewis in Sturtevant, which is, I only have the Florida Law Weekly site, 35 Florida Law Weekly.
Why are you not
D
prepared?
1993, a decision of the 1st District Court of Appeals in September of 2010.
Another good guess. I'll give you a hint. It's someone from law enforcement. Okay, just right there, though, right? The defense starts by their case in chief, not just by calling one of the state's key witnesses, but a member of law enforcement. What does that say? You don't ever see that. You don't ever see that in a trial. That's a powerful statement.
Conflicts. The panels in the 1st District Court of Appeal conflict with each other as to whether or not the language in Brooks is in fact dicta. Appended to the opinions in both Lewis and Sturtevant, I attached.
If I could, I wish I could just go and just be like Mr. Baez's what's the right word? apprentice, like it's like a teacher, but like back in the day they would do that, right? Where you go and you like live with your teacher and you like learn everything with them, and you do and it's like you learn all their wisdom, right? And you're just like doing all the things, and it's like back in the day they used to do that, right? I think they call it apprentice, yeah. It was like that with violin makers back in the day, for example. But I would just apprentice. I'd be like, wherever you go, I go. Yep, and I want to learn everything I can from you. Like, that's what I would do.
The minutes as of last evening.
Another good guess, but not him.
Released the docket minutes from the Florida Supreme Court as to the status.
I'll give another hint. It's somebody, this doesn't really narrow it down that much either. Someone who Miss Drane-Burdick had trouble pronouncing their name.
Of both of those appeals. Lewis is on hold pending resolution of the matter in Sturtevant. The last entry in the docket has to do with the reply brief, which is dated 2/1 of 2011. The other opinions dealing with this subject, again, coming out of the first district, is Lim versus State, LIM, found at 50 Southern 3rd, 34, which is a First District Court of Appeals case from December of 2010, where regardless of the language in Brooks, they indicate that the multiple events surrounding the victim's death would take it out of the holding in Brooks. Similarly, the Second District Court of Appeal in Rosa versus State, which was a case out of Hillsborough County. The opinion is dated March 2nd, 2011, cited at 58 Southern 3rd, 900, that more than one hold or grip on the victim during a single act of abuse or of strangulation. The holds during the strangulation did not constitute a single act of abuse. Therefore, it is our argument to this court that
I don't even know what her point is here. She's giving examples of case law that I understand. I understand the issue, right? In terms of like that is a good legal issue of like, if you shake a baby, right? Is each shake or whatever, I get it. And which, by the way, you get used to thinking like that if you listen to oral argument from the Supreme Court, which I'm thinking about maybe covering at some point too sometimes. But anyway, it's like those types of issues, right? Where it's not really fact-based in terms of the case. It's like, it's more like, it's really more philosophical, which I love. But I don't know how that applies here. Like, how does that apply here? Are you saying that I just don't understand how that applies. We'll see.
Since a reasonable jury can conclude that Caylee Marie Anthony's death was caused by the application of multiple.
No, she's not. You guys, no. I had to stop it because if you recall, I know I told you guys when I was editing this, I was so moved. It was great. I was like so moved by Mr. Mason. And then I was trying to edit this and I couldn't listen to all of it because it literally, I couldn't. And I did not hear this part. I'm going, hold on. Let me back the question I just asked, right? I'm like, how is this relevant? How is this related? If just when you think she can't stoop any lower, I'm going to lose my mind.
Therefore, it is our argument to this court that since a reasonable jury can conclude that Caylee Marie Anthony's death was caused by the application of multiple pieces of duct tape, which obstructed her airway, both her mouth and her nose, based on the evidence presented in this case, that would not.
She said based on the evidence. The evidence is that there was nothing on her face, her mouth, or nose, and the evidence is that is one piece. And you know what? That's so fucked up, right? Because again, the two pieces were 7 feet away, and that you would like, if you're going to make this argument, it still falls flat because it wasn't on her nose and mouth. That's what the evidence showed from your people. I can't. But then to try to say, because you want to be able to say it was multiple instances, you're saying that all three, you can't just make things up. You know what she would have been better off? She would have been better off making it up that the one piece of duct tape was stuck on, pulled off, stuck on, pulled off, stuck on. At least then you've got the one piece of duct tape, even though it's still going to be in the wrong place because it's not found on his mouth, whatever. Anyway, but if you were to argue that stuck on, pulled off, stuck on, pulled off, because we, you know, that is a better made up scenario. Because because here at least there's no evidence to disprove that, right? Whereas there is evidence to disprove the three pieces. We've already seen it, you guys.
Constitute a single act of abuse under the theories espoused by the various district courts of appeal in this state, and therefore the aggravated child abuse does not merge into the homicide and preclude us from the application of the felony murder rule, either as it relates to the application of the duct tape or the administration of a poison to the child for whatever purpose. The other issue for the court's consideration.
What poison? No poison was found. A Google search after getting a picture that says chloroform in it does not mean you can't just then the leaps that you have to have. You guys, the leaps you have to go from the Google search that really was like probably one search, right? And again, the tab refreshing, right? We heard about all that. Like the leap to go from that one search to someone died from being poisoned. It's my poor goat is going to die of exhaustion. I don't even know. For anyone who's just now joining us, we're at the end of the state's argument for their motion, the motion for directed verdict, and then we have the defense rebuttal.
Consideration as it relates to the judgment of acquittal has to do with the issue, admittedly, of premeditation. I've touched upon this very briefly, and I will not belabor the point, but at this juncture, resolving all inferences in favor of the state, the question is whether or not there is substantial competent evidence from which a jury could conclude that Ms. Anthony, based on her computer searches, based on the manner in which the evidence establishes that the child died,
you know what else,
whether that can be.
You know what else? George's work records prove he was out of work that month, and all of those searches could have been him. By the way, let's just not forget that part. All of those searches could have been done by him.
Concluded conclusively by the medical examiner that this was.
If those searches are enough to charge her with first-degree murder and seek the death penalty, then how come it's not enough to do it with George?
An intentional act by the defendant designed to cause the child's death. That there is no fixed period of time that must pass, despite earlier evidence of computer searches, but that when Ms. Anthony decided to place duct tape on the child's face, not one application,
at least
not
face
two,
isn't technically incorrect because the chin is on the face.
But three,
stop, ma'am.
that sufficient time had passed for her to understand the nature and quality of that act, and that premeditation has been established as a
I would love
result.
to destroy her in a debate, dude.
Therefore, we would ask the court to deny the motion for judgment of acquittal as it relates to all counts of the indictment.
And I thank the state for pointing out some of the depth of the errors. Let's start.
Yes.
If I heard correctly,
over it because he's fired up. I don't know how he, like, as you guys can see, it's tough. Let me just make sure we can hear what he's saying. And this is short but very powerful. So let me just go to the right before. Okay, that's fine.
Asked for her to understand the nature and quality of that act, and that premeditation has been established as a result.
No. I'm premeditating.
Therefore, we would ask the court to deny the motion for judgment of acquittal as it relates to all counts of the indictment.
And I thank the state for pointing out some of the depth of the errors. Let's start.
Fuck yeah.
If I heard correctly, the state is suggesting that they have presented evidence to overcome the motions here by talking about poisoning by chloroform. Now, I realize my hearing disabilities are such, but I don't believe there was any evidence whatsoever of poisoning by chloroform.
No!
In fact,
Sir!
Dr. Garavaglia acknowledged, if I recall, that the issue of chloroform had to do with the claim that there had been detectable chloroform traces from decomposition, and that she in fact employed the services of Dr. Bruce Goldberg from Gainesville, a toxicologist PhD, who said that every test they knew how to do scientifically was done to try to fit that square peg in a round hole, and they couldn't do it because there was no chloroform related to the death of this child at all.
Yes, sir.
The duct tape issue,
Thanks, Josh, man.
we established it despite suspicions and arguments.
Oh, boy.
The duct tape had not been wound around this child's head at all. And all prior reports and suspicions of that were bogus. There were 2 pieces of duct tape found, one attached to some hair, the other one attached to it, and a third piece 9 or 10 feet away. It is a stacking impermissibly of inferences and suspicion on suspicion to suggest, first of all, that it had anything to do with the cause of death.
Yep.
And as important, that anything it had to do with Casey Marie Anthony. There is no evidence of that. You can't even guess that far. There's no fingerprints, there's no admission, there's no witness, there's no possession, there's no utilization. The only use of duct tape evidence in this case was George Anthony putting some over a breather valve on a gas can, which sits right there in evidence.
Thank you.
And that there was similar duct tape on a command center flyer looking for a missing child.
Thank you.
The only person having that
Thank you.
was not this defendant.
Thank you. I feel better.
She mentions computer searches.
Yeah.
Well, the only evidence computer searches seem to have been.
He's making all the points I was making. It's so funny. I see. I it's hard. I'm like, I should have just remembered. Don't worry, he'll handle it. But like, it's funny. He's saying all the same things.
On unrelated issues of self-defense and prior to any relevant times. You can reconsider that yourself. More importantly, though, I want to talk to you just a little bit about some case law handed up this morning. And, you know, with the advantages of another volunteer, my colleague Elizabeth Fryer, reading these while we were talking and giving me notes. And then I was able to grab this Jackson case. What a world of difference. In that case, the medical examiner did not say that his opinion was based on a preponderance of the evidence, an improper standard, like Dr. Garavaglia did. Further, the evidence was that was a drug deal, a kidnapping, prior threats, and a shooting. That has nothing to do with our case. In reading the notes as to each one of the cases they cited, if the court will please do that when you review this. Abdul versus State case cited by the state at 53 Southern 3rd 208. 3 witnesses testified that the defendant spoke of and planning to kill the victim on the night of the crime and went and got, interestingly enough, duct tape, a gas can, and gasoline, which were used to kill the victim.
Oh, man.
Doused with gasoline and lit on fire. Norton versus State, they cited 709 Southern 2nd 87. Gunshot wound to the back of the victim's head. And by the way, that wasn't sufficient to establish premeditated murder.
Wow.
But it goes to point is how distinctive are these authorities from the weakness of the evidence that we have in this case.
Oh, look at that view. Wow.
If you look at these cases, I've gone through every one of them.
We never get this view. Let's pause. Look at all that evidence. Wow. Oh, you can see Mr. Baez over there. Wow, how cool to get this view. Flashman says he should have been her defense attorney. Well, I don't know that anyone could have done better than Mr. Baez. I mean, he's just, I mean, dude. Again, obviously you can see why it's so impressive to me how he keeps his cool, because it is hard with the state in this case. It is hard. And, you know, I think there's been times where, like, I've noticed the camera, like at times where, you know, it's zoomed in and it's like Mr. Ashton's making a face. Like there's that specific one. Anyway, but it's funny because there's been times where essentially, you know, camera will like show the state, and Mr. George seems to look kind of like, what's the right word? Like he sees that this was wrong and he's like, you know, I don't know, what's the right word? Shame, maybe, I guess, or maybe guilt or sadness. Anyway, you know, in other words, even just to be associated with them and sitting at their table, he's probably like, I want to go sit at the other table. Yeah, you know, it's so funny because as I've talked about how I've always loved law and stuff, you know, it's so funny because I really would have thought, I don't know, I couldn't put an exact time limit on it, but maybe a year or two ago even, right? I would have probably thought I would want to be a prosecutor, or like that's where I would excel, you know, or that's where like that, you know. But I'll tell you what, that's changed for me. Like mostly just because I think it's really because I guess it's like the importance of strong defense attorneys for so many reasons. The list I won't go into because you guys have heard it before in different situations, but it serves such a bigger purpose, you know? But the only thing is that, you know, you have to get used to losing because they usually lose. And by losing, what I mean is, I don't mean losing. What I mean is seeing your client get convicted and maybe even like, you know, life sentence or death, God forbid. I don't know how I'd handle that. You know, again, it's like, I don't know how these people do it. I feel like I'm almost setting myself up in that direction because of the fact that I'm covering all these death penalty cases and I'm really passionate about it. And I don't know, but I don't know how you handle that. You know, but it's just got to be so hard, right? To see people, you know, like I always think about how like I would love to be a defense attorney where I get every client acquitted, you know what I mean? But like it's not possible. And anyway, but all right, we're almost to the end. Let's keep going. Come on, StreamYard. Come on.
Briefly as I can here.
Yeah.
I mean, then go to this concern about this merger doctrine. I know what Lewis says. Somehow, without evidence, without basis, there's a suggestion that in that case, the drowning by holding the victim under the water was more than one act. That's speculation. There's no evidence of that.
Even I said
in
how.
That case.
I even said the same thing.
How in the world? I mean, I know that bad cases don't make good law and all that routine, but don't tell me that there's evidence that mother in that case was repeatedly dunking this child. There's no evidence that somebody made a conclusion. In our case, there has been no evidence presented that Casey Marie Anthony used duct tape for any purpose, that she used chloroform ever for any purpose, and that in any way or any capacity whatsoever she contributed to the cause of death of this child. It is forcing, guessing, and speculation, and not in this country.
Yes, that's it. That's the point. That's the point. That's the point. Let's hear that again. That's the point. And that's why this matters. And that's why I get so worked up about it, because that's the point. That's it.
In our case, there has been no evidence presented that Casey Marie Anthony used duct tape for any purpose, that she used chloroform ever for any purpose, and that in any way or any capacity whatsoever she contributed to the cause of death of this child. It is forcing, guessing, and speculation, and not in this country.
Yes.
I ask the court to please take the time to read all these authorities. before you rule. Theirs
Makes me emotional.
and ours.
It really does.
Thank you.
Wow.
Okay, the court will be in recess until.
Really? I mean, it's so important. It's so important. It's so important. And you know what's so shitty is that you know he's going to deny it. I hate that. Like I never had any question about it. I've never seen anything, a motion for directed verdict that is so, I've never seen anything like that. Again, usually it's just going through the motions. I've never seen anything like that. You know, never mind the fact that this case is so weak that you shouldn't have to even try that hard. But like, look at how, I mean, and then even still, the fact that you know he's going to deny it speaks volumes about this court, you know, this judge. I hate to say that. Like, I hate that that's the case. And this is why, if it wasn't for the jury, she would probably be awaiting execution if it wasn't for this jury and her defense team, right? That's the safeguard to making sure people that aren't killed by the government, wrongfully killed by the government, or killed by the government, period. The jury and the defense attorneys are the only thing they're the only thing between the government and killing people. Or locking them up for the rest of their lives. But I think there's a big difference between that and killing people. I mean, well, of course, they think killing people is so bad. It's that the reason they think they should kill them is because they're like, killing people is bad. So that's how bad it is, right? Anyway, it's so bad that we're going to kill you. But think about that. The only thing keeping the government, like between the government and taking someone's life and killing them, it's not the judge. You know, it's not the state, because, you know, justice is only justice if it's fair. And there's times where the prosecution is being fair. There's times, right? And then that's one thing. That is not what we have here. That's not what we have here. And it's the state's job. It's the government's job. They are supposed to be on the side of justice. And it's so messed up when it's like, they're not. They're not. Like the way that's why I got so upset about how they try to sneak that evidence in front of they try to freaking hide things from the jury without publishing it. They didn't want the jury to see that heart sticker. And you know why? It's obvious why, right? If it was a match, they would have wanted them to see it. That shouldn't be happening in this country. Even if you have a solid case, that shouldn't be happening in this country. And if it wasn't for her defense team, and if it wasn't for the jury, she would probably end up executed.
11:15. Just a second. To let both sides know, I have read most of these cases, and I have spent a great deal of time over the weekend researching and reading all the cases, and last evening I have
the Baldwin was different though. The Baldwin ended up being dismissed because of prosecutorial misconduct, essentially, right? The Brady violations. So that's something different, right? Because Carrie Morrissey personally handed him, you know, that was all on her. And then the other, I forget her name, but the other lady, the crime scene tech lady, that was on them fucking up. And yeah, so that's kind of different circumstances. In other words, that dismissal with prejudice was a sanction upon the state in that case. It was a sanction. Like that's why they're like, we're dismissing it and you can't bring it again. It's a sanction on them for their actions. So it's a little bit different. I mean, I guess unless you're saying that could happen here. Is that what you're saying? I mean, it should. It should. I mean, in my opinion, right? It should. But you know, hasn't happened yet.
View
this trial.
The testimony.
I mean, it will be interesting to see because, again, we don't know. During the defense's case in chief, there could still be other issues coming up that the prosecution does, and they could. I don't know. It'll be interesting to see. There's still quite a ways left to go in this trial. The defense has a big case in chief, so who knows? Maybe there will be something when they, have some sort of issue like that. But I mean, we know it doesn't happen if it,
that has been given in this case.
Yeah, Baldwin got lucky.
So we'll be in recess until 11:15.
Well, you could say he got unlucky, right? Because, it sucks that they were trying to, that they were being shitty about, the way they were like, he got unlucky in the sense that the prosecutor, right, Carrie Morrissey, was like being shady and like hiding evidence, withholding, it's Brady, right? Potentially exculpatory evidence. Like that's unlucky, but lucky in the sense that she did it so badly and so blatantly that, that's it, right? And they can't charge her. They can't bring those charges again. So.
Let the record reflect that the defendant is present along with counsel for the defendant. Both the state and the defense have presented their arguments on the issue of the motion for judgment of acquittal. Both the state and the defense cited the case of Serrano versus State,
it's like you already know where this
a
is
March 17, 2011 decision
like you
of
didn't
the
even
Florida Supreme Court.
I mean, I feel like had he thought about it at all, or had he read the case, I just, anyway. And he does actually say a couple times, it might have been in one of the parts that I kind of skipped because I was like, let's get to it. But one thing he says, he's like, I know all these cases, which I don't doubt that, right? He has one thing I'll say about Judge Belvin, he has a great command of the case law. He can actually cite some of it, and I've seen him do it without even looking. Like he knows it verbatim. Like he really does know the case law. But that's one of the things he kept saying is he's like, I know all these cases. So I don't know that he really did go back and read them. And remember, that's why Mr. Mason kept saying, I really hope you go. And he would give him, he was like, go to this page, go to this paragraph and read this one part right here. In other words, he's almost like saying, I know you're not going to read all this, but go read this one thing. So I don't know. Did he read it? I don't know.
Which correctly lays out the standard for motions for judgment of acquittal. There's another case that the court also took in consideration, the case of DeRisso versus State, found that 55-7 3rd edition 543 AD
is he's actually mentions cases that were not cited or provided by either party, which I don't think I've seen. I'm trying to think. I don't know that I've seen that before. If so, it's rare. Because really, they're supposed to use what is provided to them. That's part of the strategy, right? Is that you can find the right case law that's on point. And the thing is that right? I mean, you're really not supposed to, because here's the thing. He can go looking for case law that supports his opinion if it's biased, right? I mean, that's why the parties do it, right? That's why the parties do it, because they're going to look for case law, and then they provide it to the judge. I mean, I can't think of an example where this happens, because this kind of defeats the purpose, right? If he can just go find whatever case law he wants to use, then why would you even, it's like, then that's what you would do. Okay. I could see him doing that when like there's certain decisions where that would be applicable. Like, trying to think, like, it's like when they take it under advisement, right? That type of thing. But that's different than making a ruling in the moment based upon what's presented by the parties in oral argument, right? Like, in other words, the whole point of this, right? So I guess maybe if it's gone for argument or not, I think makes a difference. Because if it's gone for argument, the whole point is you provide the case law and then you make your argument. And if you forget something, you forget a case, too bad, right? That's the whole thing. Like for example, like if there's something that's filed but if it's not contested, if it's not being argued, if there's just like something, I don't know, a legal standard or something, like you would consult whatever. So like he can use case law, but like in this situation, for him to go and find case law and bring it in as part of his opinion, I've never seen that before. And I don't, Usually you see the opposite, where the judges are like I've seen it where someone will be like, oh, well, you forgot to consider this case. And they're like, well, you didn't provide me that case. Sorry, too late. I only can use what you give me. That's what you usually hear, whether it's, not just for a motion for directed verdict, but for anything, if they're arguing.
December 9th, 2010 opinion of the Florida Supreme Court. The court in that opinion goes on to say that when faced with a motion for judgment of acquittal in a circumstantial evidence case, the trial court must determine whether there is a prima facie inconsistency between the evidence viewed in the light most favorable to the state and the defense theories, citing Reynolds versus State, 934,
The state has theories
7
plural, and the
second,
defense has
1128, a 2006 decision of the Florida Supreme Court. The court in that opinion goes on to say, under the circumstantial evidence standard, where there is inconsistency between the defendant's theory of innocence and the evidence, when viewed in the light most favorable to the state, the question is one for the finder.
In this case, if you view anything in the light most favorable to the state, what you wind up with is George. That's what you wind up with. And I just...
fact to resolve, and the motion for judgment of acquittal must be denied, citing Floyd versus State, 850, 7 second, 383, a 2002 decision of the Florida Supreme Court.
Yeah, that can
The court goes on to say, we have held the state is not required to rebut conclusively every possible variation of events which could be inferred from the evidence, but only to introduce competent evidence which is inconsistent with the defendant's theory of events.
There's nothing competent about
If the state has presented evidence
nothing
to support every element of the crime, then a motion for judgment of acquittal must be denied and the denial affirmed on appeal. Once that threshold burden is met, it becomes the jury's duty to determine whether the evidence is sufficient
thank you, jury. Just thank you, jury. Thank you. Thank you. This judge clearly needs help with using brain cells, but the jury thankfully made up for that.
Include every reasonable hypothesis of innocence beyond a reasonable doubt. Whether a premeditated design to kill was formed prior to a killing is a question of fact for the jury to be established by circumstantial evidence. Pierce versus State, 880, 7 second, 563, a 2004 decision of the Florida Supreme Court. Evidence from which premeditation may be inferred includes such matters as the nature of the weapon used, the manner in which the homicide was committed, citing Griggs versus State, 753, 7 second, 1117, a 1999 decision of the 4th District Court of Appeals. Where the elements of premeditation is sought to be established by circumstantial evidence, the evidence must be inconsistent with every other reasonable inferences. Those are the principles of law which this court must abide by.
So he's like, my hands are tied. I have to follow these. I feel like that's ignoring a lot of the other things that were brought up, but that's one of the downsides of this whole way that it's set up, right? One judge makes a decision at one point, then everyone else has to follow. I really don't like that. And that's what they do. Rarely will you see any judge deviating, because we always hear, right? They don't want to rock the boat. They don't want to do all, and so they just follow. And then that's what you have to do, right? If it's mandatory binding authority. But just imagine, does anyone ever think about what if that first judge got it wrong? Does anyone ever consider that? What if that first judge got it wrong and then everyone's been following that same case law for decades? What about that?
The Florida Supreme Court in the case of Rose versus State, which is cited at 425 7 second 521, a 1982 decision of the Florida Supreme Court, dealing with a case involving circumstantial evidence. The succinct facts of this case was that the defendant was the last person seen with the victim. In that particular case, the defendant did have some motive.
Because I was like, wait a second, how do we know? And I'm like, wait, how do we even know? Like, even from what Casey said, she dropped Caylee off at Denise. We know that's not true. And I'm like, wait, who saw her with the victim? And then I remembered. He's saying that as if it's like factually been proven. Nope. George. Because Cindy was at work. George is the one who said he saw them together. I mean, I just don't know. Are we really in a place where we want to say that what George Anthony says, his memory, what he says happened, really, are we going to just go ahead and accept that as like factual? As if it was like an accepted fact? Like no one's like what? I don't accept that. Sorry.
What basically happened that...
If it was just the two of them at home, right? Now, she didn't take the stand, but it could have been her word against his because anyway, it's just, that's like, it's like something that you say if you were the last person, right? Like we see this all the time. If he was the last person to see her alive, he could easily lie and say it was Casey. Ugh.
Case was, there was an 8-year-old victim by the name of Lisa Berry. The evidence revealed that the defendant was the last person to be seen with young Lisa Berry at a bowling alley. The evidence showed that he left with...
Yeah, to that end, I just have a question. So at a bowling alley, so you've probably got a lot of eyewitnesses, right? So you say that you're saying it as if, so it's like the last person to be seen with. That sounds like that was either they saw them on camera, like a security camera, or eyewitness testimony at a bowling alley. So what do you have there? You've probably got a lot of witnesses that don't know them and are unbiased and like they're all going to say, right? So to compare that or use that as if that should be helpful here, right? Or on point in terms of like I would say we need to back up a second. What counts is validating whether somebody saw somebody. Like we need to take a step back here and say, okay, is that even, how do we even define that standard? Because really that should be fleshed out, right? Like at what point is it really accepted as fact? If you're basing a bunch of other things after that, like or upon that, then that first thing needs to be verified. And then it needs to be understood how you verify that. And like, there needs to be a standard for that. Because I would say, if you've got people in a bowling alley or you've got someone on security and you can see them leaving, there's a world of difference between that and George Anthony, who has every reason to lie, and all the other circumstances. There's a complete, even if he didn't, it's just one person, right? It's just one person. How is that good enough? Y'all.
That particular young victim, and that he had dated the mother for about 9 months. They were no longer dating because of he was an extremely jealous person. Subsequent to this, he was found with a large spot of blood on his pants, the same blood type as the victim. There was
Why are you highlighting how there's oh wow, listen to that, like normal evidence that you hear and things of wow, actual physical evidence. You know, maybe it's circumstantial, but at least it's something. It's like all it does is it reminds anybody that how like wow, we don't have anything here. Like it's crazy, right? Like how in any case you're going to have more than this case. Just really pick one at random, you'll have more evidence.
And the defendant made numerous statements that were inconsistent. The court concluded that evidence was sufficient to sustain the crime charged in that particular case, first-degree murder and kidnapping. The next case the court reviewed and had reviewed prior to the state citing this case was KRAYNICK versus State, 894 7 2nd 59. In this particular case, There are some interesting, in this particular case, the evidence showed that the defendant, who was 52 years of age, met the victim's mother, that he was the last person seen with this particular victim. It is interesting to note that the last time that the child was seen, she was seen sleeping next to the defendant in this particular case, and then the person abruptly disappeared.
You're probably talking about a young girl and
the Supreme Court, in finding that this evidence was sufficient, cited a case out of the Supreme Court of Virginia, Epperly.
Oh, right. Yeah, I know that.
That case is found at 294 Southeast 2nd 882, a 1982 decision of the Supreme Court of Virginia.
So we're just going to use persuasive.
In that particular case, the victim in this particular case disappeared on a night in June of 1980. She was last seen leaving the Marriott Hotel in Blacksburg. She left with the defendant in this particular case, went to a lake house, and ultimately disappeared, her body never being found. And the court goes through a long dissertation in that particular case and talks about premeditation and what premeditation meant. There is another case of interest
Why are you
for persuasive value,
They've already done this.
which is found at 323 Northeast 2nd 888, a Supreme Judicial Court of Massachusetts
I would not be relying on that. No, sir.
decision in 1974, which is still good law in the state of Massachusetts
Yeah, nope, never mind.
for
Nope.
persuasive value,
Yeah,
even
I
though
would
it
say
is
don't
not
do-
binding
the fact
on
that dude, you're in trouble if you're following any case law out of Massachusetts. Just
this
saying.
particular court. The evidence presented in this
Oh, wow.
particular case was that on February 16th, 1973, sometime after 4 p.m. on the first floor of this particular building, a tenant
Yeah, if he
heard
did,
moaning sounds coming from the direction of a cellar.
then he very well could have been
particular-
one of the people prosecuting Shannon Gardner because it's the same state attorney, Florida.
Witness, along with her husband, took a flashlight and went to a cellar where they observed a boy lying naked face down on the floor. They immediately got law enforcement assistance. The police arrived and they took the boy to the hospital for treatment. He remained at the hospital for a few days, was later discharged, came back home. His condition began to deteriorate.
It doesn't matter. State attorney is a state attorney. So, so if Judge Belvin had become a state attorney in Florida, if he ran and he was elected, then the state attorney's office prosecutes statewide. So, like those prosecutors, even though they're in Duval County, the office is the state attorney. That's why it's ASA. Like those are the state attorneys. Those are not otherwise it would be the Duval County. It would be the district attorney, right? District attorney would be like the Duval County. It's the state attorneys are for the entire state. So yeah, it would have been, yeah. Does that make sense?
and he was taken back to the hospital where he remained until his death. The evidence in this particular case was that the victim was last seen in the company of the defendant prior to the disappearance of the victim. The defendant and the victim were seen together shortly before the victim's disappearance.
Well, actually, having said that,
at the front.
I'll put one little caveat on that. In Florida, they do have the different circuits, so they're in the fourth circuit. So I don't. The question would be if it's which circuit. So because Florida is so large, I'm just remembering the difference between Florida and North Carolina. Because Florida has just one, or sorry, North Carolina has just one. But because Florida, I don't know how many circuits they have. I mean, it might be 5, or maybe it's just 4. But basically, that would be the only. But again, so you still have a large. In other words, whatever the Fourth Circuit might still cover Duval and Orange. I don't know. But usually the state attorneys in any state are the whole state. But yeah, I forgot about Florida being divided into the circuits. But that's kind of like what I was saying too, where if they have that, they're making that motion to disqualify the state attorney's office of that specific circuit, then if that happens, would happen, then they would have a different office. It would be like, say, the Third Circuit or whatever. You know what I mean? Yeah, so that must be because they're in different circuits. Yeah, I'm sure there's a map. Let me see online. There's probably a map. I'm sure that's why. Polk County, I don't remember where that is. Is that Miami? Let me see. Oh, they have a lot of circuits. Let me see. Hold on. Let's just see if I can go to this. The Office of the Attorney General is in, where did I say, Tallahassee? Oh, here we go. Here we go. Here we go. There's 19? What? Huh? Holy. Okay, here we go. Here we go. First Circuit is Escambia, Oskaloosa, Santa Rosa, and Walton. Second Circuit is Franklin, Gadsden, Jefferson, Leon, Liberty, and I'm not going to read all these. Fourth Circuit is Clay, Duval, and Nassau. Okay. Let me look for some of the noteworthy ones. So Ninth Circuit is Orange and Osceola. And then let me see if I can find Polk. Where? Oh, there's Brevard. Oh, Broward is the Broward is the 17th Circuit. It's the only county in that circuit. It's all by itself. Dade is also all by itself, 11th Circuit. Okay, so the Polk is in the 10th Circuit. Hardy, Highlands, and Polk are in the 10th Circuit. Oh, ha! What's it doing? What is it doing? Hold on. Oh, I think I need to re-add it. Okay, so anyway, let me just do this. Hold on. Sorry, I'm just looking this up on my phone. So, okay. Yeah, 19. Oh, why did I say 19? There's 20. There's 20 circuits. There was a little one hiding at the bottom there. That's crazy. So Wow. So let me just pull this up where we were here. Yeah, so hopefully that makes sense. 20 circuits, though, that's insane.
The detective who happened to be in that particular area making surveillance of the area observed the defendant and the victim on the front porch of the residence in question, walking into the doorway at approximately 3:45 p.m. The
Focus 10th circuit is what I have on here. Interesting.
victim was discovered shortly after 4 p.m. on that particular date. Again, this court was faced with a question of whether or not this was sufficient evidence. The court concluded that this was sufficient evidence since the defendant was with the victim immediately prior to the victim having been found strangled and naked. They had been seen together entering the building in which the victim was found.
You're fine. I was like thinking like, oh my God, like did I was actually like, oh, I need to do more research. Like, did something change? I'm like, am I on the wrong thing? Did they update it? Okay, you're fine. You know, this is just, that's, you know, I'm nothing if not thorough, right? And I don't ever want to give wrong information. I prefer to know the truth regardless of what it is. So yeah, I'm like, you know, if I got that wrong, I want to make sure I clarify. So I just pulled up another website to look. So they have them, they have a whole system. It's SAO and then the number. So that's good to know. Whenever you see SAO and then you see a number, that's Florida and the state attorney's office. So
It could be inferred from the layout of the cellar in the general
it's almost over.
General,
you made it. Made it all the way through.
Generally, the problem of anyone being able to gain entrance thereof, that was basically the only way that they could enter or leave that particular building. And the court goes on to lay out other particular reasons. The last case the court reviewed was a case out of the Supreme Court of the state of Arkansas. Zone versus State, found at 702 Southwest 2nd 1, 1985 decision of the Supreme Court of Arkansas. Again, in this particular case, the appellate and his co-defendant were the last two individuals that were seen alive with this individual. The appellate tried to make the argument that his co-defendant was the one who did it, made certain statements. The court concluded that this was sufficient evidence. The defense brings up the issue in talking about whether or not felony murder would be applicable, the Brooks case. And the court has reviewed Brooks, and the court has reviewed Amanda E. Lewis versus State, a 2010 decision of the First District Court of Appeals found at 34 Southern 3rd Edition 183 on the doctrine of merger. The First District points out a couple of things. One, the felony murder statute specifically provides that aggravated child abuse is a predicate offense for felony murder. The plain, unambiguous language of the statute demonstrates that the legislature intended that a defendant who kills a child during the perpetration of the crime of aggravated child abuse may be charged and convicted of both aggravated child abuse and felony murder, regardless of the number of acts of abuse which caused the child's death. And they go on to talk about Justice Lewis's dissent in Brooks, disagreeing with that particular analysis by the Supreme Court. As Mr. Mason, though, pointed out, that law is the law unless the Supreme Court decides to change it. The key argument is whether or not there is more than one single act that leads to the abuse or death.
I don't think Daryl Brooks would have fared
In
well.
this particular case,
He got lucky.
there is more than a single act. Those acts consist
Oh dear.
of duct taping, the nose,
I can't. He's going with what the state said. That was honestly one of the worst things they said of all of it. I cannot.
mouth, the presence of chloroform,
There isn't any presence. What is
in the
going
trunk.
on? What is going on? What
coupled
is happening?
with the fact
Stop.
that there is evidence
Gross. You need
that
to get out of here.
the child was placed in a trash bag and other container,
Yeah, but you know what about that trash
and
bag? Yours trash bag.
the
Just tell me.
statements
Oh my God.
introduced into evidence
My mind.
that even during this time period, Miss Anthony, through statements that she made, that the child was alive during various segments of this time.
Well, you know, George
So
said
it is
the same,
quite
so-
clear in this particular case that there is more than one single act which satisfies the test of Brooks
I have
versus
no idea
State.
what that word is.
Considering the evidence in the light most favorable to the state, and reviewing all of the evidence and considering the tests that have been laid down by the Florida Supreme Court, the defense's motion for judgment of
Here it is.
acquittal
Denied.
as to counts 1 through 7 are hereby denied. These are strictly questions for the jury to decide. The court specifically finds that the state has presented substantial, competent evidence for this jury, who is the trial of fact in this particular case, to decide this
What about the
particular
evidence
issue.
from the jury? What about that evidence?
This court will be in recess until 9 a.m. tomorrow morning.
Okay, yeah. Okay. It's a lot. It's a lot to take some of that stuff, but that's that. We did it. We did it. Yay. So Flashman said Judge Belvin came out later and said he thinks Casey did it by accident. Well, at least accident, so he's on the right track, but I still don't know why people, you guys have heard me say it in every way, shape, and form a million times. Okay. Did he say that he thought Casey was trying to frame George? Because where does all this George stuff come in? So I did make a note about, that was a great suggestion about looking at the changes to the Florida death penalty jury instructions. I did write that down. For anyone that forgot, because it was such a long time ago earlier in the stream, how crazy it was, I just remind everybody how crazy it was that Judge KRAYNICK presided over some of the charges regarding Casey back in the day. Insanity. But tomorrow what we'll do is we'll have that evidentiary hearing for Shanna with the witness testimony. So that'll be really exciting. That's kind of a long one. That'll probably be the whole thing. And there's one other document, but it's not long. So we'll do that and then we'll do the hearing. He didn't even mention George at all. How? Wow. That's crazy. So yeah, I had other things I was going to talk about or say, my brain, it just feels like, I don't even know. I lose it because it takes so much, what's the right way to say it? Like listening to the arguments made by the state and stuff, and trying to take all of because there's so many reasons why they're so incorrect, trying to distill all of that into a comprehensive sentence that makes sense so where I can say and be articulate. It's anyway, basically my brain is shot. I feel like I can barely make a regular sentence anymore at this point, which is really funny. Yeah, the return of Gardner Fernandez. I know, right? I know. Yeah. And there should be filing any second in Idaho. This is like the longest they've gone, I feel like, without filing. I'm like, what's going on? Because I'm used to like, fast and furious. But I mean, I check every day, as you all know, and I haven't seen anything yet. But I'm sure I'm sure it won't be that much longer. And I'm excited for that because I've been waiting for the next filing to cover some other stuff related to the trash, because that whole thing is crazy. That thing is crazy with the trash. So yeah. But anyway, Flashman, I will try to make it to come say hi to you while you're on your show or your friend's show. I'm sure you're going to do great though, and don't be nervous. You're going to have a lot of fun. It's going to be awesome. So yeah, but and maybe tomorrow we'll have some good news about finding the suspect in that CEO thing case. Like I said, my brain is brained out. You too. Yeah. Thanks everyone for being here. Anyone who's on replay crew, as always, I'll have timestamps. Love you guys. Y'all are the best. I love that you guys show up and listen to me ranting even, and that you tolerate listening to Drane-Burddick, because I know it's not easy. But I'll see you guys soon. Love you guys, and thanks for being a squirrel.